13th jurors. Y'all didn't see this, but I was over there while the theme song was on, or the intro song was on. I was over there trying to finish making my coffee real quick. And as I'm like rushing over here, I like tripped and almost fell and almost knocked everything over because I'm graceful like that. So we almost had a totally different start to our morning, but I made it safely-ish. And I didn't spill the coffee, which is the most important thing. So good morning. Hello. It's verdict watch, y'all. It's verdict watch. And most importantly, it's Choose Your Adventure Day, which we had so much fun with a couple days ago. So I am so excited about that. So good morning. Hello, Saw Schooler, Jasmine, Queen Olive Ruth Ann. Hello, hello. Oh, goodness gracious. Hello to all my friends. Good morning. Good morning. My eyebrows survived the night. If you look closely, I can't zoom in on this camera, and even if I could, y'all don't want to see all that. But there's like a couple like little like spots that have pulled out, but they survived. So we've still got day one verdict brows. Now, if we don't get a verdict today, then we're gonna have to reapply, which will be the first time doing that. But we're gonna try to make these last as long as we can. So we'll see how it goes. Good morning. Good morning. Hello. Hello. Well, why, thank you. Thank you. I put them on myself. Thank you. Good morning. Good morning. We had nasty storms and oh, well, that's not good. Good morning. Hey girl, hey. Hello, Bryce Productions. Good morning, Sheree. Good morning. Hello. Hello. I'm trying to scroll through and say all my good mornings, but I know I'm going to miss some of y'all. And it's not because I don't love you just as much. It's only because my old lady eyes can only pick up on certain words and scenes. And I miss a lot. And I'm sorry. But I still love you all just the same. Stephanie Willis, think we'll get a verdict today. I think that there's a possibility. Good morning. The poll we did yesterday on how long everybody thought the jury would be out, the majority of people said that they thought the verdicts would come back today. And our people are pretty smart people, so there's a good chance. Also, while I have you all here this morning, good morning, good morning, good morning, good morning. I will tell you that I broke my microphone. So not the actual microphone, but just like the boom thing. So you can see it over here because I had to like rearrange it because normally you can't see it. I have everything strategically placed. But it like this part came completely, you can't see. But anyway, a piece of it broke and now it's just kind of, we're making it work for today. So I'm going to have to pick me up another one this weekend. So if it sounds funky, that's why we're just going to push through. These are first world problems. Good morning. Good morning. Good morning. Hello, Ashley. Good morning, Law Nerd Amber. Is that Law Amber Nerd? I haven't had all my coffee yet this morning, obviously. So I am going to go ahead and jump right into saying why didn't it go? What happened to what happened? It's not on. Let's see. Nope. Nope. I was like, yeah, I've got it figured out this morning to where there won't be any issues with the tailgater thing. And there's issues with the tailgater thing. There it goes. Okay. Let's see. I can never make it through the tailgater. The congratulations to the first tailgaters. I can never make it through this video one time without some kind of hiccup. And I don't know how JT does it every single time with no issues. And every single time mine will either skip or it won't show up like this. But I'm going to go back to the graphics because I can't work it the same. It's our first 3 in chat. Congratulations to our first in tailgate. And, you know, it is tradition for me to somehow screw up the little thank you song. So if it ever went on without a hitch, then y'all would know that something ain't right. Hello to those of y'all still coming on in. Ghetto Intellect says, good morning, beautiful family. I am in the chat today. Heavy, my prediction is 5 p.m. Guilty. Everybody make your predictions. Make your predictions. We have some things coming up today. Oh, thank you. Oh, wait. Oh, I have to pull it up. Hold on. See, I am so unprepared this morning. Wait, we had this going. Okay, I think I got it now. Hold on. Oh, wait. No, wait. No, wait. What are all these things coming up on? Now not even that is working. Nothing on my computer is working. I tried to do the little thing. All right, hold on. Now let's try. Nope. Why? Eyebrow stash fun. Your brows are beautiful. Thank you. Thank you. I put them on myself on camera. Now my fun little sound effects aren't even working. Why is nothing on my computer working this morning? Nothing. Nothing's going right. Jimmy Law said, I was late. I had to watch Gossip, Rumor, and Innuendo. I have not got to watch it yet, but I am excited to. Thank you. Thank you. I'm still trying to figure out how to. Oh, wait. It's not working. Somebody sabotaged my sound effects. So rude. Let's see. Can y'all hear them, or am I just crazy? Let's see what all is going on wrong. Let's figure out all the computer problems I have today. Broken microphone, screen's not working. What else we got? I predict however long it takes for them to fill out all the paperwork, maybe by lunchtime. Could be. I think everybody put in their not what I wanted to do. Put in their predictions. It may have been Lucy, y'all. Y'all are like, she may look cute. That girl's trouble. I don't hear any of my stuff. Thank you for the super chat. I appreciate it. Will I be covering the show business trial? Yes. As if if it happens, yes. If it happens. I have plans to do it, and it's going to be quite the trial. So we'll see how it goes. There is actually a wrong one. That's the Young Thug RICO case. There's actually a hearing today. And the hearing today is so where they had the one person who said that she is not fit to stand trial. They have a state expert doing it today, or coming today to give their opinion on it, and then the judge will make a ruling. So that's supposed to be at 8:30 Wisconsin time. So let's see. Podcast Bride Fun. Thank you, Weather Watch. Thank you. I appreciate it. I would give you my little sound effect thing, but for whatever reason, it's not working today. None of my stuff on my computer is working today. This is just the Friday we've been dealt. But thank you. You don't have to bribe me. However, I do appreciate your super chat. For those of you who don't know or haven't seen, they just said on court TV that her trial and Sarah Boone's trial is probably going to be on the same date. Well, they were scheduled on the same date. They're supposed to both start on Monday, and then Sarah Boone got pushed back again. But we won't know until today when the judge rules about what's going to happen. For those of you who have not seen our dear friend Weather Watch, and I know some of you know him, some of you might also recognize him as one of our trial daddies, along with Matthew Harrislaw. So if you don't or are not familiar, he does a podcast. He's more than just a trial daddy. He does a podcast on Friday evenings, and I think we're going to try to work it out to where I'm going to join along and hang out. So when we figure out what date, then we will let everybody know. Let's see. Good morning, Katie Bell. Yes, Florida is hot this morning, y'all. I went out this morning at 5. I woke up at 5. I think me and Lucy were out on the beach by 5:30 maybe. And it was already hot and muggy. But I got some of the cutest little pictures of her running in the waves. Her sandy little fluff. She goes to the groomer tomorrow. So right now she's super just, she's half Yorkie and half miniature poodle. So she's got like that really thick fleur, like that just fluff. She's like a fluff ball when she starts growing out. A lot of the Yorkies will have like that silky hair, but the poodle comes out of her and she just turns into like this little dust mop, and she's so cute, but she looks about twice as big as normal when she's all grown out. So she goes to the groomer tomorrow. So cute. So cute. Let's see. Jimmy Lawson, it is way too hot here. It is way too hot here. Somebody asked if I wanted to go to Schooners tonight, and I was like, "Are you kidding? I ain't going nowhere without AC today." Question: why is Florida so violent and crazy? Is it the laws? Why is every huge case in Florida? Well, let me tell you. We get hot and cranky, but also it's not just Florida. I mean, Wisconsin gives us a run for our money. Idaho has produced some doozies. Ohio is getting up there with, crazy town. So we are, as of right now, the only one who has, like we have Florida man, but that's okay. Let's see. If they decide to give him manslaughter, could he get out on time served since he has already been in jail for 5 years? What is the general sentence for that? That's a good question, Virginia Little. I don't really know, because the only sentences I've heard of are for this specific trial are, of course, life without parole or death sentence, and that's for conviction of first degree. But the thing is, it's going to be hard to do a manslaughter because it's either you believe that he was in the car and he did it, or you believe the other story that he didn't. So that's manslaughter is going to be, if they convict him on manslaughter, it's because they believe he did it, but they feel bad for him. It's just, you can't, it doesn't fit. This is the way that this happened. It's either he's guilty of murder in the first because he was in there in the car and he did that and then has been hiding it, or he wasn't there. So I will be shocked if they convince him, or if they convict him on that, just because it's not even a thing. We'll see. Did y'all see Portland's Instagram? I did not. I have not looked at Instagram. I worked last night sat here till about maybe 9:30, and then went to bed and was up at 5. So I have not looked at it, but I am nosy, so we can look at it now. Let's see. And let's see here. What are we looking at? Before I pull this up, are we looking at his pictures or his little thing with the video thingy where you press the thing and it's like the video thingy? Because if we're doing that, I'm scared to do it on air without knowing when it is first. Let's see. The story. That's the name of it. Is it something that we can show here? I don't want to pull it up if it's going to be something like gets me kicked off again. funny how they throw him under the bus and he's still like, look, I tried for 2 hours last night to get a verdict watch clock, and I cannot get one on StreamYard. I cannot figure out how, so I will have to figure something else out. I tried so hard, which might be why my Stream Deck is not even working today, because I may have done something to it when I was trying to do that. But I tried, and I can't get it. But they don't have one up right now either. I don't know if they haven't started yet. But it was a little over an hour and a half yesterday, I think, that they deliberated. Borland is not in custody. He is on house arrest. Let's see. RA had a similar issue and he downloaded one that works great. Sorry, I don't know the name of it. I'll have to ask him when he comes back. I cannot. I tried to Google it. I tried to fix, do one out. I couldn't get one on StreamYard, because I use StreamYard because it's the easiest. But then when it comes to adding stuff, I didn't know how to do it. So we'll have one going in the corner. So when they get theirs up, we'll keep it to where we can see it, and we'll keep it updated, because I've got to keep this on all day long anyway, so that we can watch, to make sure that we don't miss anything. If the stuff with show business happens today, well, I know that they have the hearing, and I pulled the court roster last night, and I know that they have the hearing, the evidentiary hearing, and it said jury selection is supposed to start today. So if the judge, depending on what the state expert says, if the state expert goes against the other evaluation and says, nope, she's good to go, then he may rule in favor of just going ahead, going forward with it. This is not her first, evaluation that they've done with her. So we'll see how that goes. But if he does rule to move forward with the trial, then they're supposed to start jury selection today. So that will be interesting. I have not seen that yet. I watched his video on I watch all of his videos. I like his legal insight into things. Lady Grace says, Laura, was really impressed with the state rebuttal. Look, see, I'm trying to remember to read the questions for those who can't watch that are listening. I did not get to see that yet. The last video I saw was his, the one he did from, or the one he did about the last witness or the only witness for defense. And that's the last one I saw. So I haven't seen that one yet, but I'll be interested to see it. I like hearing his perspective. Timer Plus for iOS. I have Timer S for iOS is what I recommended to RA, and he now uses. Thomas, can I do that one on? I have Windows, but I use Chrome, and I have StreamYard. I don't know if that works with that, but I'll have to try to find out. I tried really hard, and actually, I think that I may have messed up something with my connection, because I was trying to do it. because now they're not working. All right, let's see. See, this says that this one is just playing over and over, but obviously it's not. Let's see if we can fix it. Good morning. Good morning to those of y'all still coming in. Wait, what? William Shatner passed? Wait. Where is this trial located? It is located in Wisconsin. So the hearings, I checked court papers for the hearings, I think said 8:30 their time. So 7:30 my time. 6:30 Eastern. Choose your own adventure. Computer repair. Yes. Yes. Let's see. And we are going to watch that one if the hearing for it, if we're not doing Melly stuff. That trial is wild. Good morning. Good morning. Everybody coming on in for Verdict Watch. No. See, you people. Tony Bennett passed away. I saw that right before we started that Tony Bennett passed away. Oh man, I wish I could do a beach day. The only thing about streaming on the beach is that I can't share screens. See, my setup here, I have multiple screens, so I can share my whole screen over here and stuff. If I do it on the beach, you can only see me, really. I'm not the interesting one. I'm not saying anything about Shatner. No, he faked us out. He's in trouble. How come the commands aren't working? I have no idea. There have been all kinds of issues with YouTube stuff the last couple of days. It's been super glitchy. So I'm not sure. Put the poll up. I want to see if people think he's guilty or innocent. Do you want to see guilty or innocent? Or do you want to see guilty, not guilty? Because it's two different things. Two very different things. Let me know which one and I'll put a poll up. Guilty, not guilty. Okay. All right. Yeah, I'm just closing my sound stuff. I don't know why it's not working, so we're just gonna give up on that. Give up on that. Ooh. All right. Start poll. Do you want me to do if you believe he's guilty or not guilty, or do you want me to do what you think the jury will come back with? We'll do what you think, guilty or not guilty. What would your vote be? A juror. Okay. Here we go. So we got it up and going. Let's put what you think. What do you think? This is the show business. The show business hearing. They subpoenaed 100K track management, and they said in the court papers that they were refusing whatever, but he was on the list of potential people who could be called, so that he said that's why he wasn't able to go. But once the state and the defense both rested, he was no longer potentially going to be a witness, so he was then able to go to the courtroom. So he went and he spent the first half of the day in the gallery on the victim's side, and he spent the second half of the day in the gallery on Melly's side. So you got to go to Bort's post before it gets deleted. The one that we just looked at, the one on his story on Instagram, or a different one? Is there another one I'm missing? Wow, 91% are at guilty right now. I'm going to keep Melly down here in the corner. What do you guys think the possible motive was, given all the evidence the state and the defense have presented to this case? What do y'all think the potential motive was? Money is the number one that I hear from people. Oh my gosh, here, I'm trying to. There's one. I'm having trouble making this to where it's like we can watch both or watch for both. We'll just do what we can. Let's see. Does he even have to prove motive? No. They do not have to prove motive, but it does, help the jury understand things. But Motives are generally about, either money, relationships, or power. Thank you for the super sticker, Ashley. Thank you, thank you, thank you. I don't know what's going on with my sound effects. It's working. I don't know. Anyone who says Brandi is biased goes instantly in timeout. Y'all, I literally screenshot the definition of what bias means and had to start giving it to people on Twitter. Bias does not mean that you disagree. Bias means you are like only for one side you're prejudiced against, like to the point of being prejudiced against anything else. I'm so sick of people using that word to call other people who disagree with them biased just because they disagree. I think our chat does such a great job of disagreeing and still like respecting each other so much. I wish that other people in the world in general were able to learn from our chat. I hear, like, I'm trying to listen. Is the verdict in? I don't think so. I think they're just starting to. We're waiting. This one down here is Melly. This one up here is Shabusiness. Let's see. Portland is just a side person trying to fit in, and he basically did what Melly told him to do, and he did just that. That's what it seems. The whole thing kind of makes me like, I mean, not sad for him because obviously he's, so involved in this, but
the side doesn't pick it up. So I moved it this way. See, it's this. This is what picks it up. So we're not this. Oh, this. At least. Yeah.
Do you think you will win appeal if found guilty?
Wait. We're just gonna eat.
No, not really. All right, here we go.
Nobody can hear then. Yeah.
Here she is.
Does that little speaker feel?
Whoa. You should just. I want to move Melly for a minute.
Morning, guys. Hello. Morning. Good, you? So I talked to Dr. Layton for several hours. 3 last night. I joined FAM treatment, right? 3 last night. What's today? 21.
It's on.
I want to get these releases. So can you sign that? Eric, I'm going to ask you everything. Can I give her this pen to sign the release? Sure. I need to get some more records. Yeah, absolutely. Yeah, go ahead. I got permission. There you go, right there. Sorry. Yeah, I just like to ask. Appreciate it. Absolutely.
I'm trying to listen to what they're saying. He had to ask if he could give her a pen to sign that. Do they make a decision with show business? That's what this is for. Yes, this is live. This is the hearing for, they're going to do, it's an evidentiary hearing and then potential jury selection. So basically the state expert will offer their opinion on if she is her mental capacity to stand trial and if smile. And the judge will hear it and then make a decision if they're going to go forward with trial. If they do go forward with trial, they also have jury selection scheduled today.
Look at stuff and find her.
If this one goes forward Monday, this is the one that we're doing next. But we're about to find out. Can you give us a brief recap of this show business case, please? It's pretty bad. It's pretty bad. So this happened, I think 2022, Wisconsin, and it was her boyfriend. So she was apparently on meth and she unalived him. Wait, how long have we been on? Yeah, we're only on 45 minutes in. I have to be careful the first 2 hours of how I say things and how many things are said and all that. So she unalived him and then she dismembered him. One of the parts she dismembered was his member, and she used that. So there's also a sexual assault charge. she said that she used knives that she got from the kitchen, and she said a bread knife worked the best because it was like because of the type of blade. He's explaining to her right now what it paused. That's their feed, not ours. I think he's just explaining things to her, nothing too spicy. So she, the detective that arrived asked her, about what happened and stuff. And she said that the knives would be in a black bag along with body parts in the basement. And she said that the bags that were used were just ones that I think she said she found in the basement. She said that she started getting paranoid because of the meth or whatever.
All rise. Corporation is now in session. The Honorable Jewel providing your silence is requested.
You see,
That she, I guess, lived in with a chain.
okay.
Like the
Call UCF 363, State of Wisconsin versus Taylor Shabusiness. State appears by Deputy District Attorney Saunders and District Attorney Lizay. Also appearing is the defendant, Ms. Shabusiness, Mr. Frederick. Here today, or this morning, continuation of the competency hearing. And the court has now received a copy of the report from the Wisconsin Forensic Unit, Dr. Seipel. He's here on the Zoom. Did both parties receive a copy, Mr. Saunders?
Yes.
Mr. Freilich?
Yes, I did, and I reviewed it with my client.
Very good. So I think that's where we will pick up, because we had the first half of this hearing last week. That was Dr. Lighton testifying. I know that she's on the Zoom as well. So Mr. Freilich may or may not choose to call her in rebuttal.
Thank you.
Afterwards. But I think I'd turn the case over to you. Do you want to initially direct Dr. Seipel, Mr. Saunders?
I'll take care of questioning this morning, Your Honor.
Mr. Lizay, then are you going to call Dr. Seipel then?
Yes, I am, Your Honor.
Okay, doctor, if you could please raise your right hand, I'm going to place you under oath. Do you swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. Mr. Lizay, the witness is yours.
Thank you. Dr. Seipel, can you state for the record how you are currently employed?
I am employed as a licensed psychologist with Behavioral Consultants Incorporated at the Wisconsin Forensic Unit, where I perform forensic mental health evaluations, including competency to proceed, on a full-time basis.
And how long have you worked at the Wisconsin Forensic Unit?
So I began with the Forensic Unit as a postdoctoral forensic psychology fellow in September of 2020, and I've continued with the practice since obtaining my psychology license in February of 2022.
Can you estimate approximately how many court-ordered competency evaluations you have performed over the course of your career?
It is approximately 800 to date.
And have you been accepted in Wisconsin courts as an expert or as a witness on the issue of competency to proceed in criminal cases?
Yes, I have.
And in fact, you previously testified in this case, State of Wisconsin versus Taylor Business. Is that correct?
Yes, on 2 occasions I provided testimony in this matter.
And on those occasions, did you provide testimony regarding your background and your licensing?
Yes.
And the background information generally that you provided in that testimony, does that remain accurate here today?
Yes, there have been no changes to my licensure status or any of my employment or professional affiliations.
Thank you. And Dr. Seipel, you were then subsequently asked by the court in this case to provide an additional competency evaluation. Is that correct?
Yes.
Can you just briefly address the additional materials that you reviewed in order to prepare the present report?
Yes, so in order to prepare the present report regarding the defendant's competency to proceed, I performed a direct in-person examination of the defendant, and that occurred on July 12th within the Brown County Jail. I again reviewed the criminal complaint for this case and discussed portions thereof with the defendant in the evaluation. I reviewed all of the competency and criminal responsibility evaluations completed to date in this case. I reviewed updated records from the jail medical service. I reviewed a discharge summary from the defendant's previous treatment at the Brown County Nicolay Psychiatric Center. And I also spoke with defense counsel regarding recent observations and concerns, as well as reviewed the motions that were provided to me by defense counsel requesting new competency evaluations.
After all of that additional document review, the discussions that you had and the in-person meeting that you had with Ms. Business, did you ultimately form a conclusion regarding her competency to proceed in this criminal case?
Yes, I did.
And did you prepare a report that discussed those conclusions and the bases for those conclusions?
Yes, I did.
And is that report a letter to the court dated July 17th of 2023 that you provided to the court?
Yes.
Again, that report is 20 pages in length. Is that correct?
Yes.
Your Honor, I believe that all of the parties are looking at document 223. I would just ask for the record that this be marked as an exhibit, or I don't know if it necessarily needs to be marked as an exhibit, but that the court accept document 223 as the report prepared by Dr. Seipel in this case.
Any objection, Mr. President?
Your Honor, I have document 223, which is the report from Dr. Seipel dated July 17th of 2023, and it was filed on that same date.
Do you have any objection to my receipt?
I have no objection.
That'll be received into evidence. Go ahead, Mr. Lizay.
Dr. Seipel, I believe that you indicated that you had reviewed all of the other competency reports that were prepared in this case. Does that include a report that was recently authored by Dr. Litton, which called into question the defendant's competency in this case?
Yes.
And did you have an opportunity to thoroughly review that report?
Yes, I did.
And does your report outline some concerns that you have with Dr. Litton's report?
Yes, it does.
Ultimately, do you come to the same conclusion as Dr. Litton?
No, I reached the opposite conclusion with respect to the issue of competency.
And what is your conclusion with respect to Ms. Business's competency in this matter?
So the opinion that I offer to a reasonable degree of professional certainty is that the defendant is presently competent to proceed.
And your report lists a number of reasons for that opinion, does it not?
It does.
And I would like to just sort of walk through some of those reasonings if we could. First of all, you address, I think, the issue of her background materials and I think the threshold question of whether or not she has a mental illness. I'd like to start with that supposition. What is your opinion with respect to whether or not Ms. Business currently suffers from a diagnosable mental illness?
I would object on foundation. I don't know if there are enough questions asked to render an opinion at this point. So I object on foundation.
I think he has given a sufficient foundation. He listed all of the things that he did, including reviewing all of his records, conducting
I could barely hear
his
you
own
with these
personal
headphones.
interview
He
with
said
her and evaluating all of the
he believes
available
she
materials
is
in this
competent
case.
I'll rule the objection. Go ahead.
And so after reviewing the
Go through trial.
data sources, I noted that sometimes in the defendant's history, she perhaps has experienced clinically significant depression, has contemplated suicide, has had various behavioral issues. Although I found no evidence to sustain an independent diagnosis of a severe mental illness, such as bipolar disorder, schizophrenia, or a like condition.
And with respect to the defendant's own reporting of having such a mental condition, what did you note?
I noted that there's been a remarkable inconsistency in the extent to which she has endorsed having a mental illness such as bipolar disorder, and instead on many occasions has ascribed any related or similar symptoms squarely to her abuse of intoxicants, most notably methamphetamine.
And did you also review information about her recent behaviors, whether that occurred in the jail or in court proceedings and things of that nature?
Yes, I did.
And what were your observations with respect to those recent behaviors and how they might impact a diagnosis of bipolar?
Yes, I noted that there certainly have been behavioral issues within the jail and in the courtroom, and I am certainly well aware of the assaultive behavior towards the previous defense attorney within the courtroom. I'm aware of the defendant throwing a chair at Dr. Litton. And while certain such behaviors certainly are disruptive and concerning, I found no evidence to suggest that there was a consistent pattern of such behaviors that could be directly attributed to symptoms of a mental illness. Rather, I am fundamentally unable to rule out that they're primarily volitional in nature.
In particular, let's deal with the issue of her throwing a chair at Dr. Linton. What concerned you about that particular incident in terms of your ability to assess whether that was related to mental health or volitional conduct?
So certainly if that were a pattern of behavior that was consistently occurring and seemed to be out of control, that could be an issue relative to competency and attending to and meaningfully participating in proceedings. Although again, that was an isolated event. And there's noteworthy that after immediately, at least according to Dr. Litton's report, immediately after the defendant did such behavior, she calmly sat back down, which is inconsistent with someone in a state of psychotic agitation, who typically would require significant external intervention or chemical or physical restraint in order to regain behavioral composure.
And did you note, so similarly, did you note behavioral concerns that occur at the jail?
Yes, there are very intermittent acting out behaviors that do result in citations within the jail.
And did the nature of those citations, is that in your view consistent with a psychosis or consistent with volitional behavior?
I would say I cannot rule out that they're most fundamentally volitionally motivated, and perhaps by motives such as boredom as well.
And what is the basis for forming that conclusion?
Again, there's a lack of consistency both in the timing and type of these behaviors that were occurring. Again, they were very isolated brief incidents, and again, other motives could reasonably be inferred, such as I'm aware that there was a day in which she stood nude when receiving her meal trays, and it could easily be confirmed that exhibitionism or sexual gratification was a motive at play, and there was otherwise no evidence that she was actively symptomatic of a mental illness on the date that she exhibited such behavior.
From your review of the jail records and from the other behavioral observations of Ms. Shabiznes, does it appear that she has any trouble controlling her behaviors when she has a need to get her own needs met?
Calls for objection. It calls for speculation, Your Honor, and it's kind of a compound question.
Overruled. Answer the question if you can, Doctor.
And so I would say that based upon the information provided within the jail records, as well as my knowledge and contacts with the defendant, it does appear that she is able to maintain behavioral control when it is in her desire or interest to do so. For example, she displayed a sustained period of behavioral stability, which she herself directly attributed to her desire to have reduced security precautions within the jail.
And Dr. Seipel, you obviously mentioned you reviewed the report of Dr. Litton with respect to the contact that she had with Ms. Shabiznes and her observations in the course of her interview. Could you describe how your interview with Ms. Shabiznes differed from Dr. Litton's observations?
Yes, and so Ms. Shabiznes, during true contacts, and especially focusing on the most recent contact earlier this month, she maintained behavioral control. There was no acting out or aggressive behaviors. There were some moments in which her commentary waxed somewhat provocative, although she was easily redirected from such commentaries such that we sustained rational, reciprocal verbal communication about her recent adjustment within the jail, her clinical concerns, and various aspects of the pending case, such that I did not note any substantial deficits in her mental capacity to understand the proceedings or meaningfully aid in her defense.
And I want to talk particularly about that last point. You did in detail address with her understanding of the legal proceedings. Is that right?
Yes.
And was she able to meaningfully describe the roles of the parties and the purpose of these proceedings and how they would go forward?
Yes.
Did she really express any concerns regarding any of those issues?
I would say there were some minor points of confusion, such as the maximum sentence for her lesser charges, or some of the nuances of the no contest plea, although she easily responded to brief education about those topics, such that in the end, there was no substantial deficits in her understanding of the proceedings in general, or the specific posture of this case and the plea that she has selected for her defense.
And on the second point, the ability to assist in her defense, one of the concerns I think that Dr. Litton raised was proclaimed amnesia or inability to recall events. Is that something that you significantly noted in your interview with Ms. Shabiznes?
What was interesting was that across prior evaluations, she has claimed amnesia for past events, most specifically the date of her alleged misconduct in this case, although she did not make such a claim during our most recent contact. Rather, she relayed what seemed to be an intact recollection of the date in question, was able to comment coherently about different aspects of her experience and her mental status during that time frame.
One of the other issues that it appeared Dr. Litton relied upon strongly is this idea of both audio and visual hallucinations. Did you make any notation of that in your interview with her?
Yes, I noted that while there were some intermittent moments in which the defendant did claim to experience those symptoms, especially during the moments of the interview, I noted that to the extent that there's any legitimacy to those symptoms, they did not impair her ability to focus and communicate rationally with me, and the broader information available to me suggests that it is unlikely that such symptoms are indeed legitimate.
And can you provide some detail on that, your concerns as to the legitimacy of those hallucinations and why you have those concerns?
Yes, my concerns are manifold, and I will detail them. There has been a remarkable inconsistency in the defendant's endorsement of symptoms across time, and the discrepancy between what she has said to forensic evaluators and what she has said to clinicians within the jail in a similar time frame. She's been vague and unable to elaborate in those moments when she has endorsed symptoms. And moreover, outside of perhaps her contact with Dr. Litton, no one has conceptualized her as being preoccupied with internal stimuli across those clinical and forensic contexts. Moreover, on past psychological testing, there's been a significantly elevated probability revealed that she is feigning symptoms of mental illness, or at the very least is not a credible informant regarding the symptoms of her mental illness. And moreover, the visual hallucinations she has recently endorsed, specifically this supposed green train that plays Johnny Cash music, according to the forensic psychology and psychiatry literature, such symptoms are remarkably suspicious and not consistent with legitimate visual hallucinations.
And doctor, within your field, is there psychological or psychiatric testing that could be done in order to try to assess whether or not a patient is feigning symptoms?
Yes, there is.
And did you note whether or not Dr. Litton performed any of those such tests?
I did not find any indication in her report that she administered any form of psychological testing.
Is it unusual in your experience that someone would merely accept those claims without doing any such testing?
I would say in the forensic setting, in general, yes, that it is unusual, but especially in a case of this stature and with this history that has called into question the legitimacy of her symptoms, to the extent that an opinion is predicated upon those symptoms, it would be against best practice for that opinion to not be supported by any form of psychometric data or analysis.
And in your review of the other evaluations that have been done of Ms. Shabiznes, did other evaluators perform such tests?
Yes, specifically Dr. Tracy Lucia and Dr. Christina Angan both administered psychological testing to the defendant.
And were there concerns raised in the course of that psychological testing regarding the potential for feigning symptoms?
Yes, on both of those occasions, concern was raised about the possibility of feigning psychiatric symptoms.
And that is consistent with your own observations of Ms. Shabusiness as well, correct?
Yes.
And then, Doctor, again, just to reiterate, what is your conclusion with respect to Ms. Shabusiness's competency to proceed in this matter?
My conclusion, to a reasonable degree of professional certainty, is that Mr. Business is competent to proceed.
Thank you. I have no further questions at this time.
Cross-examination, Mr. Freilich.
Thank you very much, Your Honor. Dr. Seipel, good morning.
Good morning.
So you did a competency evaluation on my client, Taylor Denise Shabusiness, correct?
Yes.
And you met with her at the Brown County Jail on July 12th of 2023, correct?
Yes.
How long was that interview?
It was approximately 90 minutes.
And where did the interview occur?
It was in a conference room within the area of the jail that was immediately adjacent to the reception area.
And it was just you and Miss Shabusiness in the interview room?
There was also a postdoctoral forensic trainee with my practice who accompanied me and was a silent observer for the evaluation.
Was that the postdoctoral fellow, Dr. Steven Steinert?
Yes.
Was that typical practice to have another person like a fellow sit in on the evaluation with you and the defendant?
Yes, for training purposes, that is standard practice to have postdoctoral fellows accompany and observe evaluations.
Did Dr. Steinert ask any questions or engage in any conversation during the interview on July 12th?
No, he was an entirely silent observer.
Was Ms. Shabusiness handcuffed at the time?
Yes, she was.
And then she was also handcuffed to the floor?
Her handcuffs were secured to a waist belt and her ankle shackles were secured to a metal ring up on the floor.
So she could not get up or do anything, correct?
She could not rise from her seat, at least not fully, due to those restraints.
After July 12th, after your interview was done, after it was completed, did you go back to see her again or not?
I did not.
And basically, is it your understanding that as it relates to the issue of competency, the law, because you've been in the field, that a person is not responsible for criminal conduct if at the time of the conduct, as a result of mental disease or defect, the person lacked substantial capacity either to appreciate the wrongfulness of their conduct or conform their conduct to the requirements of the law. Is that correct?
Judge, I'm going to object at this point. That's the standard for NGI, not competency. So yes, at the time of the conduct, competency is her present sense.
Yes, I'll ask a different question.
All right, questions withdrawn.
You did address that issue though as well, correct?
The issue of NGI?
Yes.
No, I was not ordered to address that issue in this case.
As to the issue of competency, what were the elements for that you were looking for?
Yes, so evaluating a defendant's competency in the state of Wisconsin is guided by statute 971.13, which provides the legal standard that no person shall be tried, convicted, or sentenced for a commission of a crime so long as they would lack substantial capacity to understand the proceedings or meaningfully assist in their defense.
When you talked to, thank you, when you talked to Ms. Shabusiness on July 12th, did she have any difficulty understanding what you were talking about?
No.
Would you agree that she was not the best historian as far as providing detailed answers to you?
I would say that in terms of providing her personal history, there was no substantial deficits in her memory functioning or ability to convey such information. I would say that there was a vagueness to her endorsement of clinical symptoms that was not in and of itself suggestive of inability to provide detailed responses.
How did you start the interview off? Did you kind of have some small talk and then go into it, or can you tell me a little bit about that?
Yes, so every competency interview begins with an advisement of the evaluation purpose and the attendant limits to confidentiality associated with the professional contact.
And then you started to kind of talk about some of the problems that she's had at the jail. Is that fair?
I'd say that not necessarily problems per se, but began with the discussion just overall of her functioning and adjustment within recent months, which naturally lends itself to discussion of various clinical issues, different events that have happened over the pendency of this case, and then proceeded into very direct and detailed discussion of various competency-related terms and topics.
You had a chance to review some Brown County jail records with regards to her stay there, correct? Her progress?
Yes,
You went through all the records, correct?
I reviewed records that were provided to me from the end of December of 2022 through July 6th of 2023.
You reviewed records that I sent to you, correct?
Yes, there were some additional incident reports from the jail that were sent to me after I had sent this report in for submission, and I did review those.
When you looked at the jail records, did you find that she had a lot of different issues in the jail on a daily basis with regards to not coming out of her room, not standing for jail count, other issues?
I would say the only issue that has been regular, but not necessarily daily, has been failing to stand for the required counts within the jail.
What about, was there an incident where she allegedly took a staple and jammed it into her arm where she needed to leave and get some medical care?
Yes, there was.
Can you tell me about that, what you reviewed as to that topic?
Yes, and so there were, and again, that was around the time that these records began in December of 2022. There was an incident in which she had inserted a staple into her skin, and then was sent out to the emergency department for treatment of that injury. And what is noteworthy was when discussing that during the clinical interview with Ms. Business, is she suggested that that behavior was largely motivated by a desire for, she called it, a change of scenery or to get some time away from the jail.
Do you know if when that happened, she was suicidal or in a psychotic state at that time?
And so she disclaimed to me experiencing suicidal intent at the time of that behavior. And immediately upon her return to the jail and discussing that incident with jail providers, she denied feeling suicidal and did not endorse or display any psychotic symptoms.
That incident where she put a staple in her arm, that was self-mutilating behavior, self-injurious behavior, correct?
I would say yes, it was a behavior for volition that resulted in an extent of minor injury.
During your contact with her, did you find her to be suffering from like a depressive disorder, from PTSD, from other issues?
I noted that she gives somewhat of mixed and conflicting information with regard to her recent emotional functioning, suggesting that on the one hand, she was experiencing some depression, although perhaps on the other hand, experiencing some modest mood elevation. Although during the moment of our contact, she did not present as significantly depressed, she did not present with significantly elevated mood. Essentially, there were no mood-related symptoms that impaired her ability to sustain focus and communicate coherently and rationally with me. With respect to the issue of post-traumatic stress, there does seem to be some symptoms of that kind in her clinical history, stemming from seemingly a history of abuse, although she's been inconsistent the extent to which she has endorsed abuse. Although there was nothing that she endorsed or displayed that warranted an independent diagnosis of a condition like post-traumatic stress disorder. Did
Ms. Shabusiness indicate to you that her father had sexually abused her when she was younger?
Yes, that she did endorse experiencing that kind of abuse, that she conveyed that to me during the current clinical interview.
You also commented on the fact that her mother died, I believe maybe in 2008. Did you take that into consideration as as you reviewed her mental status?
I would say that is an aspect of her clinical history that I am aware of, although I did not note any direct impingement upon that historical event upon her current mental status.
I studied the jail records. There was an entry on or about June 19th of 2023 where Ms. Shabusiness apparently wrote on the jail wall with blood, "Happy birthday" for an officer or somebody. Remember seeing that?
Yes, I did find indication that she had written some letters upon the wall and filled in at least one of those letters with her own blood.
Does that give you pause when you assess her whole overall mental status?
I would say if there were more active indications of acute psychiatric instability that event would give me more reason for concern, although given its isolated nature and the various performance strengths and psychiatric stability that she displayed during the clinical interview, no, it does not cause any substantial concern on my end.
Did you understand that Taylor Shabusiness was prescribed medications at the Brown County Jail, at least in 2023?
Yes, she has been treated with some psychotropic medications within the jail.
Like olanzapine, correct?
Yes.
And did you gather or garner information that she wasn't taking the meds, she refused to take the meds, that the meds got passed around, that she didn't actually ingest the medication so that she could get better?
There was indication, at least from her medication administration record, that she generally took that medication daily during the month of March of this year. I'm also aware that there was at least one incident in which a pill was discovered in the pocket of her uniform, which calls into question her medication compliance. Although since March, she has been remarkably inconsistent in accepting that medication, including taking it just a few times in recent months.
Is it fair to say, Dr. Seipel, with your training and experience, that if people don't take their psychotropic medications, then they can have a lot of mental health problems, and that can impact their understanding, memory, all of that, correct?
I say to the extent that someone has an underlying mental illness, then yes, medication non-compliance could cause some issues with their mental status and relevant functional capacities.
You also reviewed, is it true that you reviewed some jail records where she was walking around naked during dinner service, standing naked in front of her jail cell window, and having issues with that? Taking the clothes off, putting them back on?
Yes, there was one date in which it was noted that she stood nude at the window of her cell for passing of two of the meals during meal service.
Also, did you gather that she refused to stand for head count often when asked to do so?
Yes, and that would tend to happen in spurts, where there'd be several days in a row where she, and it was also noteworthy that it was often several other inmates on her pond, would all refuse to stand for count.
With regards to this case, you had a chance to review Dr. Diane Litton, PhD, her evaluation of Taylor Shabusiness, correct?
Yes.
Her conclusions and findings are in direct conflict with your findings and conclusions. Is that fair?
Yes, we reached the opposite opinion with respect to the issue of competency.
And that's where the contest lies, correct? On the issue of competency?
Yes, as my understanding, that is what I have been ordered to evaluate in this case, and as my understanding, that is the purpose of this morning's hearing.
You had a chance to review Dr. Deborah Collins' report, correct?
Yes, I did.
You had a chance to review your earlier report, correct?
Yes.
You had a chance to review Dr. Tracy Lucetta's report from April 29th of 2022, correct?
Yes.
In Dr. Lucetta's report, do you know her?
I do not personally know Dr. Lucetta, although I've certainly seen her work on several occasions.
Okay, thank you. But you read over the report and you're aware of her findings, correct?
Yes.
Would you agree with me that she recommended a transfer of Ms. Shabusiness to one of the state's psychiatric facilities like Mendota Mental Health Institute or Winnebago Mental Health Institute for further evaluation under close and extended observation by qualified professionals? Are you aware of that?
Yes, that is the recommendation that she offered at the conclusion of her report.
Do you agree with that? That maybe the court should consider having Ms. Shabusiness go for a longer observation period with a team to assess her competency rather than having a 90-minute interview or conference with the doctor?
Well, I would note, sir, that my examination finding for the product have substantially more data than just that 90-minute contact. It reflected extensive records that predated the charges being filed in this case, as well as extensive observations of the defendant over the entire pendency of this case. And as that provided sufficient information for me to reach an opinion to a reasonable degree of professional certainty, I do not believe that additional inpatient examination is warranted or necessary at this time.
Would you agree that this is a very complex case from a competency standpoint, from a mental health standpoint?
I guess I would not necessarily say that it is head and shoulders more complex than many other cases that I have handled in my career.
You've only had your license since February of 2022. Is that fair?
Yes,
And would you agree that Dr. Litton, who's a PhD like you, has substantially more experience than you do? Fair?
I would say she's been practicing longer, although the extent to which her practice is focused on competency examination is unclear to me.
But you're aware that she did work at Mendota Mental Health in the past, correct?
I'm aware that she was employed at least one of the state psychiatric institutes, yes.
Did you look at her curriculum vitae at all?
I guess I did briefly review it as it was attached to the PDF that also contained the report.
Would you agree that more data, more information could be obtained regarding Taylor Shabizis if she went to Mendota or Winnebago for a 10-day, 30-day observation period? A lot more information could be obtained, correct?
I would say that yes, in a very general sense, certainly more time being observed by different professionals would provide additional data and observations.
Did you review the Glen mental health records with regards to Taylor Shabizis?
Yes, I did review treatment records from Glen that she sent to me after my report was submitted pertaining to 2 episodes of care, one from 2012 and one from 2014.
I know that you indicated that you may consider preparing a supplemental report. You didn't do that with regards to the Bellin issue, Bellin records, correct?
Yes, for our correspondence, I advised that if upon reviewing those records, there was any information that altered the opinion offered in my report, that I would offer an addendum. And after reviewing those records, there was nothing that altered the opinion offered in my report, so there was no need to offer an addendum to that effect.
Okay, thank you. As to Ms. Shabizis, she apparently received mental health services at Bellin Health here in Green Bay from approximately July 15th of 2012 to October 31st of 2014. Is that fair?
I noted that there were 2 separate inpatient admissions, one that was for 3 days in July of 2012 and the other that was for 3 days in October of 2014.
How many days in July of what date? You said July of 2012 and July of 2014?
It was July of 2012 and October of 2014.
How long was she at Bellin in October of 2014?
It was from October 28th to October 31st of 2014.
Was that inpatient admission?
Yes.
So she had 2 inpatient admissions at Bellin, correct?
Yes, from the records that I received, it reflected 2 inpatient psychiatric admissions.
And would you agree that she was admitted to Bellin Health Psychiatric Center as an adolescent because she had mental health issues, mental health problems?
I would say that yes, in a broad sense, there were mental health issues and symptoms that seemed to prompt the presentation to those facilities.
Did you gain information that she was prescribed Lamictal, Wellbutrin XL, Abilify, Seroquel, medications of that sort?
Yes, those types of psychotropic medications, the records indicated were provided to her within the facility.
That she was diagnosed with depression and attention deficit hyperactivity disorder?
Yes, those were historical diagnoses noted in her record, and she was also assigned a diagnosis across both of the inpatient admissions of a mood disorder not otherwise specified.
Thank you very much. And was it your understanding that as a youth, she was expelled from school?
Yes, that is my understanding.
Can you explain the mood disorder? I'm looking at a report from Bellin Health that seems to indicate a diagnostic impression, access 1, mood disorder, not otherwise specified with prior history of psychosis. Could you expound on that a little bit for me?
Yes, so from the information I gleaned from these records, it indicated that the admission in 2012 was prompted at least in part by an adverse reaction to the antidepressant medication sertraline. Sertraline is a selective serotonin reuptake inhibitor medication that in adolescence is widely known in some cases to cause paradoxical or adverse reactions such as increased depression, increased suicidal ideation, and in some rare instances it can induce psychotic symptoms. So the record suggested that it was not until beginning that medication that the defendant began to display psychotic symptoms, and those symptoms promptly resolved when that medication was discontinued within the hospital. So that would not be consistent with an emerging schizophrenia, but rather it was a time-limited and purely medication-induced psychotic episode.
I'm pausing show business. We'll listen to the jury question, then we'll go back. I've been keeping my mic muted because you can barely hear him. It's not picking up on his stuff at all, and you can barely hear him. So I'm keeping my mic muted to keep any extra anything out of the feed so we can try to hear him. It's really hard to hear him though. Do you want to keep watching this one while they're not doing it? Or not back?
Did you read in some of the Bellin records that one of the major stressors in her life was the loss of her mother at such a young age?
Yes, that was clearly reflected in the records.
When she was 16, she was voluntarily admitted to the crisis center for some suicidal ideation and being a runaway and not taking medications. Is that correct?
Yes, and she was admitted to an inpatient psychiatric unit after presenting initially to the crisis center.
And in the records also, did you gather information that Ms. Shabazis had complaints of feeling things that were not real, almost like a dream for several weeks, for 2 weeks or so, sometime in October of 2014?
Yes, I did read in the records that she endured experiences of that type in the time period leading up to her hospitalization.
And will you agree that she had a real hard time with the loss of her mother and cries about it quite often?
Yes, that again was reflected in the records that she continued to struggle to adjust in the wake of her mother's death.
And did you understand that Miss Shabizis had to go to school even on the day that her mom passed away?
To the extent that that was contained anywhere in the information I provided, that is not something that I took note of.
In school, she did terrible. She got all Fs. Is that correct? Did you gather? I'm sorry. Did you gather that from going through the Bellin records?
Yes, it described how there was a decline in her academic performance during the school year following her mother's death.
Now, have you had cases where people that you work with in a professional capacity as a forensic psychologist, where people have court orders for civil commitment or court orders to take psychotropic medication?
Yes, that is certainly something that is commonplace across the state of Wisconsin.
And in this case, you did receive a copy of those orders, the order for commitment and the order for medications for Taylor Shabizis?
I did not receive the court orders, although I received discharge documentation pertaining to the hospitalization during which she was assigned such a court order.
And an order for commitment, that means the person has a mental defect. Is that correct?
The relevant legal standard primarily pertains to dangerousness. The person is in acute danger to oneself, others, or of serious property damage. It is not necessarily predicated per se upon any specific psychiatric diagnosis.
If I'm looking at an order for commitment and it talks about court finds the subject is mentally ill, and that says it for Taylor Shabizis, would you believe that to be accurate?
I would say that, again, it is implicating some degree of mental health symptoms, although, again, it can be somewhat of parsing words, looking at is it a legitimate mental illness per se versus aberrant mental status resulting from acute and insignificant ingestion of intoxicants.
I'm looking at the order for commitment. The court finds number 4, the subject has been adjudicated pursuant to 18 USC United States Code 922 G4 as a mental defective or committed to a mental institution. Would you have any reason to doubt that?
I was wondering if you can clarify your question, sir.
Well, the order says that. So does that mean that she's got a mental defect?
I would say it means that someone involved in petitioning for that order apparently did believe that she did, yes.
And that from your review, was it your understanding that Taylor Shabizis was committed for 6 months to Nicolay Psychiatric Center?
I'm aware that she was subject to a 6-month civil commitment that did not result in her placement within the facility for that duration, but rather discharged her with several conditions that, if not followed, could have potentially resulted in her return to a more restrictive setting.
And was your understanding that she worked with Brown County Human Services when she was at the Nicolay Treatment Center?
Yes.
And was it your understanding that the Nicolay Psychiatric Center is a maximum level of treatment? It's a locked unit. It's an inpatient facility. Is that correct?
Yes, it is a locked inpatient psychiatric unit.
So they don't just send anybody there. If you have a mental health problem, that's probably where you go, correct? At least in this town.
I would say if you're having an episode of aberrant mental status, regardless of etiology, that yes, that it would commonly be a setting in which an individual would be placed.
If someone is deemed to be, to suffer from a mental defect or a mental illness, does that always tag along with them? Is that always a label that they have for the future going forward?
I would say certainly it's something that, to the extent it's contained within someone's file, that's a label that future evaluators and clinicians will see. Although according to best practice, they would perform their own independent evaluation to determine whether they think that the individual continues to qualify for such a diagnosis.
And you don't often see people being ordered by the court to be required to involuntarily take medication and take treatment, correct?
I would say that the base rate for that it is certainly quite low, as again, part of the legal standard revolves around dangerousness, and it's a relatively high bar for someone to be determined to be in acute danger to themselves or others, or
But was it your understanding, at least back in 2021, when Taylor Shabusiness was at Nicolay, that she was prohibited from possessing a firearm because of her commitment? Is that true?
Objection, Your Honor, just to the relevance of this,
Goes to the dangerousness that he just testified to.
which is not at issue here.
I said what I said, so that's just my argument, Your Honor.
I'm going to sustain the objection. Move on, Mr. Farrell.
All right. The fact that she was under a civil commitment order and a order to take psychotropic medications, that's a very serious consideration that a psychologist has to take into account when assessing the competency issues, correct?
I would say that certainly is an important piece of the defendant's clinical history that's taken into consideration, although it does not necessarily directly translate on the issue of her contemporary mental status, especially given that at the time of her admission to that facility, she had been using methamphetamine several times per day for several months leading up to it, which could easily explain the apparent mental status at that time, and presumably is not a factor given her restricted access to intoxicants within the jail at present.
You know, as a psychologist, you have a PhD degree, you have a lot of education, a lot of experience with your 800 competency evaluations that you've done. You look at records, correct? And you've looked at the Bellin records for Taylor Shabusiness, correct?
Yes.
And at least as to the diagnosis for her from Bellin, is it true that at least in 2021, they diagnosed her with bipolar disorder, current episode, manic severe with psychotic features? You remember reading that?
Yes, I am aware that that diagnosis was assigned when she was hospitalized in 2021.
And that she was even treated with medications like Aristata and Prozac, correct?
Yes.
And I looked at did you look at the Brown County Human Services Community Treatment records, which I believe are part of the Nicolay records? You looked at those records, correct?
I reviewed the records that pertains to the inpatient hospitalization. So to the extent that there were any peripheral records that did not directly pertain to that episode of care, I cannot necessarily say that I reviewed them.
It's true that she was at Nicolay, they say Brown County, but she was at Nicolay from March 22nd of 2021 to April 12th of 2021, correct?
Yes.
And in the records, it says, quote, this patient was on the psychiatric unit at Brown County from 3/22/21 to 4/12/21. She has a diagnosis of bipolar disorder and presented extremely psychotic and manic. And then it talks about her situation was complicated by methamphetamine use and also by the fact that she was pregnant, correct?
Yes, I'm aware that those were the impressions and the information contained within those records.
Do you agree with the fact that she was diagnosed with being bipolar?
I agree that that diagnosis was assigned to her as reflected in the records, although providing a diagnosis of bipolar disorder to someone who had very acutely been abusing numerous intoxicants is not best practice, as a bipolar disorder, by definition and by diagnostic criteria, cannot be most fundamentally attributable to the effects of a medical condition or an ingested substance. And so from my perspective, I don't see how those providers could have determined the presence of an independent mental illness separate from the very significant polysubstance abuse that continued up until the day of her admission to the facility.
So it's your opinion, you don't think she's got bipolar disorder, correct?
It is my opinion that the totality of information available to me weighs contrary to that diagnosis.
But do you know for sure if she has bipolar or not?
I would say to a reasonable degree of professional certainty, she does not meet diagnostic criteria for bipolar disorder.
Who diagnoses that? Is that the purview of a psychologist or a psychiatrist?
I would say either of those disciplines would be trained and equipped to assign such a diagnosis.
In this case, well, for a psychologist, there's 2 gold standard tests, correct?
I would say that certainly there are tests that are more widely used than others. Some people will apply the label of gold gold standard, although it's not as if there's a list I can consult that differentiates gold standard from non-gold standard tests, psychological tests.
The main widely known test is the MMPI Minnesota Multiphasic Personality Inventory. Is that correct?
I would say that yes, that is the most widely used objective measure of adult psychopathology and personality.
And then the other test is the Milan Clinical Multi-Axial Inventory. Is that correct?
Yes, that certainly is almost as widely used as the MMPI for the same purposes, and primarily it is used specifically to tease apart a different personality disorder.
Jamal Dennis, president, is the defendant. His counsel, I see two of his counsel, or three.
Mr. Howard is on his way out.
All right, are we able to proceed without Mr. Howard?
Yes.
All right, and we have assistant state attorneys as well. So jury had a question. The question reads, where can we find the call logs of the 9807 number? Then the second says, can we hear Mr. Kelly testimony, Trayvon Glass, Portland, Sutherland? When I look through the my notes, am I missing something on Portland? Courtney, rather, Sutherland?
There were 27 witnesses that testified, known by that name. I don't know if they're trying to refer to the statement of Portland Henry, if they mean one of the other witnesses. I don't know if to read them. The list of the witnesses that testified, ask who they mean.
Any suggestions from the defense?
Maybe ask what they think this Courtney Sutherland testified to, and based on the basis of the testimony, we could probably figure out which witness it was.
I would suggest you respond back that there is no witness by the name of Courtney Sutherland.
So my thought would be, that's what I would do. I agree with you, Counsel. I would just say, please clarify regarding regarding Courtney Sutherland. We have no witness by that name. Is that all right with the state?
Yes, Your Honor.
Defense?
Yes.
And what about the call logs?
So that is on states 63.
States
And
53 or 63?
63, and then it's within subfolders therein. So there's multiple call logs for the manual of Glen.
Right. So state 63, and now court order regarding Mr. Kelly, you indicated that it would take you how long to get Mr. Kelly's testimony ready?
Probably not till tomorrow.
Probably not till tomorrow. And on trivia and glass, you're ready to go on that, correct? Is that right?
Yes, Judge, besides, I just need to go through it.
Yeah, you need 15 minutes or so.
Yeah.
All right, so just indicate for the record that the court advising you take about 15 minutes or so to be ready on Mr. Glass's testimony. Mr. Kelly should have by tomorrow, and regarding Ms. Sutherland, we need clarification. So I'm just going to write that back, let you know what it is.
So they want to see Melly's phone records, and they want to revisit Trayvon Glass's testimony. And they asked about Portland's testimony, but verify that. Yeah, I guess they can't. So it looks like we'll be on verdict watch tomorrow too. I was planning on having a beach day.
Definitely a good point. The computer in the back might not have Excel on it to be able to open the call logs for the 9807 phone number. So we could provide a printed copy of those.
Council, is there any objection to that?
Can we have a moment on that?
Sure, yes.
And I think there's another question.
Step outside, please. Step outside, please.
Michael Kelly. So they want to. They asked about Michael Kelly. So Michael Kelly is the one who did CSI. He's the one with the he did the string and gum trajectory stuff on day 3. So they want to. They asked about him and
Is on the question, where can we find the call logs of the 9807 number I indicated? Please refer to State's Exhibit number 63. And below that it says, can we hear Mr. Kelly testimony of Trevion Glass, Courtney Sullivan? I said, please clarify, Courtney Sullivan did not testify. Trevion Glass's testimony can be read back today. Michael Kelly testimony needs to be prepared to read back probably tomorrow. Any objections?
No.
In terms of the printed version, council?
We're not agreeing to print it out. Whatever's in evidence is evidence, so if it's the computer, chip, or whatever, that's what I should look at.
Can I see council sidebar for a second?
Yes,
Gary,
yes, sir.
can you give this to the jury to hold this note? Do not destroy the note, so we need that in the court file.
All right, so this is Michael Kelly. So they're asking about his testimony. But he didn't testify, so I have no idea who that's supposed to be, and neither does the judge or the attorneys, because they're going to ask the jury to clarify that. Don't know who that is. I don't even know who they could be talking about unless they're talking about Brooke. All right. We'll keep that one over here and watch this while we're waiting.
You can get a lot of data as a psychologist by performing these two tests on a patient or an individual, correct?
It certainly can yield relevant information, yes.
Did you administer these two tests to Taylor Shabizis when you met with her earlier this year or on July 12th of 2023?
I did not.
And yet you criticize Dr. Litton for not doing that as well, correct?
I criticized her for not performing more symptom validity testing, which is something that is embedded within instruments such as MMPI, although there are also separate instruments that are much briefer that can be used for the same purpose.
And I think you said that Dr. Engine and Dr. Lucetta did the MMPI and the MCMI, is that correct?
So Dr. Engen administered the MMPI and Dr. Lucetta administered a competency-specific instrument, the evaluation of competency to stand trial. I believe there's the revised edition. And so within that, it contains sub-skills looking at the probability that an evaluation subject is feigning both psychotic and non-psychotic symptoms towards feigning adjudicated incompetency.
More information could be gathered about Ms. Shabizis's mental health profile and status as it relates to competency if she went inpatient for a period of time at Mendota.
Every time I pause it.
or Winnebago. Is that fair?
I'm going to object that this has been asked and answered already.
No, it hasn't, because it relates to the MMPI and the MCMI. I can rephrase, Your Honor. Maybe I should do that.
All right, well, maybe you should. When you will, the question is withdrawn, ask another question.
Okay, thank you very much. As it relates to the MMPI and MCMI, if Ms. Shabizis was sent to or transferred to Winnebago or Mendota, more data, more information could be garnered as it relates to this competency issue. Is that fair?
I would say that the repeated administration of those instruments could yield additional clinical data, although again, there was sufficient data for me to yield an opinion of a reasonable degree of professional certainty regarding her competency. So I really have no reason to believe that there would be much competency-specific data that would be yielded by such instruments.
But the issue as it relates to competency, as far as the doctors, the psychologists are concerned, it's kind of fractured because people have different opinions. Is that fair? The professionals have different opinions?
I would say that yes, certainly in terms of recently that myself and Dr. Litton have reached diverging opinions regarding the defendant's competency.
Did you also understand that Taylor Shabizis was admitted as an EM1 petition for auditory hallucinations and tactile hallucinations, such as being punched in the face and stomach and other delusional behavior? Was that your understanding that that happened?
It is my understanding that such symptoms were endorsed upon her admission to the Nicolay Psychiatric Center. Again, I would note that that occurred following a prolonged period of heavy methamphetamine use.
And she was at least telling staff at Brown County that she was seeing the staff's hair fly all around, that she was hearing voices and seeing things like small rabbits and feeling as though a magnet was keeping her in her chair. That was in the reports as well, correct?
Yes, the records reflect that she did endorse such symptoms at that time.
And she indicated that all she wanted to do was just go to heaven, correct? That was in the reports.
Yes, there were certain comments to that and other effect, generally pertaining to thoughts about death and or suicide.
And did she also indicate that she couldn't think of what was going on in her head and that her thoughts were disorganized?
From my recollection of the records, yes, she endorsed cognitive symptoms of that kind during that treatment episode.
Did it indicate, at least now I'm going to focus on your report. Did it indicate in your report on page 3 that you talked about there was some difficulty or a possibility in parsing out to what extent she got improvement from taking medications, psychotropic medications versus forced abstinence from intoxicants?
Yes, I noted that that was, again, a point of confounding information with regard to her diagnosis.
And that she had a pretty significant history of polysubstance abuse, correct?
Yes.
She abused marijuana, hallucinogens, cocaine, opiates, methamphetamine, heroin, fentanyl, correct?
Yes.
And that she had aberrant mental status and sometimes a tendency to rampage, is that right?
Yes, and she specifically attributed that rampaging tendency to acute methamphetamine intoxication.
Did she ever tell you that, well, strike that. When you met with her on July 12th of 2023 for 90 minutes, did you see her smile at times where you wouldn't smile? Did you see her laughing inappropriately? Did you see unusual, bizarre, weird behavior?
I would say that yes, that the grinning out of context and some brief moments of inappropriate laughter were noted. I would not classify them as bizarre in this instance, and they did not detract from us having irrational reciprocal exchange.
But she would smile out of context to a evaluation topic, correct?
In some isolated moments, yes.
Did you see any evidence of psychosis at all during your contacts with her on either occasion when you met with her?
I did not.
You did a report to the court on November 18th of 2022, correct? Competency evaluation?
Yes.
And then in there, you indicated, page 5 of your report, that you indicated, in effect, her current endorsement of psychiatric symptoms appears illegitimate or at the very least exaggerated, correct?
Yes, that is what I wrote in that document.
So is it fair to say that you don't know if she is suffering from some kind of a mental disorder or if it's feigning or faking? You can't say 100% what it is, correct?
I would say, again, to the totality of available information as available to me at this time, to a reasonable degree of professional certainty, I can say that there is no credible evidence of her laboring with a severe mental illness, such as bipolar disorder or schizophrenia, which are typically the types of psychiatric conditions that would in and of themselves have the potential to render someone incompetent to proceed.
Did you ever see her distracted by internal or external stimuli of a delusional or psychotic nature during either interview that you had with her?
I would say during the November 2022 interview, there was no evidence whatsoever of any distraction. During the current interview, there was a moment in which she quite forcibly presented herself as if she was seeing the green train within the room, a symptom which again I find no credence or credibility to believe, but even to the extent that I would indulge that it did occur, I promptly redirected her, and there was no further apparent issue with such a green train. So again, to the extent that symptom was legitimate, it was a one-time instance, easily redirected, and had no impingement upon her rational participation.
During your interview with her on July 12th of 2023, did you see her get off the chair, sit on the floor, kneel down, turn her back to you, or anything like that?
She remained seated. There was no restlessness. There was no attempts to substantially shift her posture. She remained seated, facing towards me, and engaged in our discussion.
When you met with her, did she ever say that she heard voices at all?
She made a vague reference to hearing screams that sometimes come from other inmates within the jail. Other times she believes they're originating from within her own head.
Did she indicate that she was suffering from nightmares at all since being at the jail?
I do believe she made some reference to intermittent experiences of nightmares, yes.
For those of y'all asking it,
Okay, I have no other questions. Thank you.
You redirect Mr. Lizette.
Just very briefly, Your Honor. I think early on in the cross-examination, you were asked a question about having a postdoctoral fellow accompany you in the interview. Is that correct?
Yes.
You were asked about the appropriateness of having someone else present during an interview. Did you note in Dr. Litton's interview whether anyone else was present?
Yes, according to that document, it suggests that defense counsel was present for the entirety of that evaluation.
Based on your experience, is that consistent with best practice?
I would say that is a highly atypical arrangement for a forensic mental health evaluation.
Why is that?
And so when a third party, when I say a third party, I don't mean a silent observer. I have no reason to believe that my postdoctoral fellow would be present at any incident I interview. When I say a third party, I mean someone with some form of other pre-existing relationship with the defendant, whether that's an attorney, a relative, or whoever it might be. It is fundamentally impossible to parse out to what extent that person's presence and or influence might have influenced the evaluation subject's performance or the content of their responses.
In fact, from your review of Dr. Litton's report, does it appear that Mr. Freilich was actually asked at some point during the interview to participate?
I'm going to object to the form of that question, Your Honor. It's in her report. One question was asked. I didn't ask to be there, but the problem was that the chair got.
Mr. Freilich testifying? He's not been sworn as a witness.
The objection.
Relevance.
Overruled. Do you have the question, Doctor?
Can it please be repeated?
Just asked, I think, whether or not from Dr. Litton's report, you were able to observe whether or not Mr. Freilich was actually asked to participate at a point during the interview.
Yes, it did appear from my reading of that report that the interview was asked directly about his impressions of the defendant's competency.
And that was done in front of the defendant?
Again, according to my reading of the report, it does seem that it was done in the room only that the defendant was still present.
You were asked a question about medication noncompliance and whether that might have an impact on someone's mental state. Did you observe in the jail records from the recent time period, end of 2022 to present, whether or not Ms. Shabiznis had been compliant with taking any mental health related medications?
So since the end of March 2023, she has been remarkably inconsistent in accepting olanzapine, which is her prescribed psychotropic medication.
And based on your review of those jail records and your conversations with Ms. Shabiznis, has her non-compliance with medication appeared to significantly impact her functioning?
I did not notice any appreciable change in the records provided to me in her mental status or behavior that would seem to derive from her becoming non-compliant with medications. Really, her baseline behavior remained unchanged even after those medications were discontinued.
Is that significant to your analysis that when she's not taking medication, her behaviors don't appear to get any worse?
I would say certainly it suggests that, one, it's a point of data that weighs contrary to the presence of a legitimate severe mental illness, which typically, if someone were to become non-compliant with medications, there would be a noticeable exacerbation in symptoms. So from that clinical perspective, it's relevant, but also from the forensic perspective, it suggests that medication non-compliance really is a peripheral issue to her competency, and her baseline knowledge and functional capacities appear to remain constant, regardless of whether she is or is not taking psychotropic medication within the jail.
Then, Doctor, you were asked extensively about the stay in Nicolay in 2021, where she, I think it was March of 2021, where she arrived. That was about a 21-day stay, is that correct?
Yes, I noted that it was approximately 3 weeks.
And it was indicated both in the notes and through other information that's available that Ms. Shabiznis had significant methamphetamine use prior to that hospitalization?
Yes.
And did you note a significant change in her behavior from the first part of that stay upon arrival and to her behaviors at time of departure from the facility?
Yes, a linear trend towards psychiatric stability was noted across those 3 weeks, such that the seemingly psychotic symptoms had cleared and her thinking and behavior became more organized, and she was no longer viewed as an imminent risk of harm to herself or others.
So essentially within a relatively short time frame, when the methamphetamine was no longer in her body, we're noting a very significant improvement in symptoms.
Yes.
I have no further questions.
On those topics, Mr. Freilich?
I have nothing further.
Okay, then the question is, I suppose, is whether Dr. Seipel is going to be excused or whether anyone might want to potentially call him as rebuttal testimony to the rebuttal testimony that we may be hearing. I'll start with the state. Do you want him released, or do you want to have him stay on the line?
I think he can be released, Your Honor.
Any objection to him being released?
I have no objection to that.
Dr. Seipel, your participation is concluded. Thank you very much.
You're very welcome, sir.
Any other witnesses you want to call, Mr. Lizay?
Not from the state, Your Honor.
Mr. Freilich?
Your Honor, I'm going to need a little bit of time to talk to Dr. Litton on the issue of whether she's going to testify on rebuttal. We talked about that last night.
Okay, we'll take it, the court will then take a recess for 10 minutes. It is now it'll be a little more than 10 minutes. It's now quarter to 10. We'll reconvene at 5 minutes to 10. All right?
Okay,
We are in recess.
thank you.
Michael Kelly is the one that they had asked to, Robin's Viewpoint asked, what's the name of the person, the pic that I showed with the white hair that the jury was asking about? It's Michael Kelly.
I'll call Diane. Okay.
The judge reminds me of that actor. What's he play on? I can see his face.
Sorry to interrupt.
Desperate Housewives. What is it? I can see him in my face. Yeah, they probably come back, but I want to see her behavior before they go to the actual recess. There it is, Twin Peaks. I could not remember. But I see his face. All right, let's. Yes, Kyle McLaughlin. Look, this is totally the judge. That's exactly who I was thinking. I love y'all. Y'all know everything. Everything my old brain can't remember.
Thank you.
Look, when it gets back up there, I won't put the picture out there. So she was on meth, and she choked her boyfriend with a chain and unalived him, and then dismembered him, and then used his parts on herself, and put his body parts into bags and left his head in a bucket in his mom's basement. Some of the parts were also in shopping bags. And then his torso was in a storage tote. And I mean, it was, it's pretty. How do you even, what the hell? She's supposed to start trial Monday.
All rise. Circuit Court Branch 2 is again in session. Your silence is requested.
Be seated.
We'll go over the court document we have and all this is done. Look at there. We know who's going to play him on the movie. Right? Like they could be brothers. So here's his two twins.
Really?
Thank you, Your Honor. I talked to the defense expert, Dr. Litton, had an extended conversation with her last evening and this morning after we took our break. I need 1 minute.
At least his notepad doesn't say evil plans and stuff.
Your Honor, after much thought and discussion with Dr. Litton and with my client agrees with this, that we're not going to call her in rebuttal. We're going to leave the record as it is.
Okay, then, unless I'm mistaken, I'm going to excuse her.
Yes, she can be excused.
Mr. Freilich,
Yes, she can be there, Your Honor.
any reason, Mr. Lezay, why I wouldn't excuse Dr. Litton?
No.
Dr. Litton, you are excused. Thank you very much for your time. Okay, then I will turn to the state for an argument. Mr. Lezay.
Thank you, Your Honor. As the court is aware, it is the state's burden at this juncture to demonstrate by the greater weight of credible evidence. So it is a relatively low burden, but it is the state's burden to demonstrate that Ms. Shabusiness is competent to proceed in this matter. I think when the court considers the totality of all the information before it, that it's quite clear that Ms. Shabusiness is in fact competent to proceed in this case. And this is a judicial decision. It's not a medical decision. It's a decision that the court can make based on a variety of different factors. We've now had 5 different competency evaluations in this case. Dr. Litton's evaluation is frankly the only evaluation that suggests that she's not competent. I think there are a number of flaws with Dr. Litton's evaluation, and I think that Dr. Seipel's report and his testimony here today call into question a number of her findings and certainly the methodology that was used today. And I do just want to take a moment that when I asked the question about Mr. Freilich being present, I certainly was not intending to suggest that Mr. Freilich did anything inappropriate at all. That was not the purpose of my question. I think to the extent that Dr. Litton had someone else in the room, that's a decision she made that may not be consistent with best practice. But I don't want to suggest that Mr. Freilich made any attempt to try to influence competency. I do think that what clearly makes the most sense is Dr. Seipel's ultimate conclusion in this case, which is that to the extent that there are any potential symptoms of psychosis in this case, that those symptoms had generally been driven by 2 things: intentional use of illicit substances, particularly methamphetamine, and then volitional conduct, frankly, on the part of Ms. Shabusiness. And of course, as the court is to consider, it isn't just does she have a mental illness, does she potentially have some sort of symptoms that may in some way make it more difficult or more challenging for her to participate. The issue is, do those symptoms, if they exist, do they substantially impact her ability to understand what's going on and to assist in her defense? And I think quite clearly neither of those things are present. Frankly, I'm not sure that even the motion from counsel suggests that there has been a significant impact in his ability to work with Ms. Shabusiness on this case as a result of any of those perceived symptoms. And in the interviews that she's had with all of the clinicians, she appears to generally understand the concepts, the legal concepts. She knows who her attorneys are, what the role is. She knows what the state's role is. She knows what the court's role is. She understands what she's facing, why she's here. And she is able to pretty substantially describe the facts that put her in this position. And the court is able to consider all of the facts and circumstances that are available and its own observations of the defendant at counsel table, of her ability to sit through lengthy, complex motion hearings without disruption, and apparently to assist her attorney throughout that process, and Mr. Freilich's ability to communicate with her quite well. It does appear that she and Mr. Freilich have developed a quality working relationship and that she's able to assist him in this process. I think when the court evaluates all of those factors, that it's quite clear that the state has met the burden by the greater weight of credible evidence that Ms. Shabusiness is competent to proceed in this action.
Okay, thank you. Mr. Freilich.
Thank you, Your Honor. The law, Wisconsin law 971.14 subsection 3 of the Wisconsin statutes indicates that no person who lacks substantial mental capacity or understanding of the procedures to assist in her own defense may be tried, convicted, or sentenced for the commission of an offense so long as the incapacity endures. We have a young lady here, Taylor Denise Shabusiness, who does have mental health problems. She's been at Bellin Psychiatric Center for mental health treatment. They said that she had bipolar disorder with psychotic features. She's been to the Nicolay Psychiatric Center for a commitment, 6-month commitment order. She was there for about a month, but she was under a court order for commitment that was filed April 1st of 2021, and that she was deemed to be mentally ill. She was deemed by the court to be adjudicated as a mental defective or committed to a mental institution. She was at the mental health institution, and that she was under a court order to take psychotropic medications. So she has a history here of lots of problems. The Brown County jail records bore out that she's had problems with following directions, standing for head count, drawing on the walls, doing all kinds of bizarre and odd behaviors. And what we have here are two diabolically opposed conclusions or opinions from the psychologist here. Dr. Seipel feels that Taylor Shabizis is competent, and our doctor, Dr. Lighton, who has a lot of experience, she opines or concludes that she's not competent. So we have a problem here. We have we're at a crossroads. We've got some issues that have to be sorted out. I beg to differ with Dr. Seipel. I mean, he testified that this is not a complex case. It sure is a complex case. There's lots of records. There's lots of history here of mental health problems, drug addiction issues, all different kinds of problems. I think that both of the doctors have a lot of information, have a lot of training. They've looked at all these reports that have been submitted to the court. But Dr. Tracy Lucetta, who's also a PhD, she sent in a report that was filed on May 6th of 2022 when my predecessor, Attorney Jolly, was on the case. And she indicated that she recommended that my client be transferred to one of the state's psychiatric facilities like the Mendota Mental Health Institute or Winnebago Mental Health Institute for further evaluation under close and extended observation by qualified professionals. If she was sent to a state facility like that for a week or a month or whatever time is needed, a whole team of professionals could assess, fully assess my client's competency to proceed in this case. There are all kinds of issues here that have to be sorted out. It's not a clear-cut case, in our opinion. And I would argue that, a 90-minute interview by Dr. Seipel with Ms. Shabizis, I don't think that is going to be able to be enough time to really fully understand and address the issues in this particular case. Dr. Seipel didn't do the MMPI or the MCMI. Dr. Lighton did not. Dr. Engine apparently did. I also want to comment on the issue with Dr. Lighton. She asked me to sit in, and I know that there were concerns because the chair was thrown at her, and she's an older lady, and so I sat in, and that's what happened there. I didn't get involved. I stayed out of it, but I was just there I think my client felt more comfortable with that. So I just want to comment on that. But I believe that my client is not a very good historian. I think she's got memory deficits. We've got all these records that I've poured over and looked at, sent to the court. I think that my client has had or does suffer from bipolar 1 disorder based on my review of the records. And, based on her conduct with regards to throwing a chair at the professional that's trying to evaluate her, attacking her, Mr. Jolly, allegedly previously in court, engaging in other courtroom antics, the staple going into her arm, not taking medications, who knows? Who knows if the drugs, the methamphetamine, the marijuana, the cocaine, all these other drugs, did they cause brain damage? Did they cause a mental defect? That's all for the court to decide, but I submit that it likely did. And it's caused a lot of different problems for Ms. Shabizis with being able to really participate, understand what's going on, assist in her own defense. The fact that she apparently did have some hallucinations in the past, I think all that leads to the conclusion and my argument that my client should be deemed not competent at this time, or if the court doesn't feel they can even make a decision on that, send her over to Mendota or Winnebago for a further evaluation. Then we'll know. Then we'll know for sure if she's ready to participate in the trial and assist with defense counsel and be able to understand what's going on. I have some serious reservations on her mental status, especially in light of the civil commitment, especially in light of the order to take medications. She has been deemed mentally ill by a court of law. So nobody can dispute that. I would submit that that's likely continuing, but there's all kinds of different opinions here. So I'd ask that the court go along with my arguments that she be transferred to one of the state's facilities for further and extended observation. Thank you.
Thank you, Mr. Freilich. Well, I've had an opportunity now to listen to the testimony of both of the evaluators. I've also had an opportunity to review both of their reports. I've had an opportunity to observe and weigh their credibility as they've been testifying and observe their testimony. And frankly, as has been alluded to here by the parties, I've had an opportunity just from the time that we've been in court over the recent past to observe Ms. Shabiznes and how she's participated in this case. And on several occasions in the past when we've addressed this issue, I've had I've reviewed the history, and I'm not going to review the history of the competency process that's gone through here in this case again, because I've done it several times. But I want to highlight a few things, and that is that on 3 separate occasions, this court has ordered, has tasked the Wisconsin Forensic Unit with assessing Ms. Shabiznes' competency. And I know there's been other evaluations that have been conducted as well. But in the first one, Dr. Collins really cautioned the court to maintain vigilance on this issue throughout the case. And I have done that. I have done that. And I've listened to the requests for on various occasions to have more competency evaluations conducted. On a few of those occasions, I've denied that request. And then this time I granted it because Dr. Lighton came forward. Really each of these evaluators has a different opinion. Dr. Lighton's opinion on page 2 of her report is, quote, "My opinion also is that to a reasonable degree of psychological certainty, Ms. Shabiznes is not competent to proceed to trial," close quote. Dr. Seipel, as he testified here today, has an opinion directly to the contrary. His report indicates, quote, "The weight of the credible information again points to the conclusion that Ms. Shabiznes is competent to proceed, and I offer that opinion to a reasonable degree of professional certainty to the courts for the court's adjudication," close quote. In analyzing not only their testimony but the reports, I parsed through the reports, and frankly, it's actually difficult to parse out and unwrap Dr. Lighton's report regarding which piece relates to the NGI and which piece relates to the competency. Some things I want to just address regarding Dr. Seipel's report that I find meaningful, that I find insightful to me. I'm going to read a couple of those things. On page 14 of a report, he addresses his interaction with Ms. Shabiznes, and I think it's very relevant. He says, quote, "Her commentary occasionally waxed somewhat provocative, for example, sexual or otherwise graphic. However, such comments were not directed at me in any form of threatening or solicitous manner. Rather, she simply seemed to be fishing for a reaction. Thus, I either ignored such comments or matter-of-factly acknowledged them before continuing with my line of questioning. Through such an approach, I was easily able to sustain Ms. Shabiznes in rational, reciprocal, forward-moving discussion. Her replies were almost always relevant, albeit not always forthright, and she was easily redirected and responsive to prompting when needed. Moreover, in the few moments Where she was evidently confused by questions, she easily benefited from simple accommodations such as repetition and rephrasing. Her expressed thoughts were consistently organized. I detected no credible delusional beliefs, finding claims such as that she believed Dr. Lighton to have stuck her tongue out had her to be entirely lacking in credence. I found that relevant. It was a direct reflection of what the doctor experienced when he was interacting with Ms. Shabusiness. In another portion of his report, he notes, in any event, there was no evidence whatsoever of Ms. Shabusiness being distracted by any form of hallucinatory phenomenon. That's on page 15 of his report. Just summing some of the highlights that were also gleaned during the testimony. On page 16 of his report, he notes that Ms. Shabusiness indicated that she can assist her attorney in her defense by giving him all the information possible. Thus, she offered that it is important to be forthcoming with defense counsel. So he's able to help me. He can't if I don't be honest. Indeed, she stated that she has been honest with Attorney Freilich about the circumstances of this case.
The super chat.
The report goes on in another location to indicate, quote, when considered in that light, there simply is no reasonable basis on which to conclude that Ms. Shabusiness lacks capacity to behave appropriately and communicate rationally, given that she has now twice clearly displayed such capacities. He goes on to indicate, quote, she has no difficulty grasping the roles of relevant courtroom personnel and the adversarial nature of the criminal proceedings. Again, I found all of those to be very insightful and credible. They seemed very credible. I've weighed the credibility of each of the experts regarding this topic of competency, and I find those observations to be credible from Dr. Seipel. I've observed Ms. Shabusiness interacting with her attorney. Obviously, I can't hear what they're talking about, but as I sit up here, I can see everything that goes on in the courtroom. I can see them interacting, discussing. Ms. Shabusiness indicates she thinks she can work with him. She understands what the courtroom procedures and players are. There's been occasions of inappropriate behavior, which Dr. Seipel indicated on testimony here, that he was fundamentally unable to rule out that they are volitional in nature. Satisfied based upon all the evidence I've received that the greater weight of the credible evidence in this case, and my assessment of the credibility is included in that the greater weight of the credible evidence supports a finding that Ms. Shabusiness is competent to proceed to trial, and I'm going to make that finding now. So that's the decision of the court.
So going forward, this will be our trial. We start
Regarding the
Monday.
competency hearing, that piece of this case is now concluded for today.
It's a doozy.
The jury selection is scheduled to begin at 1 o'clock. I believe the jury was requested to report at 12:30, so they should be ready to go when all of us are sitting at council table at 1 o'clock up in branch 1. And I want to just cover a few topics before we break. I alluded to this before, but I'm confirming it for the parties now. I'm going to seat 4 alternates in this case. That's a lot of alternates, but I don't want to run into troubles for the sake of not having enough alternates. So we're going to have 4 alternates, and that means, in light of the type of case this is, and in light of the fact that attorneys get 1 more strike for every alternate, that each side would be getting 10 strikes.
Judge, I think the statute requires 1 more strike if the court is going to have alternates. I don't think it has to be per alternate.
Okay. Then I'll confirm that before we start upstairs. We've got the chair set up for the appropriate number of jurors. The other question I have is, have the attorneys addressed the video as far as redaction? The video was very lengthy. A lot of it had really nothing going on. Mr. Saunders requested that I just simply watch the part of the interview, and he submitted the time frames. Mr. Freilich requested that I watch the entirety of the video.
Even going to go
I
forward.
guess the question is, has
Until now.
that issue been addressed? Or Mr. Saunders?
This morning, I was finishing getting a redacted copy, not only the dead portions, but also the portions that were moved and essentially stipulated out. I can provide that. I would hope that's completed now. And I can provide those times to council that were excised.
Just answer your phone or shut it off. I'm gonna monitor that rule as we go forward. Everybody needs to make sure when you walk in the courtroom, I've entered an order that there's going to be no cell phones functioning while we're in here, with a couple of exceptions that are in the order that I published. Make sure you got your phones off, okay? Back to you, Mr. Freilich. So I guess I don't want to run into a situation where we're addressing an issue of, I got the times from Mr. Saunders and I don't agree with them, because I want to know if you don't agree with them ahead of time so that we can address it. Mr. Freilich.
Well, what I think I could do is maybe meet with Mr. Saunders and Mr. Lassay and then talk about it, see it, and then make a decision on that. But I got to see it first.
Good. That's what I'm trying to prompt, because we'll have that video wouldn't be offered into evidence until sometime next week. So you'll have the whole weekend to talk that through, but I want to make sure that that conversation is going on so I don't have a jury sitting waiting while we work through those issues. I did, just for the party's own edification, and I think the attorneys were aware of it because my JA contacted your office, I drafted orders based upon the motions in limine that were filed, just outlining what was granted and what was denied so that it's all clear for everyone and we don't have to spin our memory back to what happened. I would invite you all to look at those over the weekend to make sure that they're accurate. I've pored over them. I think they're accurate. So I invite you to do that. But then back to the jury selection, Mr. Lassay, your suggestion is that just simply one extra strike because we're having alternates as opposed to one extra strike per alternate?
I think so. It's 97203 is the statute that talks about peremptory challenges, and it says in a case of this nature that everyone gets 6 challenges, and then the language specifically says each side shall be allowed one additional peremptory challenge if additional jurors are to be selected under 97204 sub 1, which I think is the alternates.
Mr. Freilich, do you have any opinion on that?
That makes sense, Your Honor.
Okay. It's a lot easier if you stipulate, and that sounds like what I've got. So I'll review that section of the statute as well, just to make sure we're ready. And if that's the case, obviously, jurors we pull up changes. So anything else before we break? Mr. Saunders?
Oh, Judge, there was an issue that's related to, I think, the NGI evaluation. I think when the court ordered Dr. Engen to perform the NGI evaluation, the court provided access to the competency reports of the other parties, including the prior competency reports of counsel. I would ask that the state be allowed to provide, or that the court provide to Dr. Engen as the court-appointed expert on NGI, the new reports of Dr. Litton and Dr. Seipel.
Mr. Freilich, any objection to that?
No, Your Honor, that's pretty common practice.
I think it's fair that everybody that's going to be testifying regarding that issue be allowed to access the reports. So I will order that. I guess the other issue actually that is out there is the situation with Dr. O'Donnell. So let's take that up. Mr. Freilich.
Your Honor, I did, the defense did retain Dr. James O'Donnell from Illinois, toxicologist and pharmacologist. He did testify at the motion hearing that we had on the issues and the substances that my client had been using or abusing in the past. I thought his testimony was helpful, and I feel it's relevant as it relates to the NGI issue. I know that the court said that I was to let the court know by a certain date on whether I wanted to have him testify, which I believe was for the trial. And I know the law, voluntary intoxication is not a defense, so I wasn't intending on having him testify at the trial. But if the case gets to a point where we have phase 2, the NGI phase, I would like to have permission to have him testify. I provided notice in June, I believe, with his curriculum vitae and a summary of his opinion. We now have his testimony that's been filed. That's all part of the record. So I would like to have permission to call him as a defense witness if it gets to the NGI phase of this trial. I would not call him during the fact-finding phase of the trial, but I may have had a misunderstanding as far as what the court was asking of me. But as to the trial, I had no intent of calling him at the trial, only at the NGI phase. Thank you.
Well, I guess the issue, I'm going to turn to the state in a minute. As far as the timing goes, I've been very conscious of the timing of how things go to make sure this trial stays on time. And I printed a copy of the transcript from the hearing that we held on June 13. And near the end of that, I noted that I think we've addressed all the motions that were set on today, other than the state's motion to exclude the testimony of Dr. O'Donnell. The state doesn't want him to testify. I go on to say, so I think what we need to do regarding that motion is, Mr. Freilich, you need to make a determination rather promptly of whether you intend to utilize his testimony. If he indicates to you, I don't intend to use them, then your motion is really not relevant anymore. A Daubert motion wouldn't be relevant. But you need to make that determination, Mr. Freilich, and then notify the court and notify Mr. Saunders so we can get that on, if need be, and have it heard promptly. So I'm trying to think of a deadline that would be appropriate. And I'm thinking if I gave you a week, you could assess whether or not this was a piece of information that you want to use at the trial and notify everyone of that fact. Obviously, you need a little more. If you need a little more time, let us know. But I'd like to hear from you by the 20th. And then you responded, could I have until either the next Thursday or Friday? And I gave you until the next Friday at noon. And I indicated, so I'm not going to give you until the close of business on Friday because we'll lose a weekend of scheduling. And what we have now is the state is objecting. And I don't know if they're asking for a Daubert hearing, but I don't know when I'll hear it. And, as far as the trial is one whole piece. It goes in two phases. But if you're suggesting that Dr. O'Donnell is going to be testifying, they're objecting. And so the court's in a little bit of a bind because the jury's coming in two hours. But Mr. Saunders.
Yeah, so obviously there's the issue of the Daubert hearing. I guess the state's concerns are twofold. First, if we're calling Dr. O'Donnell strictly for the confines of what he's previously testified to at the motion hearing on the 13th, not only is it in the state's belief not relevant for the first phase, it wouldn't be relevant for the second phase either, because a voluntarily ingested substance is not a mental disease or defect. So if we're looking at the confines of the prior testimony, I don't believe there's anything relevant to the second phase either that Dr. O'Donnell could testify to. If there's things counsel wants to explore, and I don't think it's clear from the notice or the summary we received that there are additional areas to explore, we would have concerns then about Dr. O'Donnell's ability to testify and provide relevant information that he's qualified to offer if we're going beyond the scope of that prior testimony. So those are the state's concerns and why we asked to exclude Dr. O'Donnell.
Daubert hearing is
Your Honor, in, I believe it was June, quite some time ago, I provided a very detailed notice of intent to present expert testimony. I put the state on notice. I filed it. It was quite thick with the CV and a summary opinion and all of that. We had the motion hearing. I mean, the state, the prosecutors had a chance to ask all the questions that they wanted to Dr. O'Donnell. They have the transcript. I'm sure they've read it. I've read it. It's in the record. I mean, in fairness to me, I would argue we don't need a Daubert hearing. We already had it. We already kind of had it. But the other thing is with Dr. Christina Engine, I wasn't the lawyer at the time. I don't know if she testified. I've had no chance to do a Daubert hearing on her. I've had no chance to question and cross-examine her about her report and findings. And so I'm at a disadvantage. we're all should be on a level playing field. And I know the court said that, but in my opinion, I thought you were talking about the trial. I was always thinking about the NGI phase of this case. And that's where the relevancy, in my humble opinion, that's where the relevant testimony would come in with Dr. O'Donnell. The other thing is, Your Honor, was the funding. I mean, I got the funding for him to come here and provide testimony with regards to the motion hearing. But I had to get permission for funding for any future hearings. And, experts are extremely expensive, and they've got to basically reorganize their calendar. But I did get additional funding for Dr. O'Donnell to come for the NGI phase of the trial, if it even gets to that point. But I understand the court is kind of in a difficult spot, but I mean, we all kind of know what he's going to say and what he would opine about and the information that he would provide. And I think it is relevant and helpful to the court because, maybe the drugs caused a mental disease or defect. I don't know. That's for the professionals to talk about, but you would think that a toxicologist or a pharmacologist would.
We'll
go back to
jury adjournment. We have a new jury inquiry question. It says clarification. Courtney Sutherland should have been Portland Henry. We have decided we do not need to hear his statement from the hospital. Trevion Glass, who would like to have his testimony read back. Michael Kelly, who would like to have his testimony read back when available. So my thought is just to bring it in. We'll have him read back Trevion Glass testimony now. Further communications ready on that. Is that right now?
Your Honor, I'd like to take a few positions with respect to the questions. With respect to the reading back of the testimony, our position is that testimony is comprised not only of its substance, but the manner in which it's delivered. When we are in a fortunate situation such as this, where the entire testimony is captured on video camera, we think it would be more appropriate for the jury to either be told to rely upon their recollection, because even though their recollection would be incomplete, it would be comprehensive. They'll be recalling not only what was said, but the manner in which the person testified. A gentleman like Trevion Glass in particular, who was hiding behind the monitor for half of his testimony and then hiding deliberately behind his dreadlocks for the rest of his testimony. I think his testimony is going to look a whole lot better on paper than it did when it was delivered. The best evidence of his testimony was captured on videotape, and the jury would be able to see it. And so we would suggest that since we're in a situation whereby the testimony has been captured on video, that the best practice in this instance would be that any testimony that is asked back for not be read back, because it would be devoid of its context, but be shown. And with respect to Mr. Kelly, Officer Kelly, whose testimony won't be available until tomorrow, it would also expedite matters because I'm sure it would be a lot quicker to obtain video footage than it would be to have it typed up. My other point would be this. The request for the testimony of Mr. Glass and Kelly both came in the same question. And subsequent to that, we received a note that indicates that there may be factions that are beginning to calcify. We can only speculate as to what the jury is thinking and saying. But I think it's unequivocal that the substance of Mr. Glass's testimony favored the state. It is also unequivocal that Mr. Kelly made some concessions that essentially his analysis had defects and he really couldn't draw the conclusions that he was attempting to draw. So one can surmise that maybe that might be more favorable to the defense. If we have a jury that's now divided into factions and one side is sending for information that might support their argument, another side is sending for information that might support their argument, then I think it would be unfair if we allow one side of that faction to get their ammunition and wait another 24 hours before the other side is able to meet that argument with whatever they're trying to fashion or whatever that testimony they're using as a component of their position. So we think it would be prejudicial because we got both requests in the same questionnaire or same question, asking for the testimony of both people. And until both is available, first of all, we'd like it to be shown back as opposed to be read back. And secondly, we think that it should be done at the same time so that both sides, assuming they're for different sides, are equipped with the ammunition they need when they go back and deliberations continue. But we think it would be extremely prejudicial if Mr. Glass's testimony were to be read today and tell them, wait until tomorrow before we get you kettles.
Thank you, David Spears.
Your Honor, it's entirely speculative. The rules would conform with a readback occurring. The state suggests Your Honor should stick to the rules of criminal procedure on this case.
So objecting to having some type of seeing what the crime and whatever the born crime video is and have that played back to you, correct?
Yes, Your Honor.
Anything else, counsel?
Yeah, well, once we can ascertain that it's complete, then clearly it's the best evidence. There might be rules which do not contemplate the existence of video, but now that we know we have it, the court as the gatekeeper knows that it will not be an inaccurate reflection of what has occurred. As a matter of fact, it will be the best evidence of what occurred. And therefore, to use a procedural deficiency as a basis for objection, I think is an attempt to obfuscate what would be the best evidence and the truth. And I don't think the state took a position with respect to whether or not it should be read at the same time, but we would maintain that it would be prejudicial to Mr. Demons. And I know we're reading tea leaves, but because we don't know what's going on, it's all the more important that we give the jury what they asked for at the same time that they asked for it and not split it up.
Thank you. Well, counsel, respectfully, the court reporter is the person who keeps a record of the proceedings. So if they want to read back, that's what we're going to do. They have to read back. I understand the case was live streamed. That's not in evidence. The court reporter could read it back. That's what the rules provide for. That's what we will do. Regarding Mr. Glass and Mr. Kelly, Mr. Glass's read back, my understanding his testimony is relatively short. It would take the court reporter too long to do that. She's going to read that back now. She's working on Mr. Kelly, and when that's available, she'll read Mr. Kelly as well. You're good. No,
Thanks, sir.
You can bring the jury.
Yes, sir.
Wow. So they want him, so the jury instructions were to, that if they wanted to revisit testimony, that it would be read back to them from court reporter. So he wanted the video to go in, but that wasn't in the jury instructions. And like he said, video is not entered into evidence, so he overruled that objection. And then he also wanted it to be read back to back. He overruled that. He said that they can hear it as it comes available. He feels like I agree with the judge's ruling because that it was in, if that was going to be an objection later, it would have been one of those things that needed to be discussed beforehand. So, I understand the judge's, ruling on that. He said that, you know, the law and crime footage is not entered into evidence. The jury instructions that they agreed on beforehand were that it would be, if they wanted to revisit the testimony, it would be read back to them by court reporter. The other thing was, he feels like the two questions that came in, the two witnesses, even though they were both state witnesses, he feels like the one that Mr. Kelly, Michael Kelly, the one with the accent, who him and, you know, David went back and forth. But that one.
Jury's in the jury room, you wanted to supplement your positions there?
Yes, please. In lieu of them watching the testimony, which we maintain is the best alternative, to allay some of the concerns we have with respect to prejudice, we would ask that an instruction be given to the jury, reminding and admonishing them that a readback cannot reflect the matters of demeanor, tone, or voice in which the testimony was given. So we can ask that the jury be reminded that a readback is not a complete accounting of the testimony because it doesn't account for manner, tone, voice, and the things which they may have observed. So we ask that that instruction be given prior to them getting the readback or after.
See if you heard.
There is a standard jury instruction 4.4 that covers this. That would be the state's position that that's a stream.
Thank you. That's what I typically do, that's me to read back the standard jury instruction.
I do notice that that the headings of each one of these speaks to readback / playback. So I do believe that the rules do contemplate a playback as opposed to a readback. Just to correct the record, because my understanding from the state was that a playback was not called for, but this proposed rule does actually mention playback.
Thank you.
On their mics. You know, look, I agree with the judge's decision because that's the way it goes, but you can't blame him for trying. I mean, it's actually really smart of him to try. He's fighting for his client.
Your Honor, also, this Rule 4.4 does not contemplate the issues that are concerning, particularly with respect to Mr. Glass hiding behind the monitor and behind his hair. We think that it's important that the jury be reminded that tone, manner, and comportment during testimony are also important in their assessment of credibility. So we ask that not just the standard.
Thank you.
Thank you.
Madam State, anything additional?
Yeah.
Two things, Counsel. Number one, my understanding of the readback, playback issue has to do with evidence. That's something that's in evidence that's going to be played back to the jury, not trying to find out something that was live stream, not in evidence to play back to the jury. I think there's a difference. That's the first thing. Second thing, regarding the witness, my recollection was you said he was hiding behind it. My understanding is you asked him, or somebody asked him a question about it, and he said he was blind, and I thought that was the issue, he was blind and was left out. But regardless, I'm sure it's in the transcript. But your objection, I'm just going to read this thing. All right, bring the jury.
Thank you.
Yeah, I mean, look at it like this. Like, I know I see some of y'all getting annoyed with him, and he is very wordy, but he's a really good attorney. And think about it like this. Put yourself in his shoes. He's doing his job. Think about it like this. He knows that the demeanor that he had during that cross-examination of Michael Kelly and how Michael Kelly was such a soft-spoken, sweet kind of guy, and David Howard was very dominating, I guess is the word. Like he gave off that kind of energy. So of course he wants them to see that.
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, his counsel, the assistant attorney. I have a jury inquiry form. It says request of due evidence. It states clarification. Courtney Sutherland should have been in court with Henry. We have decided we do not need to hear this statement from the hospital. Then it goes on, Trayvon Glass, we would like to have his testimony read back. Michael Kelly, we would like to have his testimony read back when available. So what I've done, ladies and gentlemen, I've talked to the court reporter, and she is able to read back the testimony of Mr. Trayvon Glass. At this time, I discussed this with the attorneys, and the court reporter is going to read that back now. As far as Michael Kelly, she's working on getting that done, and as soon as it's ready, we will have it read back to his testimony. So, Madam Court Reporter, can you read back the testimony of Mr. Trayvon Glass, please? Sure.
God, there's so much noise on there.
You need to take the microphone down.
And Mike.
The court, call your next witness, please. Ms. Smith, Trayvon Glass. The court, are you ready, Mr. Glass? The witness, yes, sir. The court, welcome. This is our witness stand over here. Once you come to the witness stand, what I'd like you to do is remain standing and raise your right hand to be sworn. The clerk, do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth? The witness, I do. The clerk, state your full legal name for the record. The witness, Trayvon Glass. The clerk, please spell your first and last name for the court reporter. The witness, Trayvon Glass. The court, please have a seat. Mr. Glass, that microphone in front of you, only just up or down, it doesn't move back and forth. The witness, all right. The court, so if you could scoot up close to the microphone. Ready to proceed, sir? Counsel, you may. Ms. Smith, thank you, Your Honor. Direct examination by Ms. Smith. Question, good morning, Mr. Glass. Answer, good morning. Question, I know that you are quite soft-spoken, so I'm going to need you to speak up a little louder, okay? And remember, you have to make oral responses, okay? Answer, yes. Question, how old are you? Answer, I'm 23. Question, and where are you currently living? What city? Answer, Vero Beach. Question, and have you lived there all your life? Answer, majority of it. Question, okay, you completed high school, or what was the last grade you completed? Answer, 11th. Question, all right, you're not married, correct? Answer, excuse me? Question, you're not married? Answer, no. Question, so I'm going to talk about some prior stuff before we get into why you're here today. Have you previously been convicted of a felony? Yes or no? Answer, yeah. And how many times? Answer, to my best knowledge, once. Question, if I were to show you something, would that refresh your recollection? Answer, yeah. Question, the prior judgment? Ms. Smith, your honor, permission to approach the witness? The court, first show counsel first, please. Ms. Smith, yes. Question, I'm going to ask you to just look at the document. Don't say anything, okay? Have you had an opportunity to review the document? You have to answer. Answer yes. Question, all right. Is your memory refreshed to how many convictions you have? Answer 2, or is that 1? I don't know shit. I see 2 charges. Question, All right, now you currently have some pending charges in Indian River County, correct? Answer, yeah. And those are 2 charges? Answer, yeah. Question, misdemeanor resisting without violence? Answer, yeah. Question, and an obstruction of service or execution of a search warrant? Answer, yeah. Question, are those misdemeanors or felonies? Answer, I'm not sure. Question, okay, do you know what the penalty you are facing on those charges? Answer, no. Question, have you been offered probation in that case? Answer, yeah. And have you been made any promises in exchange for your testimony here today? Answer, no. Question, all right, so let's go back to October 26, 2018. What were you doing like for work? Answer, I wasn't working at all. Question, were you involved in the music business at all? Answer, kind of, sort of. Question, and how so? Answer, making beats. Question, all right, and when you were making beats, were you working with a specific group or music group or people? Answer, one person to be particular, but yeah, it was supposed to be in a group. Question, all right, let's start by saying this. What group was it? Answer, in YNW. Question, all right, and when you said one person specifically, who was that person? Answer, Judy. Question, and can you tell the members of the jury Judy's real name? Answer, Christopher Thomas. Question, and how long had you known Christopher Thomas, who you refer to as Judy? Answer, over a decade. Question, and this is back in October. And did you know somebody by the name of Anthony Williams who went by Sack Chaser? Answer, yeah. Question, and how long have you known Sack Chaser? Answer, a couple of years. Ms. Smith, permission to approach the witness with state 73. The court is in evidence. Ms. Smith, yes. The court, yes, you may proceed. By Ms. Smith. Question, Travion, I'm going to ask you to take a look at state's photograph number 4 in state 73. Do you recognize that person in state's photograph with the label marking 18-3118? Answer, I do. Question, and who is that? Answer, Anthony Williams.
This is who's reading.
Question, so back on October 26, 2018, do you recall being at the New Era studio? Answer, yeah. Question, who were you with? Who were you there with? Answer, a few other people. Question, okay, was Juby and Sack there? Answer, correct. Question, all right, and do you recall around what time you guys got to the studio? Answer, I'm not sure when we arrived. Question, was it light or dark outside? Answer, I believe it was dark, I'm not sure. Question, all right, and what was the intention going to the studio? Answer, I believe we were supposed to have a 12-hour session. Question, all right, and that's a 12-hour recording session, right? Answer, yeah. Question, and who was the artist that was recording that night? Answer, it was everybody. Everybody was an artist in that room. Question, all right, did you guys end up staying for 12 hours? Answer, nah. Question, okay, what changed and why didn't you end up staying? Answer, to the best of my knowledge, people were sleeping, so we ended up going home because you don't sleep in the studio. Question, all right, and part of that is because studio time is paid for. Answer, paid for. Question, okay, you just said it was paid for. What was paid for? Answer, studio time. Question, so you guys had prepaid for 12 hours? Answer, correct. Question, I'll move on. How long? Well, you said that people were sleeping. Who was sleeping? Answer, everybody but me, Anthony, and Christopher. Question, was someone upset that people were sleeping? Answer, I guess you could say that. Question, and who was that person? Answer, Sack. Question, and how did Zach respond? And how did Zach respond? How did Zach respond to people sleeping? Answer, he woke them up and let them know it's time to go. And how did he, question, and how did he do that? Answer, yeah, he went and woke them up, shook them up. Question, okay, so at some point you just mentioned that guys were getting ready to leave the studio. Answer, yeah. Ms. Smith, publishing state 72, publishing image number 1 in state 72. Question, Mr. Glass, can you see that photo on the screen in front of you? Answer, yes. Question, okay, and who is that person? Answer, to the best of my knowledge, Melly. Question, okay, and the person I'm referring to, what is he wearing? Answer, a jacket. Question, all right, do you recognize the person on the other side of the photograph wearing what appears to be a black shirt? Answer, kinda, sorta. Question, if you do? Answer, no, I don't. Question, publishing image number 2. Do you recognize individuals in that photograph? Answer, 2 of 3 of them, yeah. Question, okay, so what you can do is identify them by clothing that they are wearing. Answer, Juvie, black jacket to the left, Sack in the middle, jean jacket, Tay, black jacket. Question, and Sack, is he standing or sitting? Answer, sitting. Question, and Tay, is he standing or sitting? Answer, sitting. Question, and you said Cortland was wearing a black jacket. Is he standing or sitting? Answer, who? Question, how did you refer to him? My apologies. Answer, Tay. Question, no. Answer, Juvie. Question, the person wearing the black jacket, who did you identify that as? Answer, Juvie is wearing a black jacket. Also, it's Tay wearing a black jacket. Question, the person wearing the black jacket who is standing up, do you recognize that individual? Answer, that's Chris. Question, okay, do you recognize the people in photograph image 3? Answer, same one you just showed, same person. Question, and who is that person? Answer, Melly. Question, the 3 images that were just shown from state 72, do you recall when those photographs were taken? Answer, same night. Question, what date would that be? Answer, 10/26. Question, of 2018? Answer, yeah. Question, what location were those photographs taken in? Answer, New Era Promotions at the studio. Question, was that the studio we just discussed that you guys were hanging out at? Answer, yeah. Ms. Smith, I'm now publishing state 7, publishing 10/26/2018, beginning at timestamp 2/17/42. Question. Mr. Glass, do you recognize the 2 individuals on the screen who paused at 2/17/47? Answer, do I recognize the back of their head? Answer, yes. Do you recognize them? Answer, I just see the back of heads. Question, okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52? Answer, still the back of the heads. Question, do you see an individual standing next to a red vehicle? Answer, yes, that's Kobe. Question, you just said that's who? Answer, Kobe. Question, and what is Kobe's real name? Answer, that's what I know him by, Kobe. Question, all right. Would anything refresh your recollection as to his legal name? Answer, I don't know. Question, if I were to show you your prior statement, would that refresh your recollection? Answer, it could. Ms. Smith, permission to approach the witness, the court, you may. Question, Mr. Glass, if you could take a moment and look at this page, read it to yourself, do not read aloud, and look up when you're done. Has your memory been refreshed as to the legal name of Kobe? Answer, yeah. Question, what is Kobe's legal name? Answer, Jacoby Mills. The reporter, I'm sorry. The witness, Jacoby. By Ms. Smith, question, all right, if you can repeat the last name for the court reporter. Answer, Mills. Question, I'm going to continue to publish date 7. There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual? Answer, not really, no. Question, okay, how about the individual that is standing at the gray Jeep? Answer, that's Zach. Question, I'm going to continue to publish. I'm pausing at timestamp 2:18:21. Do you see that individual who's walking away from the Mitsubishi Jeep? Answer, I see him. Yeah. Question, do you recognize him? Answer, that's AD. Question, I'm going to ask you for AD's legal name. Answer, I know his last name is Davis. Question, okay. Would looking at your statement refresh your recollection as to his legal name? Answer, I guess so. I don't know. Ms. Smith, Your Honor, permission to approach the court. Is that the same statement? Ms. Smith, yes, Judge. Approaching the witness. Question by Ms. Smith. Mr. Glass, same procedure. If you could take a look at that and look up. Answer, unintelligible. Question, no, without speaking. Has your memory been refreshed as to AD's legal name? Answer, yes. Question, okay, what is AD's legal name? Answer, Adrian Davis. Question, continuing to publish date 7. Mr. Glass, let me know if you need to rewind the video. Did you have a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts? Answer, that's me. Question, continuing to publish. I'm pausing the video on 2:18:41. Do you see that individual carrying something across his shoulder, wearing what appears to be a blue jacket? Answer, say that again. Question, do you see the person on the video? Answer, I see the back of his head. Question, do you see the back of the head of the person wearing the jean jacket? Correct. Answer, correct. Question, do you see the jacket in state 72, image number 3, the front of the jacket? Answer, yeah. Question, do you see that jacket in state's image 1 of state 72? Answer, I see the same thing y'all see. Question, we spoke about this, Mr. Glass. Answer, I said that. The court, excuse me. Counsel, you asked questions already. By Ms. Smith, question. I'm asking questions, Mr. Glass, and just asking you to respond if you have knowledge. Is this the jacket that was in image number 1 and image number 3, the jacket that Melly was wearing on October 26th of 2018? Answer, to the best of my knowledge. Question, to the best of your knowledge, yes or no? Answer, yes. Ms. Smith, publishing state 7. Question, I'm back to state 7, timestamp 2:18:41. The individual that's on screen wearing the jacket, it appears something across his back. Who is that individual? Mr. Glass, can you respond? Answer, I see the same person as last time. Question, okay, and can you tell us who that same person is? Answer, Melly. Ms. Smith, continuing to publish. The witness, asking questions I don't know the answers to. By Ms. Smith, question. Mr. Glass, you can't speak when there's not a question. Mr. Glass, do you see that individual carrying something in their left hand? I'm asking you if you see them, just if you see them. Answer, yes. Question, do you recognize that person? Answer, of course. Question, and who is that person? Answer, Christopher Thomas. Question, Mr. Glass, can you identify for the record? I know there's a video, but can you identify which vehicle you got into? Answer, the red Mitsubishi. Question, and can you tell us who was in the car with you? Answer, Kobe, Tay, and AD. Question, so AD, Tay, and Kobe. Answer, Is that a yes? Answer, yes. Question, so that is a total of 4 people. Answer, correct. And then the vehicle to the left of the screen, the Jeep, who entered that vehicle to your knowledge? Answer, everybody else that was there. Sat, Melly, Judy, and Cortland. Answer, okay. I'm sorry, question, okay, and by my count, is that also 4 people? Answer, correct. Question, and when those continuing to publish at 2:19:36, I'm gonna stop at 2:19:46. At the time you left the scene in that red Mitsubishi, where were you headed? Answer, supposed to be home. Question, who's home? Answer, I guess Melly's house. Question, and was everybody in that red car headed to Melly's house? Answer, to the best of my knowledge. Question, and what about the Jeep? Where was your understanding that the Jeep was headed, the gray Jeep? Answer, same spot. Question, so both cars left the studio with the intention of heading to what you identified as Melly's house? Answer, correct. Question, can you tell us, I guess, what was the mood or the vibe of the studio while you guys were there? Answer, it was years ago. I can't tell you nothing right now. Question, okay, if you don't recall, that's fine. Was there any physical confrontation that you observed at the studio? Answer, just like a regular day at the studio, smoking and drinking. And you just mentioned smoking. Where are you smoking? Specifically you. Answer, weed. Question, all right. And now the vehicles. We saw that the gray vehicle on the video pulled off first. Can you tell us where you guys, the route you guys took to the best of your knowledge? I can't tell you because I don't know. Do you recall getting on a highway at all? Answer, I recall being in the car while it was driving. I don't know where. I don't know. I don't. Question, were you awake the entire time you were in that vehicle? Answer, I wasn't. Question, okay, do you know at what point you fell asleep? Answer, I don't. Question, all right. And when you left the studio, you were awake. Is that a fair statement? Answer, I was. Question, and at what point do you recall waking up, or what time do you recall the next thing you saw? Answer, once it came to a stop. Question, all right. And where did you come to a stop? Answer, at the house gate. Question, at the house gate for Melly's house? Answer, yeah. Question, when you got to the house gate at Melly's house, who was inside your vehicle, the red Mitsubishi? Answer, same people you've seen get in the car. Question, by your testimony, Kobe, AD, Tay, and yourself? Answer, yes. Question, okay, so still 4 people. Answer, still 4 people. Question, do you recall how you guys entered the gate? Answer, the gate was open for us. Ms. Smith, publishing states 47. Question by Ms. Smith, I'm going to pause it at timestamp 3:49, looks like 58. Do you recognize that red Jeep Mitsubishi? Answer, I do. Question, is that the vehicle that you left the studio in? Answer, yes. Question, is this the guard gate you testified to at Melly's house? Answer, yes. Question, do you see that screenshot at timestamp 3:51:31? Answer, Question, is that a yes? Answer, yes. Question, do you see yourself inside that red Mitsubishi vehicle? Answer, yes. Question, and were you located? Answer, and where are you located? Answer, passenger. Question, do you recall going through the gate, going through the procedure of going through the gate? Answer, yes. Question, so you get through the gate, where do you go next? Answer, to the house. Question, all right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house? Answer, yeah. Question, are there any other cars parked in that driveway when you get to the house? Answer, no. Question, all right. Did you see the gray Jeep that you left the studio with at the house? Answer, no. Question, all right. So what do you do when you get out of the vehicle? Answer, what I remember, I just went upstairs and went to sleep. Question, okay, and you said upstairs, so the house is how many stories? Answer, a couple. Question, okay, so you went upstairs to where specifically to sleep? Answer, to Judy's room. Question, all right, was Judy in his room? Answer, no. Question, do you recall where Melly's room was in the house? Answer, not upstairs. Question, okay, do you recall where it was if it was not upstairs? Answer, I think it was like front first room when you come in the house. Question, was Melly at the house when you got there from what you can recall? Answer, no. Question, did you see Melly at any time in the house? Answer, no. Question, all right, so you go upstairs in Judy's room, and what do you do? Answer, crash. Question, crash meaning, answer, go to sleep. Question, okay, at some point, do you wake up? Answer, yeah. Question, and why? Answer, phone calls, phone calls, phone calls, phone calls. Question, okay, safe to say your phone was getting a lot of phone calls blowing up? Answer, yeah. Question, and at some point you answered the phone, correct? Answer, yeah. Question, okay, what do you do in response to the phone calls? Answer, I answered it when it kept ringing, and yeah. Question, and so what do you do in response to getting that phone call? Answer, I ended up at the hospital. Question, all right, do you recall which hospital that was? Answer, no, I don't. Question, do you recall what city you were in at this point? Answer, I was in Broward. Question, what city, not the county? Answer, Miramar. Question, do you know if you went to Miramar Hospital? Answer, I don't know what hospital it was. Question, so you get to the hospital, what do you find out when you get to the hospital? Answer, that Anthony and Christopher were deceased. Question, okay, and obviously at that, let me not say obviously, but at that point in time, what do you do or how do you react to that news? Answer, grieving. Question, okay, do you stay at the hospital? Answer, not long. Question, where do you go after the hospital? Answer, I ended up somebody's house. Question, all right, do you recall whose house that was? Answer, I don't know whose house it was, but I ended up there. Question, let's start about with the city. Do you recall what city the house was in? Answer, Miramar. Question, do you recall if it was in the same or different area than where Melly's house was? Answer, it looks similar. Question, and just to clarify, was it the same or different house than Melly's house? Answer, different. Question, where did you go when you went to that house? Answer, what do you mean? Question, like where in the house did you go? So you go to the house, where do you go? Answer, nowhere. Inside the house, I was in the back. Question, and would your statement refresh your recollection as to whose house you were at? Answer, maybe. Ms. Smith, Your Honor, please permission to approach. I'm sorry, Ms. Smith, Your Honor, permission to approach. I'm going to show defense counsel the same statement, page 4. Question by Ms. Smith. Same procedure, Mr. Glass, if you could just review page 4. Answer, I don't see nothing about a house here. Question, if you could just read the entire page and when you're done, let me know. Have you finished reading that page? Answer, yes. Has your memory been refreshed as to whose house you were at? Answer, I still don't see nothing about a house here. Okay, I'm going to now show you what's in evidence at state 62. Do you recognize individuals in state 62? Answer, yeah, I do. Question, okay, who are those individuals? Answer, Melly and another dude, Frida. Question, you said Melly and another dude, Frida? Yeah. Do you know Frida's name or any other nicknames? Answer, that's all I know, Frida. Question, Frida. Do you recall ever going to Frida's house? Answer, just that time. Question, just that time being what time? Answer, after I left the hospital. Question, and for the record, what is Frida wearing in the photograph? Answer, a shirt, a white shirt. Question, okay, so after the hospital, you went to Frida's house? Answer, to the best of my knowledge. Question, and what were you doing at the house? Answer, still grieving. Question, who took you to the hospital? Answer, the cameraman. Question, do you recall his name? Answer, Drew. Question, and do you recall who took you from the hospital to Frida's house? Answer, same person. Question, and before you left the hospital, or actually, who went to the hospital with you and Drew? Answer, just Drew. Question, who was at the house, Melly's house, before you left for the hospital? Answer, same people that was there when we got there. Question, okay, same people being the 4 people that entered the Mitsubishi? Answer, yes. Question, so you're at Frida's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were? Answer, Juby's room. Question, no, not Melly's house, Frida's house. Where were you at Frida's house? Answer, outside. Question, okay, and who was at Frida's house when you first got there? Answer, everybody that was in the house. Question, because I don't know who everybody was or is, can you please specify? Answer, Kobe, Melly, more people I don't know. Question, okay. Was that the first time you saw Melly after you guys left the studio? Answer, yeah. Question, was Melly wearing the same clothes or different clothes than when you saw him at the studio? Answer, nah, he wasn't. Question, nah, he wasn't. You got to specify. Answer, he wasn't wearing the same clothes. Answer, okay. Do you recall what he was wearing? Answer, just had on some shorts. Question, and how long do you stay at Frida Wang's house? Answer, I don't know. Question, okay. Minutes, hours, days? Answer, could be minutes, could be hours. Question, so not days. Answer, not even a day. Question, so when you got to Frida's house, was it light or dark outside? Answer, light. Question, and you previously said yourself and Melly and someone else was at Frida's house. Was Frida there as well? Answer, I think I did see him, I don't remember. Question, okay, what happens while you're there? Like you're there, you're outside, what happens? Answer, I'm grieving. Question, and you're grieving. Are you grieving alone? Answer, yes. Are you at the house at any point in time? Do more people come to the house or do people leave the house? Answer, if they did come, I don't know. I was in the back there grieving. Question, at any point in time, did Melly leave Frida's house? Answer, it came to a point where I was there by myself. Question, all right, so you were there by yourself. So the people that you previously said were there were no longer there, correct? Answer, correct. Question, and so do you know where they went during that time? Answer, I don't. Question, and we're still talking about October 26th of 2018, correct? Answer, yes. Question, and this would be shortly after the hospital? Answer, yes. Question, at some point does Melly come back to Frida's house? Answer, around that time I'm still grieving, getting a little, I don't know, yeah, I guess. Question, I guess Melly comes back? Answer, yes, I guess they did come back. I don't know, I'm not sure. Question, at some point does Melly leave again a second time? Answer, I don't remember anything from after that. For me grieving, that was the last thing I remember, was me grieving, and I end up in Gifford. Question, so before you end up in Griffin, sick, if I were to show you your statement, would that refresh your recollection as to Melly leaving and coming back the second time? Answer, I suppose so. Ms. Smith, permission to show him statement again? The court, yes, counsel. Question by Ms. Smith. Mr. Glass, I'm going to give you page 5 and page 6. If you could take a look, you can start in the middle and review those pages and look up when you're done. Are you done? Answer, uh-huh. Is that a yes? Answer, yes. Question, did that refresh your recollection? Answer, somewhat. Question, okay, so tell us what you somewhat remember. Answer, I just did. Question, if you recall, you said you weren't sure, you went to Gifford. And then I asked you if your statement would refresh your recollection. Does your statement refresh your recollection as to whether Melly left again? Answer, I'm not sure, I was grieving. I'm not sure what nobody did, I was grieving. Question, you mentioned, let's see. I pointed out to you someone was, the person that was wearing the jacket that you identified as Melly was carrying something across his side or his back on the video. Do you recall seeing that? Answer, I guess. Question, do you recall what that's referred to? Answer, a satchel. Did you see that question? Did you see that satchel again after you left the studio? Answer, no. Question, do you know what was in the satchel? Answer, I don't. Question, okay. Do you recall seeing anyone else with a satchel that night at the studio? Answer, that was 5 years ago. I don't recall. Question, is there anything that can refresh your recollection as to whether or not anybody else was wearing a satchel? Answer, I suppose so. Question, if I were to show you that video again, would that refresh your recollection? Answer, I suppose so. Publishing state 7. Question by Ms. Smith. I'm going to start publishing part 7, state 7 at 2:19:01. I'm going to pause at 2:19:13. Does the video refresh your recollection as to anyone else that was carrying a satchel? Answer, yes. Question, who, if anyone, was carrying a satchel? Answer, I see Chris with one. Question, and that's Christopher Thomas? Answer, yes. Question, did you ever have any business relationship with the person referred to as Track? Answer, no. Question, okay, do you know who Track is? Answer, not really. Question, not really, or answer, I don't know who he is at all. Question, do you know of him? Answer, yeah. Question, did you see Track on October 26, 2018 at any point? Answer, no. Question, do you recall giving a statement, specifically the statement that you previously provided, that I previously provided you with you here today to the detective in this case? Answer, uh-huh. Question, you have to answer out loud. Answer, yes. Question, that was a statement that you gave to Detective Moretti and another detective, I believe from Indian River, is that correct? Answer, it could be. Question, would showing you that statement refresh your recollection as to anything regarding your interactions with Track on October 26, 2018? Answer, I don't know. I don't know Track. Question, no. My question was, would showing you the statement refresh your recollection as to any time you saw Track on October 26 of 2018? Answer, no. Question, one moment. You said you ended up back in Gifford at some point in time on October 26 of 2018. Answer, yes. Question, and do you recall where Melly was at the time you went to Gifford? Answer, I don't remember. Question, at some point at Frito's house, do you guys all leave, meaning you yourself, everybody that you previously identified that was there? Answer, I don't recall. Question, you don't recall leaving? Answer, I don't recall leaving with anyone. I don't know where I left. I don't know how I left. Question, Okay, just to clarify my question, so you mentioned you left. When you left with Gifford, was anyone else at Frito's house? Answer, I don't know. Question, do you recall Melly making these statements in your presence while you were at Frito's house? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to anything Melly told you while you were there? Answer, I don't recall. Question, so you remember them leaving the house at least once, correct? Answer, yeah. Yes. Answer, yes. Question, all right. Now, when they came back, do you recall any conversations that Melly had in your presence that first time after the first time? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to those statements? Answer, no, wouldn't. Question, all right. Do you have a Facebook page back in October 26th of 2018? Answer, I believe so. Ms. Smith, I'm approaching counsel with what's been marked as state's quadruple I, was previously shown permission to approach the witness. The court, you may. Question by Ms. Smith, Mr. Glass, do you recognize these two pages that I'm showing to you? Answer, I guess so. Question, and this is a Facebook, do these statements reflect a Facebook conversation? Answer, they do. Question, is this a fair and accurate representation of the conversation that you had on Facebook? Answer, it is. The clerk states quadruple I will be marked as states 83. Permission, Ms. Smith, permission to publish? The court, you may. Question by Ms. Smith. Mr. Glass, can you see that document in front of you? Answer, yes. Question, all right, where it says author, can you read that for the members of the jury? Answer, you want me to read it?
Excuse me one second. Danielle and I keep the message of one of your members needs a restroom break, so we'll take a short recess. Do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in presence. We'll be back in finish reading shortly, as soon as we're done with the restroom break, all right? Thank you. Thank you. Let the record reflect the jury stepped out. Mr. Devens, you need a restroom break?
Yes, sir.
Can you raise that to Mr. Devens?
Yes, sir.
Thank you. We're in recess. Hopefully, for guys.
So interesting. Let's continue with the rest of this hearing while they're on break.
Would have some relevant information on that particular topic. So that's why I'd like to call him as a witness.
Okay, well, first of all, I'll indicate.
Answer, yes.
The expert witness in this case. So if somebody wanted a Daubert hearing and they didn't get one,
I wish
it was
that
because they didn't ask for one.
I was just told, Your Honor, about Dr. Engine.
Pardon?
I was just told about Dr. Engine, like maybe a couple
audio on
days
this
ago.
one is so bad.
The second thing is that the question, I think, is really, it's straightforward. If it isn't permissible to offer an opinion that as a result of voluntarily ingested drugs, someone wasn't able to form intent, that's not the issue, because I think the attorneys and have rightly analyzed the current state of the law in this
I'll
case.
turn your
That's not a
question here into a poll.
voluntary intoxication is not a defense that's permissible to be put on. If that's not the issue,
This is Jaded Wonder.
then what is the issue that's being presented? And I think the concern that the state has is the testimony that was provided last time relates to the issue that isn't permissible as a defense, that is voluntary intoxication. Therefore, if Dr. O'Donnell is going to testify as to something else, something that is permissible, what is it? And is he qualified to give that opinion? So I guess that's the situation that the court is left with. But I'm also cognizant of the fact that Daubert hearings occur in very different fashions. Sometimes you bring the doctor in and testify. Sometimes the court takes a look at what they intend to testify to and what their qualifications are. So what I'm going to do is I'm not going to rule on that issue just now. We'll take it up again. But I'm concerned, quite frankly, that if what the testimony is going to be, assuming we get to the responsibility phase, is that these drugs were ingested and a result of that decision to voluntarily ingest drugs, there's an issue regarding responsibility. I'm concerned that that's not going to be relevant, and that if I afford the opportunity for the doctor to testify, as soon as he gets done providing his qualifications and the questions start, I'm going to get relevancy objections, and that those may very well have to be sustained, other than, come on, just let us present this, doctor. So I think I'm going to ask you, Mr. Freilich, you need to reformulate what either. I want to be clear to you, Mr. Freilich. I'm not going to deny Dr. O'Donnell's ability to testify based upon.
Brianne Malcolm, I want to pause it because we can barely hear him anyway. Brianne Malcolm, happy anniversary. You have been a member with us for 2 months today. Happy anniversary.
Timing issue. Okay, so we had the hearing on June 13. That's not the issue. I related that simply because I want everybody to know that I want this to move along, and I want to avoid inconveniencing not only the parties but the jury. And if there needs to be a Daubert hearing, I've got to figure out when I'm going to get it done before the jury trial starts. And I'm going to start the jury trial on Monday morning. So I simply related that for that issue. So moving on from that, I'm not going to use that as some reason to deny the testimony. If the testimony doesn't come in, it'll be for some other reason. And the reason that I'm concerned about, Mr. Freilich, that you need to address, and I think perhaps discuss with Mr. Saunders, is what is this doctor going to testify to that's actually relevant and that's permissible under Wisconsin law? Because again, I'm concerned that if we just leave the record the way it is and say he's going to come in and repeat what he testified to on June 13, that I may likely conclude that that doesn't come in. But I'm not making that decision right now. I'm letting everybody digest those comments for a little bit, and we'll take it up at a different time.
Thank you.
Anything else before we break? Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor, thank you.
I'd like the attorneys there a little bit before 1. I intend to get the jury upstairs as close to 1 as I can. If you could be there about 10 minutes to 1 so we can address any remaining issues. I will take up, I will review that issue that Mr. Lizet raised, but it sounds like we have a stipulation that each side will get 1 additional strike due to the fact that we're sitting 4 alternates. That means everybody gets 7 strikes. That's your understanding, Mr. Saunders?
It is.
Mr. Freilich?
Yes, Your Honor. Thank you.
Good. And with that, we are concluded for now. We'll see you at 1 o'clock.
Okay, thank you.
It was a lot easier to hear earlier, and then he moved his microphone down. And the last few minutes, I haven't been able to hear hardly anything he said.
Unless Gerlamy comes back in.
Just make sure she's presentable before we come on. Yes. Okay. Then she's gonna come off.
Yep, they're starting jury selection. They're going to do 4 alternates, and trial starts Monday. This is our next one.
I got a sweater.
Poll result right now is 72% say this has been impactful to the jury.
But there is some makeup. There's a dress that you can inside and out.
Yes.
So do you guys It's all the big guys. So, and the shoes are in there too. I'll explain it to you. Just really tell. So if you wanted to see her, you probably don't. It's good. You can pick up the tree lines. You actually read verbatim what the state law. So it's not something I just kind of wing it. It's actually verbatim. And then I have you sign actually that you understand. Okay. Then you can pick up the dress you want. There's one that's like a lighter print and that's a darker print. But there's one that you can flip it inside now. So it looks different. We're going to go skip the entire contents of the back. You can do the correctional side. You can go through with you. Go through it and see which one you want. Yeah. Miss Keycore is a good person. She'll help. Okay. Sure. She's a good too. Miss Keycore is Sarah Keycore. Okay. She'll want you to look good for this too. Okay. All right. Sounds good. Thanks. All right. Okay. We're done. Thanks. Thank you. We'll see you about 12:30. Okay. Sorry.
You just told her that whoever she's going with is a good person and she's going to help her. So this one, she originally entered a plea of not guilty and they changed that to not guilty by reason of insanity, which is why this was going to be such a big deal because all of the, because we know she did it, but the question isn't whether or not she did it.
Fargo. Question, what does it say before Fargo? Answer, Fetty Fargo. Question, do you see where it says Fetty Fargo? Answer, I see it. Question, okay. And who's Fetty Fargo? Answer, it was me. Question, who was that? So was that was that how you identified yourself on Facebook? Answer, kinda, sorta. Question, who were you having these conversations with? Answer, right now it looks like I'm talking to myself, like I was texting. I don't know who I sent it to. Question, do you see where it says participants? Answer, okay, so texting Melly. Question, that was page 1. I'm going to now publish to page 2. I'll publish it in part since it's a little small. Can you see that in front of you? Answer, yes. Question. I'm going to scroll up. What was the purpose of you having this conversation with Melly? Janelle Demons. Answer, I don't know. Just everything was questioned. Question, when you got to Gifford, were you looking for answers? Answer, not just me. Question, were people kind of pressing you for answers? Answer, correct. Question, and did they have any impact whether or not you reached out to Melly? Answer, I don't know what you mean by that. Question, so again, you said that people were looking for answers. So did you reach out to Melly looking for answers? Answer, I did. Question, is that the gist of that conversation on Facebook? Answer, is that just? Question, meaning the gist of the conversation was that the purpose behind the conversation and the general conversation that you had with him? Answer, yes. Question, do you know who Jamie King is? Answer, I don't know who she is. I know of her. Question, do you know her relationship? Answer, his mom. Question, do you know the relationship between Jamie King and Anthony Williams? Answer, I don't. Question, if I were to show you a copy of your statement, would that refresh your recollection? Answer, nope. Question. Sorry, Ms. Smith, and 1 moment to confer. Nothing further at this time. The court, counsel, thank you. Any cross-examination of this witness? Mr. Howard, yes, sir. Good morning, ladies and gentlemen. The jurors, good morning. Cross-examination by Mr. Howard. Question. Good morning, Mr. Glass. Mr. Howard, Your Honor, do you mind if we could move the monitor from in front of the witness's face? The witness, I do, I mind. Mr. Howard, okay. Would you mind, Your Honor? The court, I don't mind. Is there a specific issue that you have, Mr. Glass? The witness, I do. Ms. Smith, Judge, can we approach sidebar? This is direct continued cross-examination by Mr. Howard. Good morning, Mr. Glass. Good morning, sir. Answer. No verbal response. Question. There was no response to this. Answer, no. Question. To your text on the first page. Answer, no. Question. On the second page, the state was discussing that essentially you were inquiring of Mr. Melly what had gone on because you were trying to get information. Answer. Yeah. Question. And you see a conversation here where you get a response. I want to direct your attention to. Answer. I see it. Question. That statement. It says, I showed them niggas more love than they parents, right? Do you see that? Answer. I do see it, bro. Question. Thank you. And the next statement by the next message in sequence is again from Melly. It says, TF. What does that mean? Answer. You tell me. Question. Okay. What does that mean? Answer. I don't know. Question. Okay. So you were having a conversation and you didn't understand the response? Answer. I don't know what TF means. Question. So you didn't understand that response, correct? Answer. I just said it. Question. Okay. Then there's another one that says, men, tell them fuck that if they think I did some shit like that. We can go to war. Nigga, you know I would never do nothing like that. Do you see that? Answer. Yes, I see it. Question. Okay, so state had mentioned that you got arrested recently and charged criminally, correct? Answer. Correct. Question. And on May 30th, not too long ago of this year. Answer. Yeah. Question. And one of the charges that was made against you was obstruction of the service of the execution of a search warrant. You're aware of that? Answer. I am now. Question. Pardon me? Answer. I am now. Question. So you got charged and you had no idea what you were charged with? Answer. Correct. And you are now on pretrial release? Answer. I bonded out, sir. Question. Okay. And while you're out on bond, you are of the opinion that if you don't come here, answer, I'll be in jail. That's the only reason. The court, excuse me, what happens is when they make objections, you wait before you answer. Objection overruled. The witness. Got you. Hold on just 1 second. I'm gonna reread that portion. Okay, and while you were out on bond, you are of the opinion that if you don't come here, I'll be in jail. Ms. Smith, objection, Your Honor, relevance. The witness, that's the only reason. The court, excuse me. What happens is when they make objections, just wait before you answer. Objection noted, it's overruled, proceed. The witness, got you. By Mr. Howard, question. You're of the impression if you don't come here and sit in the chair and testify, you're gonna go to jail. Answer, correct. Question. Okay, there are several instances which Ms. Smith, prosecutor, that questioned you, showed you a statement that you previously gave. Remember that? Answer, yes. And you told us you remember seeing me in the deposition not too long ago. Answer, I said what? Question, you remember seeing me last week on Friday? Answer, yeah, I remember. Question, and you recall at the time that your statement to the detective was a few days after the incident? Answer, you say, do I recall? Question, that's what your recollection was at the time? Answer, yes. Question, a couple of days after. Answer, a couple days after. Question, and now after seeing the statement, you realize that it was 4 months later, right? Answer, you say what? You said what? Question, the statement you gave to police. Answer, you're telling me it was 4 months or asking me? Question, pardon me? Answer, are you telling me or asking me? Question, I'm asking you. Answer, that don't make sense. If you asking me, I told you it was there. It was 3 to 4 days after they died. Why are you asking me if it was 4 months if I just told you? Question, okay. So in the statement that you gave to police back then, you claimed that you had gone into the red vehicle in the rear seat, right? Answer, that was 5 years ago. To the best of my knowledge, that's what I said. Question, you're saying the statement was a few days after, right? Answer, what did, question, the statement that you gave to the police was a few days after the incident? Answer, yes. Question, and you said then that you had gone into the rear of the red vehicle? Answer, to the best of my knowledge, yes. Question, and then you watched this trial unfold on TV over the last couple of weeks, right? Answer, no. Question, you didn't watch any of this trial? Answer, I watched it, but I didn't watch it unfold or whatever you're trying to say. Question, okay. You watched this on TV, this trial? Answer, on the phone. Question, and you saw a video of yourself get into the red vehicle, right? Answer, correct. Question, and you learned that the statement that you gave a few days ago, a few days after the incident was gone. Let me reread that question. And you learned that the statement that you gave a few days after the incident was wrong. Answer, because I said I was in the back and I was in the front. Question, yes, exactly that. Answer, that piece? Question, yes, that piece. Answer, okay, yeah. Question, you forgot where you sat in the vehicle a few days after? You can answer. Answer, answer what? Question, that question, is that correct, sir? Answer, did I forget? Question, did you forget? Answer, I could have made a mistake and said I was in the back and remembered that I was in the front. Question, so when you told the law enforcement officers that you had gone into the back of the vehicle a few days after the incident? Answer, that's what I thought to the best of my knowledge. Question, that's what you thought? Okay. And when you got to Melly's house that morning, you had a key? Answer, did you have a key? Question, no, I didn't. Did you? Answer, no, I didn't. Question, who had a key? Answer, I don't know. Question, do you know of anybody having a key to Melly's house? Answer, I don't know. Question, okay, but you did gain entrance to the house that morning after you left the studio? Answer, yeah. Question, and then you said you just went and crashed and went to sleep in Judy's room, right? Answer, factual. And you question, and you were awakened by your friend Drew? Answer, I did not say that. Question, were you awakened by your friend Drew? Answer, I said I was awakened by phone calls. Question, did you ever make a statement differently where you claimed that you were awakened by Drew? Do you understand the question, sir? Answer, I don't even remember getting asked a question. The court, all right, restate your question. Question, did you ever make a statement to the police? Answer, I don't recall. Question, okay, do you recall now being asked this question and giving this answer? Question by the detective. Then, and so when you first saw Drew, when did you see him? Where did you see him at? Your house or Frida's house? Answer, at the house in Miramar, at Melly's house, okay? He woke me up. It was like, come to the hospital. You said that? Answer, I don't recall. Question, don't recall? All right. When we spoke to you last week, you said you were awakened by phone calls from Christopher Thomas's mom, right? Answer, plenty of phone calls, different people. Question, pardon me? Answer, different people. Question, different people. And the one that you answered was Ricky. So you were awakened by a phone call from Ricky. Answer, to the best of my knowledge. Question, so as you recall it today, Ricky is the one that woke you up with phone calls and not Drew that woke you up in person. Answer, correct. Question, okay, so you smoke a lot of marijuana, right? Answer, possibly. Question, you smoke it anytime you get a chance, I think is how you phrased it. Answer, it's your answer, yeah. Question, that was your answer. Answer, I smoke when I smoke. Question, you smoke when you smoke? Answer, yeah. Question, and when's that? Answer, when I smoke. Question, and when would that be? Answer, when I smoke. Question, how many times a day? Answer, twice, 3 times maybe. Question, and on the night in question, before you got to the studio, on the day in question, you had smoked at least 2 joints, right? Answer, that's your guess. Question, that's what you said, right? Answer, I don't recall. Question, okay, and when you got to the studio, you were smoking, correct? Answer, possibly. Question, were you or weren't you? Answer, that was 5 years ago. Question, you forgot? Answer, I don't recall. Question, and you were drinking Hennessy, I believe, or do you not recall that either? Answer, it's possible. Question, possible, but you don't recall. Answer, I don't. Question, okay, so you don't recall much from that night then, do you? Right? Fair? Answer, right. Question, and when you got in the red vehicle and left, you went to sleep in the vehicle when you left the studio, right? Answer, yeah. Question, and you didn't wake up until you got to the guard gate? Answer, I woke up when we came to a stop. Question, you did not wake up until you got to the guard gate. Am I right or wrong? Answer, I woke up when we came to a stop. It was at the guard gate, yes. Question, have you ever seen track with a gun? Answer, it's possible. Yes, maybe so. Question, okay, so you don't know of any friction between Melly and Anthony Davis at any time? Anthony Williams at any time? Answer, not that I know of. Question, and you don't know of any friction between Melly and Christopher Thomas at any time? Answer, not that I know of. Question, you didn't see any friction at the studio that night of any kind, did you? Answer, I didn't. Question, you did? Answer, I didn't. Question, with respect to your daily marijuana regimen, did you smoke before you came here today? Answer, I did not. Okay, I have nothing further, Judge, thank you. The witness, I should have. The court, counsel, is there any redirect, Ms. Smith? Briefly, your judge. Briefly, Your Honor. Redirect examination by Ms. Smith. Question, Mr. Glass, did you live in Broward County back in October of 2018? Answer, I did not live here. Question, okay, when did you come in relation to this incident in Broward County? Answer, I was picked up probably, I don't know, I was picked up on the weekend or something like that. Question, so how would you, I guess, date how long you were here prior to the incident, time frame? Answer, 3 days, 2 days. Question, okay, so you were not a full-time resident of Melly's residence? Answer, I was not. Ms. Smith, nothing further. This witness excused? Yes, Your Honor. You may step down.
That concludes the readback of the witness Glass's testimony, so you may now retire and continue with your deliberations. Thank you, ladies and gentlemen. Thank you. Let the record reflect the jury stepped out. Counsel remain on defense. Counsel, I have another question that the jury posed when they came in to read back, and the question reads, what is the conversion to 1 meter equals how many feet?
Rely upon the testimony. Rely upon the testimony.
Everybody agrees?
Yes, sir.
Can I do that just in writing here? Is that all right with everybody?
That's fine.
What'd they just say?
I'm sorry, Your Honor, I think you should say you must rely upon the testimony.
That's what I started to write.
I'm sorry.
Must
I'm sorry, what did you just say?
so bad.
I'll say it. You must rely upon the testimony. Anything else you want to say? State, all right?
That's fine, right?
There are foods here, so we're going to utilize this time for lunch. You hear that?
Lunch.
Lunch.
When should we be back?
You tell me, I mean, where are you going? You buying?
Yes.
The 30-minute window thing is out the window.
No, I mean, give 30 minutes, that's fine. Just be available.
Yes, sir. You have our numbers.
All right, is that good with you, Madam City?
Yes, sir.
All right, so we need you to avoid it. All right, thank you.
Thank you, sir.
For recess.
Okay, hold on. I missed it because I missed it. They're sending the jury to lunch, right? We're sending everybody to lunch. But what did they say that to tell the jury to rely on testimony for which part? For what? I have to go back.
Writing here is the doubt, Counsel remain on defense. Counsel, I have another question that the jury posed when they came in to read back, and the question reads, what is the conversion to 1 meter equals how many feet?
They asked, what is the conversion to or meter is approximately how many feet? Is that what they said? There's so much white noise on their microphone.
Rely upon the testimony. Rely upon the testimony.
Everybody agrees?
Yes, sir.
Can I do that just in writing here? Is that all right with everybody?
That's fine.
So they're going to have them rely on testimony for that part. There is, like, the audio in there is never great, but it's like, feels like it's like worse today. So we have a couple things. I have while they're at lunch, they're not going to be, we'll keep it live just in case anything else happens, but yeah, that's what I was thinking. If they got back, if they got what they wanted or needed from that reading. So let's go back for a second to, because I didn't want to talk over anything, but let's hash some of this out while we got a minute. The attorney, when he was, we started to talk about it, but then they started talking in the courtroom. I forgot I had the eyebrows on, and because I don't really look at myself during the camera stuff, whatever but I see it over there, and I just looked over and I was like, "What is on my face?" But it's the eyebrows. So we're right now we're at 5 hours, 2 minutes, 37, 38, 39 seconds. So it's going right now. And we'll keep an eye on it, but let's talk about a few things while they're doing all of this. So the attorney, David Howard, first of all, he wasn't there earlier, but he is now. And you can see that, the difference that he makes when he is there, with him wanting to, those were a couple of big things with him, wanting to have them read back, or not read back, but rather watch the testimony. We talked about that one. But the other thing was not having them back to back. So his view was that the testimony from Travion Glass, the one we just heard, is more beneficial to the state. He says the testimony that from Michael Kelly, where you remember how that cross-examination got spicy, and he told him something about how it's possible that he cheated on his bar exam or whatever. Like they got, that one got spicy. So that was also one of the testimonies, though, that was, there were multiple things that he went over, that Michael Kelly went over. He went over like the, how they collected evidence and took pictures and got the, clothes from Portland and stuff like that. They went over that, or he went over that. But the only thing that they really focused on in the cross-examination was the trajectory stuff. So we know that trajectory stuff, and I said this when they did it originally, like it gives a vague, you can say, okay, it went in this way and it came from back here, between here and here on the glass, whatever. But it wasn't, to say, we definitely know that the shooter was exactly this height and stood from right here. No, you can't know all that. Like there are variables, but it was never, in my opinion, a testimony that was intended to be like, this is, busted. We got him. Here it is. So I think that the way that, and they knew that, I mean, that's why they had the second, that's why they had it done the second time, and they had it done by somebody who is, Sergeant Williams, who was much more intense with it. It wasn't a part of what he did. It was exactly what he did, the whole thing, and, and put much more effort into the crime scene, recreation and all that. So it made it much more scientific. That this is the, the one where they took everything apart, did, he used all of his math, and he's up there with his notepad, having to do math on the stand and all that. Like this, we know that the testimony from Michael Kelly of this kind of stuff wasn't a huge part of what the evidence was, I guess I should say. It's kind of like if somebody's, if he came in and said, yeah, here's an estimate. Well, then we have like the guy coming later who's like, okay, he gave you, an estimate. Like he gave you like the trailer to the movie, and I'm going to give you the whole movie. But David Howard, when he was doing the cross-examination, that was the main thing he focused on, because he knew it wasn't exact, and he knew it was, there were so many variables. So that's the thing he focused on, because if you focus on that not being so, accurate or helpful or whatever, and it having so many variables, then that's something that the jury will remember. So David Howard wants them to not only to see the video, because I think that he doesn't want just the information read back to them. He does want them to see him commanding that cross-examination, and he wants to see Travion, he wants them to see Travion hiding behind the monitor and stuff like that. So it makes sense for him to do that. He's fighting for his client. And then he said that because he feels like Michael Kelly's testimony was more beneficial to defense and Travion's was more beneficial to the state, he didn't want them to be split, because he said he doesn't want the jury to get the testimony and the answers they need from something that was more beneficial to the state, and then have them go with that ammunition, is what he called it, back to the deliberations and make up their mind before they get to hear what he feels like was more beneficial to the defense. So he wanted them to not be able to get the answer or the testimony from Travion Glass until the transcripts were ready for Michael Kelly, which was interesting, which was denied, obviously, because we just heard Travion's. But it was, and he said it would be prejudicial to give them these answers now, but make them wait for the other testimony. So I thought that was really interesting. Also, hearing, the last witness that we heard from, of course, was AD, and his testimony was completely opposite of Travion Glass's. So I'm sure that, my guess, I'm not sure, my guess would be that maybe they wanted to compare, because the one from AD is going to be more fresh in their mind, of course, and the one from Travion, they may have forgotten parts that maybe they were wanting to kind of compare and see what differences there were, and which of the stories made sense. If they are looking at it to find inconsistencies in one story or the other or something like that, that could be maybe why they're looking at it, to see which one makes sense. Let's see. They've been deliberating for just over 5 hours. Just me asked how many hours they've been deliberating. Just over 5 hours. Okay, so hearing things. Yeah, AD's testimony was the opposite of everything, literally. Like, we've had all these weeks of trial, then AD came and said, none of that's right. Let's see. Okay, so what out of this did y'all get from hearing her read it back? Was there anything that stood out to any of y'all about things that you heard this time, or things that stood out to you this time, or things that were different that you noticed, or anything like that? What stood out about all of this? Didn't Davis lie about the key? Yeah, let's look at all that. Let's just take a look, shall we? Let's see. Keep that one down there. Oh. All righty. Oh, Stu. Look, I'm seeing him already mad. Hey, Stu. I hope you're calmer today. Stu. So misunderstood. All right. So this was the text saying, tell AD to give you a key. Here, we can watch this part while we're waiting.
From Anthony Williams, October 3rd. I would have told AD to leave his key.
He would have told AD to leave his key, as in he has a key, as in he's a liar. Is basically what he's saying. Oops.
This is all in the messages that are in evidence. So that is on page 248 of the conversations between Mr. Williams and Mr. Demons. October 3rd, 2018. Tell AD to give you the key. Adrian Davis had a key. There's no question based on these messages. If you're going to make the argument, know the evidence. Because that is clearly contrary to all of the evidence on that. So that's that community phone everybody used on that. I agree that the 9807 phone is accurate because it doesn't have any emotions, feelings, can't be paid off. It can't be in any way, shape, or form changed. It is.
So that's how we know that it was a lie. The Underdog 330 says, so someone can't take keys back at some point. Yes, they can, but that's not the point of any of this. He said that nobody had keys to the house other than Melly and Bortland. He didn't say, I don't have a key anymore. He didn't say that, we had keys and it was took back. None of that. He presented this whole thing as the only people who could get into the house were Melly and Bortland. And that's not true. So it was just one more lie. I saw a lot of y'all saying this, that it really infuriated Ellis cases. It really infuriated me how she kept pronouncing Demons wrong on purpose in her redirect. A lot of y'all think that she was doing it on purpose. I don't. I honestly believe that because I even saw her correcting witnesses during it, but she didn't do it every time, but she did sometimes. And I've done it multiple. I almost did it now. I've done it so many times on here. They've said it's pronounced demons like lemons. I get it. But the majority of the time that I'm going over these hours and hours of papers and research and all of this stuff, I'm not hearing the name. I'm seeing the name. And I've seen those letters together in that way and pronounced it as demons for 40 years of my life. So, and when I'm reading it, I'm not pronouncing it. Gosh, I can't even speak today. I'm not like saying it in my head as one thing or the other. I'm seeing it. I mean, this is the way I've said it for 40 years. So when I've been in stream multiple times during this, I've said it wrong over and over. And I don't say it wrong every time, but I've said it wrong over and over. But I think that when you're just listening to it, you pick up on her saying it wrong. I think that if in my position, having spent, I spend almost twice as much time on my research stuff as I do actually listening to this stuff. So it takes so I get it, because I'm not just focusing on it being said. I'm reading it over and over and over on all these different things, not reading it like, oh, I need to say demons. I'm reading it as what I've known it for 40 years. So I feel like I've done it so many times too that I don't think it was on purpose. Because I've done it. I say it wrong in stream all the time. But see, that's exactly, which is funny how people see things so differently. Frankie's World says she corrected witnesses multiple times, so it did come across as purposeful. See, that's exactly why I think it wasn't purposeful, because she's corrected other people on it. When she hears it, she corrects other people, but she has slipped up and said it because I think when she's so focused on what she's saying and getting her point across, she's not thinking, I have to pronounce this differently. So we can all agree and still love each other. Because I've done it so many times here, I don't think it was on purpose. I really don't. No, she's not reading it, but I'm not reading it when I'm saying it either. But because I've read it so many times, because keep in mind, when I'm reading it, I'm not making the conscious effort to say, as I'm sitting here going over all these court papers and all of this, making all my charts and doing all these things and seeing the name seeing the name Demons over and over and over. When I'm seeing it on paper, it is registering in my head as demons because that is how I've known it for 40 years. You know what I mean? So it is being burned into my head, seeing this word that I've known for 40 years of my life over and over and over. It's automatic. So it takes a conscious effort for me to say demons, because in all of the hours that I spend going over everything, my brain is reading it the way I've always known it. So it takes a actual effort for me to say it differently. And especially when I'm in the moment and talking about stuff, or like when I've been going over charts and stuff. I mean, I've said it wrong so many times. And it's because when I'm focused on the point I'm trying to get across, I'm not thinking, hey, change up this word in my head. You know what I mean? So everybody thinks different about it. I 100% don't think it was on purpose at all. Because, I mean, it's a name. It's not something that, it's not like the jury's going to be like, ooh, his name. Like, I think that but that's just my opinion, only because I've done it so much. First time I heard his name was today. When I read it, I thought it was pronounced even. Yeah, me too. I've said it over and over. Why has the defense not been well, they've been calling him Melly. I have rarely heard them refer to him as Mr. As Demons. They've been calling him Melly for the most part, from everything I've heard. I have to do the lemons and demons 100 times in order to say it right. Yeah, me too. I've said demons because that's how I've always known it. I've said demons after they explained the lemons thing. I've said demons. I've said all these different things because it's when you know something one way for 40 years. But she has probably spent hundreds of hours on this case preparing for it. That's exactly why I think it's not on purpose. Because she hasn't spent all this time preparing for it, reading all of these papers out loud and practicing how to say his name. She's seeing this word that she's always known as this way over and over and over for hundreds of hours. Let's see. Wendy says the book isn't titled Angels and Demons. Y'all need to quit acting like our brains don't have muscle memory and then we automatically turn demons into demons. That's funny. Angels and demons. Danita says, I mess up stuff like that all the time. It's because of my ADD brain. Yeah, that might be too, because I have ADD too, so maybe that's part of it too. Let's see. Stu did twice. Oh, he did, didn't he? He did say, and then he started early on he started correcting them on it every time. Well, not every time. But when people would say it wrong, he would object. Or about halfway through, maybe. See, I think that Stu getting up there and saying this poor kid was way more prejudicial than, or like manipulative to the jury than if she, like, let's say she had been saying it on purpose, which again, we could disagree. I don't think she was. But if she was, I still think that, I mean, mispronouncing his last name is one thing. Saying this poor kid, this poor kid just had to pee. Like, that's way more manipulative to me. Let's see. Yeah, I heard, Raven said demons at one time, and I was like, and then, then I start questioning, okay, well, am I saying it wrong? Let's see. Which this will probably be an unpopular opinion, but I'll also tell you that I think that Stu, I don't think that anybody would have actually noticed it if Stu wasn't making a big deal about it. And I honestly think that she wasn't doing it on purpose. I honestly think that Stu was objecting on purpose to make it look like they were just coming after him. And I think that it has worked because I think that a lot of people have picked up on that, because there are a lot of times when probably none of us would have even noticed it if he had not said objection, the name. So honestly, I don't think it was her doing it on purpose. I think that it could have been him doing it to make her look like she was doing it on purpose. Angel Roberts says, first of all, nobody know what Kenny was talking about. Their glory by speculations. You don't know if they were talking about the key for the house. Everybody's speculating. Rosa says, I do it too. I just think as the prosecutor, she needed to be cognizant of that. Didn't mean to start a whole issue. No, this is something that I noticed a lot when people were talking about it yesterday. So I like hearing everybody's thoughts on all of this stuff, because a lot of people did think she was doing it on purpose. And honestly, it just kind of shocked me that so many people thought she was doing it on purpose, because I've done it so many times. So I didn't think that at all. So it was one of those things I noticed that there were a lot of y'all that felt that. Look at you, Alyssa K, starting issues. Just joking. Are they still picking the jury today for the woman? Yes, for Shabusiness. Shabusiness. The deliberation clock has stopped. I know the judge said that they were about to take lunch, but I don't know if they're going to continue deliberations during lunch like some juries do, or if they're taking a break. But the clock is not on the screen currently. Let's see. No one could pronounce Letitia's name either. Yeah. Letitia. Let's see. Jurors not have a copy of the trial transcript. No, actually, this is something a few people brought up too. Let's talk about this for a second. So there have been trials where when the jury has come back and asked questions, wasn't it in Murdoch where they wanted to know something and they wouldn't answer it? They said they needed to rely on their memory of the testimony. And then some of them will have the transcripts and they just came back. The clock is now on the screen again. It says it's still deliberating. But so I guess, every court is different, but it's always interesting to me. You would think that they would have the transcripts ready and available so that they could, refer back to some of it, but Stu had a thing for objections. How funny was it when he would get really in objection? That one day when he did that, where he was just clutching his pearls, that was so funny. I think that the defense team, well, 2 out of 3 of them, have been great overall. I think that Stu lost his effectiveness towards the end when he let his antics kind of take over. I think that he lost a lot of the thing is, if you go in there being too dramatic and too angry and too, whatever, then people tend to focus on your behavior as opposed to what you're saying. Because think about look at social media, how social media has responded, to everything that was said and the way he was acting and stuff. But not even what he was said, the way he was acting, but how many things have you seen about, what he said? The majority of the conversations have all been about his dramatic, presentation of it. I think that they did a great job up until that. I think that lost the jury a little bit, but up until the last, 2 or 3 days of the trial, I really enjoyed watching him, and I still enjoyed watching him towards the end, but only because it was a little bit over the top and not because of the necessarily the job he was doing, if that makes sense. But I think David A. Howard is a phenomenal attorney. I am shocked that he did not do the closing. And Raven was also there. Hey, Brandi, do you think that Melly is guilty? I do, unfortunately, because there's not any other scenario that fits with the data, because I like to go by the things that can be proven. And there's we know for a fact that somebody in the back seat shot them. We saw him get into the back seat. His phone was at the crime scene. We know he had his phone right after. So there's not really anything else that makes sense. And I have tried to, you know, plot out different scenarios, and nothing has panned out. Let's see. Angel Robert says, typo, what I'm saying is that even if he did have a key, as a Black person, we tend to give a key to people when they need it. And then when we come back home, Bethany, you better give us a key back. But they were staying there though. Because in that one testimony, when they were asking about who all was living at the house and staying at the house, there were a lot of them, but AD was one of them. So he wasn't just, he didn't just like borrow a key. My son is 21 and I still call him a kid. In my brain, he's still a kid and not grown up. I agree. I still call my son a kid, and he's, you know, about the same age as them. But the thing about saying it to the jury was it was said in a way that was to invoke sympathy, and which she did eventually, Christine Bradley did eventually object, and it was sustained. But it's, in the eyes of the law, he's an adult and he's being tried as an adult, so it was something that I say, but to continuously repeat it to the jury was purposeful. Let's see. Perhaps it was a slip up, but if I was a prosecutor, I would remind the jurors the suspect is Satan. Who, if anybody, will be charged with lying to the court? Nobody. They never charge anybody with that. It's so frustrating. So frustrating. Gosh, especially like Travis Rudolph trial. I wanted all of them to have charges for lying and for contempt, for doing all the things they were doing. They were awful. Megan says, but he got on the stand and said only the two of them have keys, and later said they went back to the house and got in the unlocked door. The whole point was Melly had to be there to open the door. Yeah, just, I mean, his testimony was just easily debunked. So there's so many things didn't add up. Glass's testimony totally contradicts, and even AD contradicted, like I said. We don't know. It's been in a video when Zach Chaser said out of his own mouth they couldn't get in the house unless Melly was there to open up the door, but I guess you can say that's a lie too. My thing is, it was a lie. He lied. He lied. It was proven he lied. So, I mean, they got in the door plenty when, you know, Melly was out of town. I know I don't know of any video, but I know of the text where when Sack and Melly are going back and forth, and he says, when Melly says he's going to go stay at a hospital, he says something about how they can't get in without him. But then when he's in Chicago and he's texting Sack, Sack was telling him if the whoever it was is at the gate, so if they call. So if you choose to believe AD, then to each their own. I don't, because the data all goes directly against everything that he said. Sometimes I feel like I hate that word, bias in here, because the defense was doing his job just like the prosecutor did her job. I'm not making a fuss. I'm not on either side. They both do well. Stu is extra. But I don't think it's bias in here at all. I think that I was even just saying what a great job I think they did. I think that the only time Stu lost me was those last couple of days because he was so extra. But I think that David A. Howard is a phenomenal attorney. I think that Kristen Bradley did not do so well in the beginning. I mean, I think that as the trial went on, she seemed to get better, but she had some, struggles in the beginning. But overall, I think, I didn't think it was going to go well for prosecution in the beginning based on how everything started out. The defense started out so strong. Prosecution did not. But the only one who I think did nothing was Raven. Let's see. He morphed into a satire of a defense lawyer. That's how, I said yesterday or the day before, whenever it was, that it almost seems like it was like a Saturday Night Live skit instead of like an actual, it was just too much. And I think that when, you put so much drama into it, you just lose the effectiveness of it. And it does become more like, a skit as opposed to being able to really focus on what they're saying. Let's see. Somebody said earlier in his career, he pronounced it demons. He definitely got really extra near the end. These last couple days were just a lot. Stu reminds of the prosecutor in the Travis Rudolph case. She was just too extra. She was, ugh. Not a fan. Not a fan. Don't care who knows it. Not a fan. Hated everything about her perfect self. His closing was a train wreck. His closing was not effective, I believe. There were a lot of things that he said that were just wrong and that he misrepresented, which is common in, some closings, but it's also always frustrating. But it just, I think that David should have done the closing. That's the only thing that I can come up to say. But Raven was also there. All right, let's see. David did not do the closing because he is going to argue for life instead of death penalty. It's legal strategy, and it's why we haven't heard from him last week or so. Okay, I get that that's a legal strategy, but I think it's the wrong legal strategy. I think that like your number one concern should be getting acquittal so that you don't have to fight for life or death. So I would think that they would want him to because he's so effective, and I just feel like to me it would have made more sense, but what do I know? That judge seems to stream several trials, so I'm going to watch him when Long Crime Report TV doesn't have time. Which judge? The one that's for Melly? She had her brain on what she was saying and the point she needed to make. I don't think it was on purpose, nor do I think it matters. Yeah, I don't think it's on purpose either, but you know, some people think, hello, hello, hello. They were roommates, yes. Thank you. I love my cup too. Can you see? I use it all the time. Isn't it the prettiest? I love it so much. It's got my nickname on here. And then it's also got the jewels and everything are like in the, they look like the beach. So it's cool because it's like some of my favorite things. But it's done so well too. It's incredible. I love it. And I love it even more because it was a gift and I wasn't expecting it. I think, is Lisa in here? Lisa was in here. She might be gone now. Let me see. Oh no, Lisa's in here. This is a gift from Lisa. I love my cup. They both, I'm skipping over some of the ridiculousness. Like, y'all, let's all be kind. It's Friday. They both lost the jury at times in this trial, especially with the photos of text. Oh my gosh, the 500,000 photos. Y'all, would you just die if like the jury was like, hey, I think we need to see the 500 and something photos again? Oh my gosh, could you imagine? Oh my gosh. Oh my gosh. So did they ask another question when they asked about the meters and feet thing, but that's the only one since then. Eileen S says, I'm in Minnesota, so I'm thinking about going to Shabusiness. First, got to see if my friend will put me up at his house first. Oh, if y'all go to Shabusiness, you have to let us know. I love when we have our insiders. Let us know what's going on. Give us the behind the scenes stuff. We can see the whole judicial process. Let's see. Someone who is retired, I don't know how people can be working full-time and focusing on this trial. Times have changed. I'm too old, I suppose. We would have been fired. I've noticed a lot of people that are like working while they're watching, there are times when they'll have to pause, and then you'll hear people all the time saying, oh, I had to go do this, so I'm going to, watch on 1.5 speed and catch up or whatever. And so you'll see them like sometimes they're live in chat, and then sometimes they're like, hey, I'm an hour behind and I just saw this. Why didn't the prosecution show that text to AD then? She did. She did show it. She showed it in her rebuttal when they brought that up. She showed that. Had to step away. Anything happened? We are still on verdict watch. The counter now says 5 hours, 48 minutes. Did Melly show up to the hospital after the incident? No. I will call in and also tell y'all what I'm wearing if I can get there. If not, Shabusiness, as soon as I find another one close for sure. We'll be watching. I'm scared to tell anybody to go because Trey went for us during this one and then got fussed at by the judge for throwing gang signs because she was cracking her knuckles. Let's see. Lady in Gray says, all this BS about Melly still being a kid. Well, so were Juvie and Sack. What about them? They don't even get to have their brains mature. People tend to take their focus off this fact. Yeah, they were. That's one of the hardest things about all this for me is that they were all about my son's age. So it's hard for me. That's why I said, from the beginning, I was like, I want to find a different. I want to find out that this isn't true. I want to believe that somebody, my son's age wouldn't be capable of doing this to his best friend, So. I think the defense did as good as it could with what they had to work with, in my opinion. I think they did a fantastic job. Like I said, the last couple of days, not so much. But for the rest of the time, I think they did a fantastic job. Let's see. I think Track has access to the money. There were times his mom and him were waiting for Track to give them money. Oh, yeah, like the phone bill and stuff like that, when she would message and say that the stuff about how she wasn't going to pay the phone bill. That what is happening on my screen? Oh, they're doing the sentencing. Sorry, I'm getting notifications over here. They're doing the sentencing, I guess, in the school shooter stuff. Or I guess they're about to. Or maybe they did it. I don't know. I'm getting notifications now. I'm trying to look. Oh, the sentencing phase is beginning. Interesting. All right. Let's see. Justice for Julian Sack. That's something that I've said all along. I want truth and I want justice for the victims. And justice is not putting the wrong person in jail. Justice is putting who's responsible in jail. And, so it's, to me, it's all about, the truth. Be Our Golden Boy says, why people think people are biased just because people don't agree with them. It's funny on Twitter. Twitter's the worst about all of that. Like the worst ever in the whole entire universe other than TikTok about that. So I literally had to screenshot what bias actually means and just start schooling people on that. Oh gosh, it's so annoying. So annoying. If you see all the same evidence as I did and come to a different conclusion, cool, you made your decision. That doesn't make somebody biased. Like if you see it and you base your decision on facts, that doesn't make you biased. Like that's the whole reason they have 12 jurors, because not everybody's going to see everything the same. All right, let's see. In closing, Stu went in circles and about made me dizzy. What was funny? Somebody had said they were, they had he had his step count was at like 24,000 steps or something as he was going on. I think there was a garage door opener too. Oh yeah, there was a garage door opener in the red SUV to get in. That is another thing that was in the text messages. Early on, someone asked Liberty who she was, and I saw this, Jen Dim Pookie. I saw this, and her response was the boss. I'm thinking that was just a sassy response. It's definitely not the case. It's definitely not the case, and here's how I know that, because anytime they were entering in like papers or documents or anything into into evidence or whatever, you notice they never handed it to her. What did she do? Jay Thomas, hello. Are we waiting for more testimony read back? They asked for the testimony of Michael Kelly as well, but they said that might not be ready until tomorrow. So we will find out. But maybe they'll have it today, but probably tomorrow, I think is when they said they'll be able to have it. But I'll say this, defense said that that they could have it ready by tomorrow or whatever, but with them having the other one read today, maybe they'll try to hurry it along so they can hear this one as well today too. Even lawyer, said that Stu and his unlucky 13 was a bad move, that he would have been better served with just sticking with 2 or 3. Yeah, that's the same thing I said. When you give like everybody who's ever texted him angry, or, the whole Bentley thing was, was mentioned but there was, I mean, just when Juvie's dad, Fredo Bang, who we know wasn't there, Quando Wando or whatever he called Quando Rondo, when he couldn't get his name saved, it's like, but could not get that right. But when you start giving all of these, it waters down what anybody who he believed could have been an alternate suspect. It waters all that down. It loses its effectiveness. She did get she did get sick. She did buy them some time. Saying, why didn't she bring that text up while he was on the stand? Oh, well, think about how many hundreds of thousands of pages they had of this stuff. So she probably didn't have it right away. So it probably took the time for her to, or for whoever, on the prosecutor's team to go through that to find it. Because, if you're looking at, because they had literally hundreds of thousands of pages of text, Instagram stuff, Twitter stuff, Snapchat stuff. So it would have taken them a while to go through it. The green mark was animated, but it was real emotion during his closing with Rudolph. I loved his closing. It wasn't, you could tell like that was genuine, like frustration with how the heck can this even be at trial? And it wasn't like a show. That was, and you could tell the difference in when somebody's putting on a show and when somebody's feeling what they're saying. I think asking for this guy's and the trajectory guy's readbacks is most trying to convince a couple. I read that Raven is regarded as one of the most successful lawyers in Florida. I got nothing. The deliberation clock is not showing on the screen currently. Trayvion's testimony went a lot faster without objections and sidebars. Can you imagine how fast we would have been done with all of this if we didn't have all of that? I'm behind on chat, so I'm just now getting to this, but yes, Lisa Dempsey made me my cup. I love this cup. Prosecution made a mistake saying the defense paid the one witness money instead of defendant. That is one ground for appeal. They're definitely going to appeal. Which, I mean, everybody appeals, but they have a few things that will they'll be able to put on there. I don't believe Melly would have forgotten his phone in the other car, even if he supposedly watered the grass on the side of the road. My thing is, if two cars leave somewhere at the same time, going to the same place, it's a 40-minute drive. Okay, let's say can't wait 40 minutes. He needs to go potty. Okay. If you have to pull over to potty, and supposedly they pulled off on the interstate, so you have to pull off and exit, potty, get back in the car and go home. Why, if that's the only reason you have to, why would both cars pull off? Why would there be no other communication on text or anything between them? I've been following, like, going on road trips and stuff. I've been following a group of my friends, or they've been following me or whatever. And if one has to pull off, there's communication about it. Is there not? If there's not, then it's, it's usually because they don't see me pull off, or I don't see them pull off because we're not in front of each other anymore. But for them to have pulled off too, there would either have to be communication about it, or, if they see them pulling off and follow them, okay, let's give them the benefit of the doubt and say that happened. Anytime I've done it, if I see somebody pulling off, I'll call and be like, hey, what's up? Or, whatever. What are we doing? But sorry, I was making sure that this wasn't coming back. But why would there be no communication about it? Which they lied originally and said, yeah, he told me on Snapchat to pull over and that we were going to swap cars. Okay, well, that's a lie. We already know that they, that was in his statement. Lie detector determined that's a lie. No, not lie detector, but the Snapchat records. So there was no communication.
Council, after we went to lunch, I received one message from the jury signed by the foreperson, and it basically is the boxes checked, requested new evidence. I think rescind previous request. It was on the stage. Jurors who requested to wanted to hear the testimony of Michael Kelly have rescinded their request. We apologize for any inconvenience, so they'll read back to Mr. Kelly. Second thing is when Dale was in there, I guess trying to get them lunch or something like that, bring them a lunch. He received from not the foreperson, but a short note. It was folded up. That's good. And it was folded up, and it was passed to him, and it says, are we allowed to have Apple Watches? Someone has one. It's not signed or anything, but that was the message that was passed to me. And that's why when we got the message, I try to get everybody to come back to just talk about it.
Was that another jury? Oh, for sure.
Yes. We're going to wait for 1 second, so I want Gary in here.
Okay.
And he just wanted to respond.
Got the mic over here. Cause what? I can't even reach it over there.
So they're not going to, they're rescinding their request for Michael Kelly's testimony. And they asked if you're allowed to have an Apple Watch because somebody has one.
Defendant, this counsel, and the assistant state attorneys. So what I was sharing with you regarding the message that Gary advised me was that yesterday when we started, sent the jury to deliberations, Gary asked for all their electronic devices or phones, including smartwatches and Apple Watches. And in fact, one of the jurors has an Apple Watch and presented it to Gary, which he has it secured with all the other electronic devices. Is that correct? Yeah. Yes, sir. And secondly, he's also indicated that when he viewed various jurors, he was unable or did not observe anybody wearing a smartwatch. Is that correct? Correct. So I don't know how you want me to handle this. And I guess that's one of the things you could talk over for a second amongst yourselves. And I also have a message here from the jury, another message. And it says, what if we can't come to a decision, question mark, everyone is stuck on which side they've chosen, signed by the foreperson.
So, I think we're prepared to the extent that the court is, I think we're prepared to offer our responses.
That's fine. If you're ready, Madam, you ready?
Yes, sir.
All right, go ahead.
I know the court's not going to want to hear this, but with respect to the first of the notes.
Excuse me, when we talk about the notes, we're talking about the.
Okay, the first would be the Apple Watch. Okay.
The individual juror.
Individual juror Apple. As far as that is concerned, my understanding of how Apple Watch works, at least how mine works, is that there has to be some proximity to a phone for it to provide access to the internet. I don't know if I'm wrong.
There are versions that selling and cellular capabilities.
Okay. All right, so I guess we need to inquire with respect to who that might be that has it. And it would just be, we would suggest that we identify who it is, we just retrieve it and keep it moving.
So I think on that, you can remember pass the note to your deputy, bring that potential particular juror out and ask who has it, so we actually know.
Yeah, I wouldn't want to isolate them. I'd want to bring up the whole panel and have the court inquire as to whether or not anybody has any remaining electronic devices.
But as part of the court's instructions in 3.13 indicate that if anyone becomes aware of the violation of these rules, which includes not having an electronic device, they must inform the court. I think for record purposes, we just identify the person who has the Apple Watch needs to be removed from the room. We don't know whether there have been any other violations, perhaps someone looking up something online, unless we inquire further.
Thank you. You all done anything?
Well, two things, Your Honor. One, the person in passing up that note did abide by the court's instruction that Ms. Smith just referred to, but it doesn't say necessarily bring them out and single them out and expose them as a snitch. and I think we're jumping the gun by suggesting that if we find that somebody had an Apple Watch, they need to be removed from the room. The Apple Watch needs to be removed from the room. Is that what you're saying? Okay, so we concur in that respect as far as this.
This is my thought, respectfully. I just bring the jury in as a group, just let them know I have a message. It says, are we allowed to have Apple Watch if someone has one? I don't know if this, when they're talking about this. One of the jurors does have an Apple Watch, but it was taken away, or not taken away, but they presented to Gary when they asked for it the other day before the jury went into deliberations. He goes in and just retrieves all the phones and electronic devices, and they presented to him. So it may be that. And I'll ask again, I'll ask somebody else to watch on them now, or anything like that, a smart watch, and just see what the response is. If they say nobody responds to it, you know, the smart watch, then we'll take the next step and we'll see where we go from there. But I'm going to ask the jury as a whole if anybody has a watch.
Your Honor, with respect to that, the only suggestion that I would make would be for the court to inquire if anybody does have an Apple Watch. When they go back to the room, please give it to Gary, as opposed to them being castigated in front of the public.
I still need to know though, if somebody has a watch and they give it to Gary,
Who it is?
I need to know, make sure they haven't used it. You know, because he specifically, I instructed them they can't have it back. I don't know that I ever talked about smart watches or Apple Watches per se, but I know in the standard instruction, which I read to them, told them they can't have electronic devices, phones, cell phones, any electronic device have to be up here in the courtroom. Gary does it again, and when they go in, he collects everything, so, and he has it stored. So let me just take it one step at a time, and we'll see what they say, and then if we need to inquire further, we'll talk about it.
Okay.
All right? So who's asked the jury to come in for a second? Yes. Oh, wait a second. I'm sorry. Did I mention this, Steve?
The third?
I got another question.
Aaron, at that point, I think it's appropriate to read the Allen charge based on that specific comment. I can print copies for the court and counsel.
Well, it says here, what if we can't come to a decision? Doesn't mean they're in impasse now. Everyone is stuck on which side they've chosen. So if they say they can't reach a decision, that's one thing, but this doesn't really say they can't reach a decision. It says, what if you can't come to a decision?
I think they're saying they have not, and what if meaning, what is the procedure that we follow now that we are in that place, as opposed to what if that eventually happens. So we interpret it a little bit differently, Your Honor. As to what we should do about it, I'd like to confer with co-counsel. As to the other, this is the part that I know the court's not gonna like. We have made a position, taken a position that the statements that were requested at the same time and should be read back at the same time. Now we've received a situation, and now we've come to a situation where testimony that by a state witness was put on. And I know we're reading tea leaves, but because we're in that position, we need to account for every eventuality and possible scenario. I would hate for it to be that the jury that has now rescinded its request for the other testimony has done so because they have now been either browbeaten or convinced of a certain position because they lacked the ammo in terms of Kevin's testimony to retort. So I know that forcing the jury now to read a transcript, which they have said they don't need, might not be optimal. And so in order to preserve our objection, I would not propose that, but I would move forward on that basis.
Thank you.
Thank you, sir.
So there's a motion for mistrial, the state which we heard.
I want to make sure I understand. The motion for mistrial is based on the jurors rescinding their request?
That's the way I understand.
Well, it's based on the fact that we did not provide them the two statements at the same time, and now a request has been made to rescind, the request to see one of them has been rescinded. So it's not the fact that they have rescinded, it's the fact that the court denied our motion to read them at the same time, and now that has resulted in them rescinding the request for one. So that's the basis to be complete.
Back to my question, state which to respond.
No, you're not manifest necessity.
Thank you. Motion denied. All right, so what I'm going to do then is, and what do you want to do about the Allen charge? Does the state agree that my state's defense?
We've asked them to print it out so we can look at the Allen charge, if they could, and then we need a few moments to discuss it with the court's permission.
I'll print it now, if that's okay. Just want to deal with it.
That's all fine, well and good. That's fine. Go ahead, we'll be in recess.
Thank you.
So he asked for a mistrial. Because the Brandi Rain, what did you're laughing at me. What did I say? God, I don't even know. He asked for a mistrial because he had asked for them not to be able to listen to Travion Glass's testimony until they were able to listen to the testimony of Michael Kelly as well, because he feels like the one for Michael Kelly helps defense more and the one for Travion Glass helps state more. So he didn't want them to be able to listen to one of them now and have to wait on the other one. Now they have rescinded their request to listen to the one from Michael Kelly. So he's asking for a mistrial, and it was denied.
I would be a little concerned, and I don't think.
Shoot. Let's see. They have their counter down here, 6:18, whatever. See if they come back. Move them somewhat off the screen so we don't have to deal with their. Oops. Gosh, I just can't get my life together today. There we go. Trying to get them off as much as I can, and we can just see their counter because there we go. There we go. And then they asked about the Apple Watch. Now, I saw some of y'all talking about the Apple Watch. I don't have one. Someone said you can't type into an Apple Watch. But depending on the ones that, or the kind that you have, you can get messages and stuff. That's old stuff. So yes, you can type on them. See, I don't know anything about Apple Watches. Okay. See,
Second paragraph, we're all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. We are fine with that as well. The third paragraph, I don't think is necessary. I don't think it's implicated here. And it says there is nothing to disagree about on the law. The law is as I told you. If you have a disagreement about the law, I should clear them up for you now. That should be my problem, not yours. I don't think anything about any question or any statement the jury has made so far implies that they're unclear about the law and they have a set of jury instructions there. So we would object to that paragraph. The fourth paragraph reads, if you disagree over what you believe the evidence showed, then only you can resolve the conflict if it is to be resolved. We would prefer that it says only you can resolve the conflict if in fact it can be resolved. The words, if it is to be resolved, that phrase has a certain sense of inevitability, which seems like it's urging them to resolve it. And so we would ask that to be changed to if in fact it can be resolved. The next paragraph we would like eliminated completely. And it says, I have only one request of you by law. I cannot demand this of you, but I want you to go back in the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's view until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your service. I don't think we should be telling the jury how to go about the function of deliberation and suggesting to them that they each get up in turn and give a dissertation as to what they think the weaknesses of their own position are. I think is an unconstitutional intrusion on the function of a jury in its deliberation, and we would object to that. The final line says you may now retire to continue with your deliberations, and we're okay with that. Excuse me.
Your Honor, I have a vague recollection of any modifications to that being a problem. I'm trying to read, I believe, it's out of this circuit, 2015 Almeida v. State. I haven't had a chance to read it in full, but I have.
You're objecting to the change?
Yes, I'm trying to read through, I know it's.
What are they talking about grills again?
Thomas versus State, which is a Florida Supreme Court case 748 Southern 2nd 970. 10 point or citation point 978, and it says in part a somewhat similar situation arose in Young versus State, and it cites Young versus State where the court held the judge's deviation from the standard jury instruction by 1 sentence was error. I know that there's a lot of case law on this disapproving a modification of the Allen charge. The state's position would be that it should be read in total to the jury as to not comment on what portions or not. I think to isolate certain paragraphs would be truly suggestive and have a negative impact on whatever issue was.
Your Honor, I'd like to know if that case that you read concerns jury instructions at large or an Allen charge?
Allen charge.
It is an Allen charge.
Who asked for the modification, the state or the defense?
Probably the defense, but yes, Thomas, the defendant, asked for that Allen charge for the standard jury instruction after the jury deliberated. The standard Allen charge is not given.
And it says that a modification can be or is error.
It says in Young versus State, it was cited in the Thomas case that the deviation from the standard instruction by 1 sentence was error.
Okay. So it's all contextual, so we want a chance to take a peek. I guess it's done as well.
Well, this is my question though. The way I read this jury inquiry form, it states, what if we can't come to a decision, question mark? Everyone is stuck on which side they've chosen. That's the question. So are you telling me, both sides telling me that they interpret that the jury is deadlocked? It doesn't say that to me. It says, you know, what if we can't? It doesn't say we can't come to a decision. It doesn't say they're deadlocked.
The second part does. That we're stuck in our respective camps. So that's the declaration of deadlock.
The state agrees, it's an indication there that.
So if both sides agree, this is interpreted as a deadlock and they're stuck. Is that what you're telling me? Both sides agree with that?
Yes, sir.
Yes, sir.
Then I'm going to read the Allen charge. I mean, I'm not modifying it. That's a standard that's been around for 40, 50 years. I'm not modifying it. State objects to any modifications not agreed. I'm not going to modify it.
Can we take a chance and look at the case also?
Sure, go ahead.
See whether or not there's some distinguishing language.
I'm gonna print comments.
Thank you. Even though Howard doesn't say that.
I apologize. That's no problem.
We're happy to look at whatever case you want.
1999, for Thomas versus State.
I don't have anything.
Alan Charzo, really? After this short of a time, Allen charge is like if the jury is deadlocked and can't agree, the judge can bring them in and give them further instruction, and basically whoever's in the minority side, they can, like, it's encouraging them to reconsider their position.
Instructions to the jury, it was as to whether or not the effect of their further deliberations. So in other words, it's giving them an Allen charge and then telling them, and even if you were deadlocked, I'm going to send you home, which is completely different from the substance of the charge itself.
And I think, and at least the way Thomas interprets the argument, saying that the judge made that error, and that was the judge's suggestion to modify the, and defense objected to the modification. So that's, yeah.
So I don't think I need to speak further to the distinction there, which is the defense saying if the jury is saying they're deadlocked and we've read them Allen charge, and Allen charge says that if you still can't, case over, sending them back in for another day would be an element of compulsion that would be unconstitutional. So we could see where that, but we'd like to see we can distinguish than any other reasons. And Alice wanted me to make this point, which is pertinent, which is that in that case, the defense was the one that objected. Here, the defense is requesting it. So we would have waived our opportunity to object should the court grant our request.
Ain't nothing about this trial been easy or simple or quick. He would stay in custody. No, he is denied wrong.
Just told us about. Or that explanation was that Thomas. Okay.
Hold on, I
No, I see it in Thomas. I mean, I see it in Young. That's in Thomas as well. It's the same issue.
Yeah.
Okay. So yes, Your Honor, the Thomas case that the state cited was Thomas v. State, 748 Southern 2nd, 970. It's a 1999 case, Supreme Court of Florida. And that also cites to a state, Young v. State, which is 7/11 of the second 1379 and 1998 case out of the second district court of appeals. And the state has represented the issue that Thomas addressed. I'd like to just read some language here from Young that indicates that Young was treating the same issue. In the very second paragraph of the opinion, it says the jury began its deliberations in this case near 5 p.m. on the second day of trial. At or near 9 p.m. it informed the court, quote, as a group we cannot agree on a verdict, end quote. The trial judge made the decision to give the jury an Allen charge. It is proper for a trial judge in a criminal case to give the standard Allen charge where it appears the jury is deadlocked. The trial judge also decided, however, that he did not want a mistrial that night and would bring the jury back the next morning. So it's the same issue, which is we're going to give you an Allen charge, but it's not going to be effective because if you still can't reach the verdict, we're going to bring you back tomorrow. So it's the same issue in Thomas, and we think that's different from the notion that a Allen charge cannot be modified at all to suit the circumstances of a particular case. Here, I don't think there is any need to tell them about the law because nothing they've said implies the law. And we also think that it invades the province of the jury to tell them that they should each get up one at a time and explain the weaknesses of their position. That is not only counterintuitive to an advocate, and they're advocates for their respective positions. It's counterintuitive to an advocate, and I think it's an unconstitutional invasion of the province of the jury. They should conduct their deliberations and discharge their constitutional function as fact finders without our interference. So we would object.
State, anything else? So let me ask you this, how do you want me to, my thought is, I'm gonna handle this question first about who's got a cell phone, if anyone. I'll ask them that as a group, and then I'll read the second inquiry form as what if we can't come to a decision, and then I'll read the jury deadline. I understand the defense's objection to it. The construction's been around for over 40 years. Stood the test of time.
Thank you, Your Honor.
I'm not going to modify it.
Thank you, Your Honor. I'd just like to read this before the court. I understand the court has made its decision, but Mr. Adelstein brought something to my attention out of the Thomas case, which is a Supreme Court case. And it says, as noted, every Allen charge issue must be decided upon the particular facts and circumstances surrounding an individual case. So that goes to the issue of individuality and whether or not it should be tailored to the circumstances of a particular case. And we're taking a position that mirrors what the Supreme Court has declared, that modification of Allen charges is not foreign. As a matter of fact, the Supreme Court has directed that it should be tailored to the circumstances surrounding an individual case. So that we maintain our objection.
Thank you.
Thank you, sir.
So you want to bring the jury in?
Yes, sir.
Wow. It is so soon. Thank you for this. Thank you for the super sticker. My sound effects aren't working today for some reason. I broke it because I did it too many times yesterday, but thank you for that. I appreciate it.
Jurors entering.
Allen charge has been around for a long time, but it's kind of controversial.
Counsel, the assistant state attorney, and the ladies and gentlemen jury. Ladies and gentlemen, two things. First, I received a note from my bailiff did. It's not signed by a foreperson, but it's a note that was handed to him. It says, are we allowed to have Apple Watches? Someone has one from one of the members of the jury. As I tried to explain to you earlier, all the electronic devices are basically, we're not allowed to have those in the jury room, so we asked our bailiffs, Gary, to try to collect them. Does anyone have an Apple Watch, yes or no, in their possession? I asked the question, does anyone have one? No? I see everybody raising their hands, or several raising their hands, showing they don't. All right, there's no Apple Watches. Thank you. The second thing I want to do is, based upon, I received this juror inquiry form that is signed by the foreperson. It reads as follows. State of Florida versus Jamal Devins, case number 19-001872 CF10A. Check the box, ask the following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson. All right. So what I'd like to tell you or read to you is an instruction. It's called Jury Deadlock 4.1, and it reads as follows. I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it's legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on the facts of the case. Excuse me. There are two things that a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back to the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you have had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. Ladies and gentlemen, you may now retire to continue with your deliberations. Step down, counsel may roll the defendant. We'll be in recess.
Thank you, sir.
Scruffle incoming. Wow. So he tells them, go back for, for whatever position you're on, go back, talk about the weaknesses in position, see if anybody will change their mind. If they don't, and they're still deadlocked, then they will call it a mistrial. This is nuts. Yeah, they're sequestered. That's what the Allen charge is for. To convince the minority to change their view. They are told to go look at the weaknesses in the case, or in their position rather, and see if they can re-examine it and come to a decision. I would love to hear the numbers for each side, like how many are on which side. If it is a mistrial because of a hung jury, he will. I would bet my whole bank account that they're not going to give him bond. It with it being a death penalty case, especially, he would remain in jail until they try him again. But see, when I was so mad over the constant arguments and the judge not, making a decision on things, sticking with it and dragging this out and the constant sidebars and all the, when I was getting mad about that, this is exactly why. I said the jury is going to be exhausted. They are going to be over it. It's going to be, one of those things where they just want to get it over with because it's been drug out so long. If there is a mistrial, yes, they will decide if there's another trial. And I mean, this is a, potential death penalty case. I think they would, it would shock me if they just dropped it. They have plenty of evidence against him, so they're not going to drop it. I wish they had not made it a death penalty case, though. I don't like this being a death penalty case. I was thinking the same thing. Just based on how, split so many people are about this one. If it's a mistrial, I would watch a different trial. I don't know if I can go through this one again. This one has been a freaking nightmare. I have been attacked more on this trial, and I've gotten to that point where I'm tired of being nice. I'm tired of assholes. I'm tired of people not being able to agree to disagree. Our chat is really good about it. The rest of social media is not. But that's why I love our chat. Let's see. What did the jury note say? Which jury note? The one that, which one? How much have you missed? The last one said that somebody had an Apple Watch, and then it said that they asked the judge what happens if they can't come to a decision because both sides are stuck on what they believe. Let's see. Anyone think they may opt to not retry him? No. I think that they will. CJ says, y'all ain't been this angry the whole time. I've been angrier, actually. This is just annoying because this is exactly what I said would happen, but I have been angrier about the phone. It's all about the phone. Will they be able to enter new evidence in a new trial? Yeah. Because it'll be a whole new trial, whole new jury. I have a headache too. Someone can only be tried up to 3 times before the case is dismissed, right? Yeah, the kid in Texas who was 16, right? When he killed his parents. He had a hung jury twice, and now he's on his 3rd trial. Why do the people at my job think I came here to work? Weirdos. Tell them you're busy. Tell them you got jury duty. and they vote no on death penalty, yes, that is let's say if they reach a decision and they convict him now, they will have a different sentencing phase. Kim Newton, thank you for the super sticker. Thank you, thank you, thank you. Thank you. Thank you. The evidence isn't beyond a reasonable doubt. See, and that's exactly why they're split, because there are a lot of people who see this as beyond a reasonable doubt, and then there are a lot of people who don't. Does he have to pay for his lawyers again for another trial? Yes. I reserve my cursey words for special occasions, and talking about the people who come after people on social media is a special occasion. What if the majority is in Melly's favor? They don't know who the majority is, which one. So they just give the instruction to go look at the weaknesses in what you believe and see if they can change their mind. Hog crime went crazy on this trial. Yeah. So did Twitter. And R says, I have seen juries come to a decision after being read the Allen charge. It's early in deliberation, so it's weird that they are stuck so soon. It is, that's my thing. It's really early for this, but at the same time, look how it's really early into deliberations. But keep in mind, these jurors have been here since April. They've been going through all of this since April. I wouldn't touch the long crime chat with a 100-meter pole with this trial. It's just insanity over there. That's a neighborhood I don't go into. Long crime chat. Neighborhood I don't go into. Let's see. Oh, you pick on an hour. Well, the jury said they wanted to know if Apple Watches are allowed because somebody had one, and they wanted to know what happens if they can't agree. Because everybody's stuck on what they believe. Do you think that it's more than one holding out? Which side do you think is the majority in it? Because I've seen polls on different ones. Like I saw like the poll in here has been mostly guilty. The poll on AK-47, was it his? Which one was I watching? I think it was him. Let me look at my history before I say wrong. Look in my history. Yeah, King AK-47. The one on his was guilty. So ours has been guilty. The one on AK-47 has been guilty. And another one Academics did the other day was guilty. A different one than he did a while back was not. Mistrial sounds expensive. Mistrial is expensive. By the wording, it sounds like sizable camps rather than one or two holdouts. In my experience, the state may reduce charges or put on a stronger case as the defendant is usually broke. I've seen where they have made a deal with the defendant to take death penalty off the table if he agrees to have, like, if it's one that's holding out, to take death penalty off the table if they remove that juror and allow the alternate to take their place. I've seen that happen. I'm not saying it's going to happen here or that it's one or anything. I'm saying I've seen that happen. Because, you know, they don't want to go through a whole nother trial. Let's see. How could you change your mind if you truly believe in your verdict? I mean, if you truly believe in it, then you couldn't. But if there's something that somebody remembered wrong or heard wrong, because that's the thing, it's like, I don't think it's early enough to be deadlocked yet. If there's something that, you know, if there's something that's keeping somebody from going one way or the other, then I could see, you know, changing it because of changing your mind based on, you know, other information that you forgot or didn't hear right or missed or, you know, whatever. I could see that. But as far as just changing it because you're in the minority, you know, of whichever side, no. Jurors are definitely ready to go home. If Brandi were a prosecutor or a defense attorney, I would not want to be on the opposite side. I don't blame you. Yeah, we're still under 7 hours and they're stuck on their sides, apparently. I feel for the two victims' families too. I cannot imagine if this is, you know, if this is deadlocked and it's a mistrial, having to go through all of this again will be so difficult on those families. And I feel so bad for them. What is Juby's mom saying? Let me look. Oh, let's see. She said, devil is a lie. And she said, son, we're here patiently waiting. That's all from her today. Brady, if you were Jamel's mother, what would you want? A mistrial? Is that good or bad for him? I mean, it's better than guilty. It's better than a conviction right now. I think that it would be a relief that there wasn't a conviction, but it's still painful if, knowing that this isn't all over and all that. But I think that I would be relieved that I don't have to, that there's still a chance that he wouldn't, be convicted, and that there's still hope. But I mean, but it would still be hard. Even of the two witnesses in the car, you can only pick one that has evidence to back what he said. Yeah, that's what I said too, Greg, that if you have to pick one story or the other, evidence backs one of them and not the other. Brandi just doesn't want to break her record of verdict predictions. But remember, I didn't predict this one. I've said what I think, but I didn't predict this because I even said this one has been so split, I can't tell you which way they will go. Actually, if it is hung, it'll keep me 100% because I think that on Tuesday, or was it Tuesday or Wednesday we were talking about it? And I said, of the trials I've seen recently, if there was a hung jury, I would see it on this one because of how split everything's been. So, but I think it's too soon for a hung jury though. Tylenol for everyone. Oh yeah, Curtis, that's a good point. Curtis Flowers, 7 times. They need to leave that man alone. 7 times. 7 times. 7 times. I'm not going to show this comment. Well, no, I'm not going to show this comment, but I'm laughing at it because I agree. Let's see. How shocked would you be if Melly is found innocent? Melly ain't innocent. If he is guilty, not guilty, that's where they're deciding now, but he sure ain't innocent. Let's see. Portland, this trial is October 2nd, as of right now. It's not working. Let me see if I can get my cash sounds are not working. I can't figure it out. They were working yesterday. Everything was fine. The jury has not seen as much as us. This is a huge point, Lisa Wilmot. There's a lot more that they did not get to see. A lot more that they did not get to see. Let's see. I talked to Mark about it a little bit, but he hasn't been following it too much because he's been busy with some of the other stuff, but we talked about it a little bit. All the jury has to come to an agreement on a guilty or not guilty verdict, or else it's hung. For death penalty phase, let's say he is convicted and they go to the death penalty phase, that one is the one where you only need 8 out of 12. Yeah, they started all this in April. Because, keep in mind that the death penalty jury selection process is crazy long. IPM's coming. Benita Clark, guess what? I finally got my summons in the mail to report for real jury duty. It says to call a day before to see if I come in. I'm so excited and happy to have gotten this. You'll be a professional. Tell them that you are a professional juror. Oh, yeah, it's big. Remember the juror that asked early on what the status of the mistrial was? Danny P says, so is there no other verdict today other than to see if it's a mistrial? Can he not be guilty or innocent? Guilty or not guilty? Sorry, I'm confused trying to learn. So we don't know yet. It all just kind of depends on what conclusion they come to. So he has sent them back to deliberate some more because they're deadlocked. And he said, talk about some more, see if they can come to a conclusion. So it all depends on how that deliberation goes to see, if they're able to come to any kind of agreement. I don't think he gave them a specific time on how long they have now. Brittany says her showing the phone didn't prove beyond a reasonable doubt. No, it did not. Her showing the phone did not prove beyond a reasonable doubt. Her showing the phone along with all of the other evidence in its entirety, with everything together, the entire picture, and how all of the different pieces of evidence rule out other scenarios, for me, is what made up my mind. It was not just one thing. One thing could not have proven this at all. Let's see. How many votes for guilty? Need to be all 12. Yes. Where does it show the cars stopped? The cars when they were leaving the studio. The only time that they stopped, according to all of the data and the timing of everything, was one of them stopped when it got to the front gates of the neighborhood. The red one did, and then the Jeep did not stop until it got to the crime scene. Let's see. So most of y'all are thinking that the majority is guilty and the minority is not guilty. Regina Crawford, thank you for the super chat. Who needs law and crime when we have Brandi? Thank you so much. Nobody needs law and crime. Not that chat anyway. Thank you so much. I appreciate that. This journal says, I think it's about half and half, maybe. They did not give us a time of when they're coming back, or if they did, I didn't hear it, but they did not give us a time. Yeah, in this chat, the majority has been guilty since after the trajectory stuff. And then the statistic went up further after the medical examiner, or whichever one was first, it jumped up. And then after that second one, it jumped up. And then I know I watched King AK-47 last night, and his poll was also guilty. And long crime is always not guilty for this one. Let's see. Why is everyone talking about an Apple Watch? Because they gave a note to the judge that one of the jurors had an Apple Watch. What about Boone? Let's see what he has to say. Oh, Stu. Hey, Stu. The only thing he really has up there right now is that Judge Murphy ends reading the jury deadlock 4.1 document to the jury, excuses the jury, and courtroom breaks for recess at 2:47. Dang, Marie Moss. Sidebars 121 and objections 353 total. That's crazy. Is it possible that they all think guilty but can't agree on punishment? That is actually a separate phase of this. So this is only for guilty versus not guilty. Lawyer, this morning asked if chat thought guilty or not guilty. Most said guilty. Some said not guilty, and some said hung. If it's retried, can evidence that was ruled inadmissible be reheard to be admissible? That's a good question. We'll have to ask one of our attorney friends. Jay Reels, you just try to push my buttons, don't you? Maybe some jurors are scared for their lives because gangs are involved. Yeah, well, that was one of the things that they had mentioned before. Remember that there were jurors that were concerned about their safety. Imagine thinking a random drive-by killed 2 people like that. Come on. There is 0 chance in hell that was a drive-by. But the jurors have separate hotel rooms, or maybe a scruffle tonight. They should be more judicious about which cases to charge as capital offenses. This was predictable. I was worried about nullification or compromise verdict. Yeah, I don't think this should have been a death penalty case. Surprise could be they come back with not guilty. If by some fluke the majority are leaning toward that, stranger things have happened. Stranger things have happened, especially in Florida. Look at Casey Anthony. The jurors should be able to provide evidence why they are voting the way that they are. I agree. It should be based on, that's all we can hope for, that it should be based on evidence and fact. I do not think the jury cares if it goes into a mistrial. No, they just care about being done with it. Because a mistrial is not their problem. Once it goes into mistrial, they're done. It's not like they have to start over. But this is exactly what I was saying. Remember weeks ago when I was saying if this keeps dragging out the way that it is, the jurors are going to be exhausted and miserable and tired, and they're going to want to just be done with it. You can change your mind if someone explains some evidence. You could see it in a new light. Yes. Let's see. How do you reason with the juror afraid of the mask? I don't even know how that juror got in there. They go through all of these questions to get onto a jury, especially a death penalty case. I don't know how that juror even made it on there. Let's see. This Allen thing is good because if done right, you get up, say your piece, then if required, ask for evidence to prove or disprove your argument. Lisa Wilmot's predicting 7 hours, 32 minutes. They come back deadlocked. If there's mistrial, how does it affect Portland's court in October? I'm not really sure, honestly. I mean, because it would affect it a lot more if they had, a guilty verdict or a not guilty verdict. But hung jury, I'm not sure. You can totally change your mind if you gain more information or understanding along the way than you had going in. Yes, Rochelle Smith. Yes. I say this all the time. I can lean one way or the other, but my mind will be open to change until there's nothing that could change it. But it takes a lot to get me to the point where nothing could change it, or until we get to the end of it. Let's see. PJ thinks 9 guilty and 3 not guilty. Rainy Rain says, I'm going to say what might be going on. I think some of the jurors feel that he was being bullied and had to defend himself. I say might because that's honestly what I was thinking. Melly? Or is that what you're talking about? You think that this was self-defense? It is horrible for the mothers. Horrible for the mothers. The witness that they decided that they didn't need to rehear was the CSI guy, Michael Kelly. And his testimony was he's the one who, he had the accent. He is the one who collected the, Portland's clothes and took pictures of the inside of the Jeep and all of that. And then he did the first trajectory thing, not like the full recreation of it, but the first one with the rods and strings. Let's see. If they don't retry the case, does Melly get out of jail? If they don't retry it, yes, but there's little to no chance that they won't retry it, in my opinion. Normally, the only time that, from what I understand, they won't retry one is if there's not a lot of evidence against them. But with 2 lives gone and the amount of evidence they have, I don't see them not retrying it. Why can't anyone put someone else in that seat? Oh, you mean in the back seat? Nobody's been able to. I want another poll. Oh, let's see. What poll do you want? Guilty, not guilty, guilty, not guilty. Who do you think the majority side is on the split stuff? What poll do y'all want? This trial has been exhausting to the bitter end. No crap. Say that again. This is extremely sad and unfortunate. Anytime there are lives lost, it is. This trial does not mean he gets released. No. Yeah, I can't even imagine the moms. Teresa Howard, Holland, not Howard. I need my old lady glasses. Teresa Holland, welcome to the family. Welcome. I'm about to do the poll, but y'all are all giving me different polls that you want to see. There's no sound because this is old. This is all just Stu yelling at the jury. Let's see. Seven hours seems really a short time to be deadlocked. They can never remove a juror during deliberations for their vote. Brandi Churchwell, what are you talking about? Never in the USA. Yes, ma'am, they did it. They did it in Georgia, and he was convicted. His attorneys talked to him because they offered to take death penalty off the table and give him life without the possibility of parole in exchange for removing one of the jurors and replacing that juror with an alternate juror. Because that one juror was the only one who they said was not voting with the majority of the jury, and they did not say who was majority and who was minority. They just said that there's one who can't agree. They removed that juror, replaced by an alternate, and they convicted him and gave him life in prison. And he is still in prison. On my channel? No clue. No clue what that is. JT must have been doing something. Uh, Can he have a fair trial if it's a mistrial? So much has come out. They have a few different things they can do. They can try to see if they can move it somewhere else out of that county. If Melly is found not guilty, will he be able to sue the state? I mean, not really. He could try, but it would be pointless. They never till Stu starts singing. I'd be scared if I was a juror and they knew my name. Well, you notice the juror that they said their name on stream is the one who then couldn't come back. Shocker. Go back and look at when the jury was coming out. Raven said something to Melly that needs to be looked at. When they were coming out, when? Which time? All kinds of tech issues today. All kinds. Is it a conflict of interest for Kristen to be the prosecutor for Portland's case? No. The prosecutor can, because think about it, like if they had not split their trials, she'd have been the prosecutor for both of them anyway. The prosecutor and the judge could be the same. The defense attorney cannot. Can Melly afford private representation for another trial or get stuck with a public defender? Apparently he's still making a lot of money. I mean, apparently he can afford it. Trisha says, I don't see where the doubt comes in. I don't see where the doubt comes in. He was sitting in the back seat. Shots came from the back seat. Phone puts him at the crime scene. Guilty. Is it legal to have Melly have another trial after Portland's, regardless of the outcome of Melly's first trial? Is it legal to have Melly have another trial after Portland's? Yeah, I mean, it may be, who knows how long it's going to take. You know, if it's hung jury and they have to redo it, who knows how long it'll take. Let's see, Miss Justice Jones. All evidence points to guilty, but when you're sick of being there, you're done. Pray it's a mistrial so the prosecution can go at it again. The only thing about that was the family's having to sit through it again. I'm not looking too happy today. That's because you keep tormenting everybody and trying to pick at everybody. So I'm fine. Everybody else is fine, but you keep trying to start crap. Do you agree that the judge should not have read the statement about a deadlock yet? Well, the thing is, he wasn't going to, but then when he said, because he said that they weren't saying that they're in deadlock yet, but then David A. Howard is the one who said that it's deadlock because the second part of it where he said, where the note said, both sides are, stuck on what they're thinking. So the first part said, what happens if this happens? So he wasn't going to. And then David A. Howard is the one who said that, the second part says that they are. So we'll see. Did I fix my internet's fine. My internet's been great. The other day when they were doing something, they were swapping it from something to something on my fiber, but it's been perfect since then. All the glitches and stuff are stuff with YouTube. It's not like it's been stuff with the commands and the chat and all kinds of stuff with YouTube. This has been going on for like 4 days now. Let's see. People keep asking that question. But I know people are kind of coming in and out based on working and stuff, checking in to see what's going on. Let's see. I think the jurors should be shown everything. There are so many things that I wish that, in different cases that they could be shown. There are some things that I do believe are absolutely prejudicial. The song lyrics, I don't think that the jury should have to see that. Like, I don't think that that's, I don't think that should be used against him. Like all the pictures of him holding, guns and money, I don't think that should be shown. Because think about it, like, if you have an innocent person who's just doing that as like their rap persona, then that could cause prejudice. But when it's the stuff about this trial and the things that were said, and now all the witnesses that have amnesia and stuff, like those are the things that I wish that they had all of the information. And even during closing arguments, when Stu started, like when he slipped up and he almost said part of what, they didn't hear about Melly going back the next day to go get the guns in that Kia. When you hear that and you hear him even saying, that Melly went back the next day to get the murder weapons, like when you hear him and then, but that the jury can't hear it. Stuff like that is really frustrating. Hearing him say, tell the jury that they really need to consider the testimony of, Felicia Holmes, how she felt threatened by the prosecution and all of that. That's really frustrating too, because if you look at all of her previous stuff until after that $5,000 went to her account, if you look at all of her previous stuff, she's talking about how she felt threatened by Melly. She was worried for her daughter's life. She reached out to police because she was scared for Mariah's life. She has all that communication about, them paying her off and stuff. So for him to say, look at her and, what she said is lies. We know that she lied. So stuff like that is the stuff that gets really frustrating when you're watching it. That's the really frustrating part of watching the whole legal process, is that when you know more than the jury is allowed to know, sometimes I believe that that's good. Like I said, the, music lyrics, stuff like that. But sometimes when it's stuff that, gives more of a picture of the truth of this matter, that's the stuff that's hard to accept when they don't get to know it. I'm trying. Yeah, I'm behind. I'm trying. Because then if I miss something, then everybody's like, oh, you only read these and you ignore me. And blah, 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 blah. Let's see. I'm convinced of his guilt by the vehicle he got into and the fact the phones put him there. Phones don't lie. Yeah, that's the thing. And, if they had gone by just the phones, then that's one thing too. But they corroborated, the phone data with all of the security footage, which is, to me, makes it even more solid. We're definitely going to have a hung jury. I'm late to the party. What happens if it's hung? Then they have to retry him. Let's see. I have not talked to Mark yet about whether that case that he was talking to us about is going to trial. I'll text him later or this weekend or whatever and find out. That one's going to be an interesting one too. That's, innocent man going on trial. He's always BS. Let's see. The juror that was scared of the mask should have been gone, and the one that claimed financial hardship. I don't even know how to. Did they take the Apple Watch? I'm not sure. Curious why they rescinded the request to hear the detective testimony. Let's see. The jurors make me feel like they're not even trying. It just seems so early for this. Which, and granted, they didn't say, hey, we're deadlocked. They said, what happens if we can't come to a conclusion because right now we're all firm in our stances. So they weren't saying, hey, we've tried. So maybe it was jump into conclusions or whatever that's what they meant. But I guess we'll see. It's pretty off in each other. Anita has waited 63 years to get summons. 63 years old and finally got jury. I love it how you're excited. So many people are like not ever wanting to do it. If Melly is found not guilty, then Portland probably will as well because the state already had evidence pointing to Melly. They can't contradict. Well, the thing is, Portland is, Melly's whole thing is, I wasn't in the car. That's his story. And Portland, we know, was in the car. So, and he's being charged with accessory after the fact too. So I think either way, Portland's. I think either way, Portland's going to be convicted for the accessory after the fact. But as far as the murder charges, it'll depend on jury instructions. Daryl Brooks in his request for jury nullification. Heard about. We started to watch some of the Daryl Brooks. I'm still behind. I'm trying to. Every time I think I'm caught up on chat, then it'll be like pages that jump forward.
This is State of Florida versus Jamal Denman, president is the defendant's counsel and assistant state attorney. The jury is in the jury. I have another question or juror inquiry form that says, ask the following question. Ray Exhibit 116, hyphen, times listed, paren, start and end, close paren, marked as UTC-4. Does UTC-4 reflect that 4 hours have been subtracted already, or does subtracting 4 hours from start and end times need to be calculated? Signed by the form.
You can answer yes. I think we need to just tell them to rely on their recollection of the test.
I don't have an answer. I agree. So.
Yes.
When it said UTC -4, UTC is like the world time, whatever, and Eastern time is -4 hours. So they were asking if that means that the 4 hours had already been subtracted.
So, Counsel, I just answered this way, so you want to rely on your recollection of the evidence tonight for my answer. All right, any objections?
No objections, sir.
Thank you.
Thank you.
We're recessed.
Recess.
There were some of the reports that they gave where it was already calculated, and then some of them where it wasn't. So if they're looking at that, though, then they are like, think about, oh, I forgot. I just think I should rub some of my eyebrow off. Think about it like this. If they're back there supposed to be talking about the things that they're stuck on, then, and they're asking about the time, that could be one of the things that is making them disagree. If somebody is convinced about something because of the time on one of the reports, and somebody, had the time stuff confused, that could be one of the things that they are trying to work out now. But the thing is, if he's having them rely on their memory of that and they're wrong, that changes everything. Because think about, we know that Melly sent his location to Fredo Bang and he called track and all that. We know that he was out there doing all that 5 minutes after Portland went to the hospital with the other guys. 5 minutes. If somebody thinks it's 4 hours and 5 minutes off, it's a whole different pace. Surely someone on the jury knows for sure. I would think so, but maybe that's one of the things that they're arguing about. You know, maybe that's one of the things that is keeping them from feeling the same way about something. Clocks go forward end of March, back end of October in UK. USA does it a few weeks earlier. So, well, that's the thing is EST could be, so they, but it's specified on theirs because you have Eastern Standard Time, but see on those it would say all of this stuff that happened, this happened before November. So it's the stuff that they had, there were only a few things that they had that were Eastern Daylight Time. Everything else was Eastern Standard Time. Or no, it's the opposite. Eastern Daylight Time is the one in the middle of the year. And then Eastern Standard Time is the second one. So all of their stuff they specified was from all of this time was 4 hours. So they had the -4. The text or something, some kind of report from that they were going on from later, like in December or whatever, was the 5 hour one. Too much mapping. But see, if that's one of the things that they're disagreeing on is, you know, somebody thinks it's one time and somebody else thinks it's the other. Think AK-47's mouth is too filthy for Brandy's channel. Yeah, you know, it's funny because I watch him, and his vocabulary is a lot more colorful than mine. But I do watch him. I think he's entertaining, even though he yells at everybody. I think it's funny. He cracks me up. Does anybody remember what? I don't remember what, or I don't know. I don't think I made notes of any of that stuff of what item 116 is. Yeah, EDT is when it's daylight savings time. And then that's Eastern daylight time. And then Eastern standard time is when it's not. I hate daylight savings time. It's like you have to watch the sunset at 2 p.m. Let's see. There's a question about the case you were talking about where a juror was replaced. What trial was it? The trial of Guy Hines in Georgia. What if the foreman juror writes a note requesting something to drink and a snack mix? Actually, I can show you. I did a promo video because I'm working on. I was going to just cover Guy's case, and then as I started digging in, crazy stuff started coming out, and now this has turned into me covering one case into the entire county and corruption, and it has gone way bigger and deeper than I thought, and it's taking me a lot longer. I was originally just going to do his. Thank you, Nurse for God, for the super chat. I hope they allow them to deliberate late tonight if they're close to a verdict. Yeah. Let's see. Let's see. I can find somewhere. Dang, I don't even know where it's at on channel. They keep shaking that camera, and I think something's happening every time they do. Why can't I find it? Oh, here it is. Okay. This is the promo that I did on it when I was planning on releasing just this part. And then as I kept going, as I kept going and investigating, everything got bigger and bigger.
911, where's your emergency? Oh, New Hope Plantation, Highway 17 North. Okay, by New Hope, what's going on, ma'am? There's a kid, guy just came home and his whole family is dead. I think all my whole family's dead. My whole family's dead. Okay. It looks like they've been beaten to death. I don't know, man. Okay. I mean, I don't know what to do, man. My name is Mike. I'm the maintenance out here. Tell him to hurry. They think Michael's still alive. Still alive? Yeah, Michael's alive.
Police say the 9th victim is still in critical condition at a Savannah hospital. Authorities say they have expanded the search for evidence around the home where these murders happened. And when asked about the lack of information being released, Glen County Police Chief Matt Doring acknowledged the community's frustration.
It's a very difficult investigation, as I know you're all aware. And right now we're doing everything we possibly can do in order to find those responsible and figure out what happened.
The family member who called 911 to report the crime is being held in the Glen County Jail without bond.
The charge of malice murder as alleged in count 1 of the indictment, we find the defendant guilty.
Oh my God, dude.
How could one guy beat 8 other people to death and not even have a scratch on him? 8 people.
Shortly after. All right, look, DA is known for misconduct, changed the wording of charges during the trial. No longer had Guy as the sole killer, but now as a participant, because there's no way that one man could have beat 8 people to death all at once. And then juror number 152 would not vote guilty during deliberations. This juror was removed and replaced by an alternate in exchange for taking the death penalty off the table. The jury then voted guilty unanimously, though multiple jurors said that they were confused the whole time.
The third day of deliberations began. The judge removed one of the jurors and replaced him with an alternate. The judge then ordered the panel to start over. He wound up convicting him 8 counts of murder, 1 count of aggravated assault, and 2 drug charges.
So that's the one. That case is crazy, and I have been in touch with his wife, and one of the victims was a friend of mine. She was murdered, and he's one of the family members. And I originally started looking into this case because I was like, there's no way one man beat my friend and 7 of her other family members to death by himself. So I originally started looking into it thinking, after he was already convicted, thinking, I bet I can prove that he wasn't acting alone. And the more I looked into it, the more I realized he wasn't acting alone. He didn't act at all. He's an innocent man, and he's sitting in prison with no parole. Always. It's the same prosecutor, the one that I just showed is Glen County. It's the same prosecutor involved in, remember the whole, I love it how they keep showing flashbacks to Stu yelling. How angry. Ahmaud Arbery, and there was also a police officer two police officers who shot and killed a woman when they showed up on a call and said that it's because she was armed, and their body cam footage was supposedly shown to a grand jury. And I won't give too many details because when I finish all of this, y'all can listen. But without giving too many details, corruption got all of that swept under the rug. The one who did it, his attorney even is on a recording. There's a lot, y'all. This one goes so deep. And I have the recording. But it's knocking, probably in the delivery. But Lucy. But she's part of the delivery guy. But anyway, it was swept under the rug, and then he went on and ended up shooting and killing his wife and new boyfriend. Crazy stuff. Yes, this is my podcast, and I have been it's been crazy. Stop. You go over the timeline again. Was there enough time for someone to replace Melly in the car? No. Let me get the delivery so that Lucy can see that nobody's at the door and everything's fine. She would not have calmed down until I showed her that nobody's out there. Oh, let's see. I have read it, and I have actually gone over it all with his attorney, his original attorney. And I've read it. I've spent a lot of time on it. Let's see. But they're in the process of doing another appeal now. I can't just like leave it out in the hall for a minute. She has to see that they're gone now before she'll calm down. Hey, Sasser. Shot by her ex-husband, Corey Sasser.
I'm sorry, Ruby, I apologize. Who would open the door? I normally open it for Ruby.
She's a little diva. Actually, you know what? Dean Sparks, you're right. It is. I do have one of the boxes is for her, which is probably it's like she knows. Lucy and Rebel would have been house. Back up, Psycho. Here. She's so high maintenance. Honestly, so surprised there's an international crowd here. For anyone outside the U.S., Just wondering what is the interest in this case for American courts? Like you'd be surprised. I have like 38 countries. I think last time I saw 38 countries that watch. The last I heard, they are ending at 5 because they don't want court staff staying late, but I'm not sure.
Make sure we're all in the same place. Everybody agree?
Yes, sir.
Yes, we're all good?
Yes, sir.
All right. So can I bring you back in now then?
Yes, sir.
Yes?
Yes, sir.
Yeah, you think, I forget whether we did during trial, you need the light gift or not, yes? So you want to bring the jury back in? Yes.
You cold? I'm in Central Time Zone. So I'm in the Panhandle of Florida. Yes, this is live.
Jurors entering.
Whatever they're asking to see, keep in mind, these are going to be the things that they're arguing over.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state's attorney, ladies and gentlemen, the jury. Ladies and gentlemen, I have a question from the evidence here. It says you requested the traffic video from 595 to see what time the Jeep and Mitsubishi passed the express lane cameras. We attempted to pull up the footage on a laptop, but it did not play. I've asked counsel to secure that portion of the evidence for you, and it will be replayed for you now. You ready, counsel?
33453.
Everybody in your heartbeat now. The audio is terrible today. Terrible.
Yes. Defense, yes, does that complete the publication?
I believe so.
Thank you.
Thank you.
Thank you, ladies and gentlemen. You can go back to the jury room. Continue with your deliberation.
So 336.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. We're in recess.
Recess. Okay, so this kind of gives us a little bit of insight into what they're arguing about. What you jumping for? Come here. If they're looking to see what time the car passed on 595, then they are more than likely arguing about whether or not they had time for them to stop on the side of the road based on what time they were on 595. Let's look at the map and everything I made. Okay, this is disgusting. This popped right back up because this is what I had, and where his mom put "the devil is a lie," somebody just put this of Melly dancing. What an asshole. How could you do that to somebody's mom? Freaking her son died. Nothing will make you lose your faith in people like social media. I'm so ready for this trial to be over. I really am. This has brought out the nasty in people. I don't care what you believe. That is unnecessary. That is disgusting. I hope karma gets him. That woman will never see her baby again, and he's going to. All right. So this is timeline stuff. All right. That video shows what time the cars passed by on the traffic camera 595. So 326 is the time that it showed, right? Can you tell us what the video could be used for on either the guilty or not guilty camps? Because I'm lost at why they asked. I would think it's because they're wanting to know what time they passed the traffic cameras to see what time they or how long it took and where they were at and all of that, because they know what time, you know, on the camera, what time they left the studio. They know what time the car parked over here. So they are more than likely trying to see if the cars actually had time to stop, like the defense said. Teresa, thank you for the super chat. I appreciate it so much. Thank you. Thank you. Put a screen between people and they forget to be human. Love you. Yeah, I appreciate it. Thank you. And I agree. It's like if you know, saying stuff from a keyboard removes you of having to take the responsibility of the responsibility for your actions. Her son died. I'm so sick of this trial. I really am. Law and Crimes reporting the jurors seem upset with each other. Jury is doing what Alan Charge told them to do, so we may have a lot of these questions that they are unsure of. Yes. Oh, what time did they leave the studio? Oh, you can't see it on here. It's 3:19. Oops. So they leave the studio at 3:19. They pass that traffic camera at 3:26. And then 3:49, the red SUV enters the gates. And at 4:02 is when they said that Melly exited the car and they had the 70 steps. This part is based on the this part is based on the opening statements. And we know that 3:53, 3:46, they saw the car passing by this camera, and 3:49 it went through the gates, and then 3:53 the Jeep passed the school up here. Let's see. Her and Jeanette, our courtroom insider tells us that jurors appear annoyed with one another. Chairs have been placed in between some of them in the courtroom. Started a podcast on that case. Will you let us check out your podcast now? What's the podcast info? To look it up, please. Yeah, I'm still working on it because I started on Just Guy's part of it, Just Guy's trial, and then I started working with one of them has asked to remain anonymous, but somebody from Glen County, and then also an attorney, and I had a bunch of stuff sent to me, and it made what I had planned on doing way bigger. So I'm still working on it. It's I'll let y'all know when it comes out though. So someone or multiple are fighting about the reasonable doubt for him to have gotten out of the car. That's what I would assume. Same Floyd, I was just thinking this too. Strangely, them being angry at each other may not be as bad as we think. They are engaged and deliberating vigorously. It shows that they're taking it seriously, and that is at least, something. Stu would have had a bigger tantrum than John Thomas in a nasal correction clinic to keep the jury from seeing this chart. Oh my gosh, yeah, could you imagine? Antoinette said Juvie and Zach's families are hugging each other and crying. Makes me so sad. I'm going to keep this. Keep it up like that. So you can still see. But then they have to disregard the guy saying all four of the others stayed in the same car all the way home. To disregard what if they believe that he swapped cars? Is that what you're saying? This is funny. My parents know all about all the trials going on over here. They say we never see Oklahoma in the news, so you must be in a safe state. My opinion, they would have had to stop and switch in the first few blocks or soon after, but even that doesn't make much sense. Show the cell towers again. Yeah, let me move this. Is it on this one that I did it? Hold on, I gotta find it. charts. Let's see. Which one did I do it on? This What's that? His attorneys. All right, let's see. Is this the one you want to see, the cell tower one? Oh wait, hold on. There's a newer version of this. All right, so this is the cell tower one. Let me move myself again. Easier to see. All right, so this is all the information that they had given, but so this is after the murders. The cell tower stuff shows. Oh wait, which cell tower stuff are you wanting? The one from their drive back? Or the one before? If you're wanting the one before, that one may be. God, I've done so many of these dang charts trying to help explain everything. Let's see. I have to find that one. Give me a second. Not that one. Not that one. That is the dang cell tower one. Why can't I find it? I know I didn't delete it. Oh, here it is. Help. All right, let's see. Getting too tired, y'all. All right. This is the one you're asking for, I'm assuming. These are where their phones are hitting. So, let's see. Oh my gosh, stop. I'm trying to keep this in the corner so you can see it, but then every time I try, and my thing takes over. Okay, so so this is the cell tower stuff. What clock isn't right? My clock? Y'all know I'm on Central Time, right? Are you talking about my clock? All right. The stuff, these are the same colors that they did when they went over all of this stuff. And the red was Melly, the blue was Sack, the green was Juvie, and the purple was Withers, who was in the red car, of course. So you can see that if you follow them around 320, they're all, and look, like when one's down here and one's up here, one's over here, whatever, this doesn't mean that it hit right here or here or here. It's just that if it's all the same colors, I put them there to where you can still see. But you can see that all the phones are moving along the same time, kind of together. When they get down towards here, when they get off the interstate, 352, Withers hits here. When his goes home, there's no other information for his the rest of the time. He doesn't, his phone doesn't show that he leaves again. At 3:46 is when they're caught on security footage right here. These are the two spots where he sends Fredo Bang his stuff, but that's later. And then the scroll over. The Jeep is seen up here going at 353, going west, and that's on that school video, and then it's seen at 406 going back east on that school video. These right here are, here's a newer one. Oh, here it is, yeah. So look, if you do these, I layered these on the map, and you can see where it said that it's somewhere in this red or somewhere in this blue. I just lined those up, and I did them kind of like this, so like transparent, so you can still see this stuff, but still see where they're at. But the all the cell tower stuff lines up to all of this. The phone for Melly and the phone for Sack both show that they're over here at 4 o'clock to 4:03. And then at 4:23, it shows that Melly's was somewhere along here. And then at 4:40, he's over here. And 4:35 is we know when they pulled into the hospital. And Sack's phone shows that it's at the hospital at 4:40 when Melly is over here. And then he drops the 2 pin locations right here. I believe I know they're deliberating tomorrow because they said that they were going to have something for the that one testimony for the jury to look at tomorrow, but now they don't need to see it. So I wonder if the court's going to ditch us again without giving us a plan for next week. Probably, but we'll be able to find out. I can text Boom if nothing else. Find out. Yep, still no verdict. If they come to a verdict tomorrow, then, like, if they make a decision, then they will. If they are going to be deliberating, then we'll still be on verdict watch tomorrow. They were supposed to be done at 5. On Crime Viewer Chat wants to know what time the verdict will be read. I almost fell on the floor laughing. 1 cake shy of a short stack. Oh, I don't go there anymore. Maybe they ended at 5 last night because they needed to get checked into their hotel rooms. Maybe they'll go longer tonight. That is a good possibility. That's a good thought. They're still going as far as I know. The clock is still going, but let me see if I can check Twitter. Wearing me out. All right, let's see here. If there's no verdict tomorrow, then they will deliberate on Sunday. And they are stuck in a hotel room with no contact with the outside world. So If there's no conclusion, then the jury has to be taken back to their hotel at 5:15. At least this was the schedule the judge said yesterday. That means they have 20 minutes, or that was 10 minutes ago though, or they are back to deliberating on Saturday. Nope, no phones. No communication outside world. So they would be stuck in there. And then deliberate tomorrow and deliberate Sunday. I was really wanting a beach day tomorrow. I say, no way they go past tomorrow. Oh, I can't stop yawning. I'm exhausted. If they want to go ahead and call it a day, if they're not close to reaching a verdict, I could use a nap. This trial has worn me out. The longer they go, the more consideration they are giving to the facts, hopefully. Yeah. Hotel room with no contact sounds amazing. It really does. I'd be down for it. Seeing doors over here. That reminds me. Cover that part. Let's see. They at least have TV. I'm not sure. Flip-flop count. We are at 1, 2, 3. But now she's gone back to sleep. Barking at the delivery wore her out. Let's see how you can see why someone snuck in the Apple Watch. Trying to keep. This fool. They can't be deadlocked now. They have to be discussing. And hopefully whoever didn't see is beginning to understand. There's a lot of evidence, and we got to talk about it all with each other. That's a good point. We have all discussed this and looked at it and revisited it, and looked at everything. And they haven't had a chance to do that. So this is the first time that they're able to do all this. How old is Lucy? Well, June 3rd was her 4th birthday. She is 4 years old. Crap, I forgot too that shaking the camera.
Council, my understanding from talking to our bailiffs is that because of the sequestration, they need to take the jury to the hotel. Otherwise, they missed it or something like that. It's 5:15, you said, the latest. So it's 5 or 10 minutes from now, and well, less than 5 minutes from now. In any event, what I want to confirm with you again is that they're going to take the jury. They'll excuse them now. There's no need for me to bring them back in the courtroom, correct? Correct.
Yes, sir.
So they'll just take them to the jury room, to their hotel room. They'll feed them tonight. They'll make their phone calls as they typically have done. They make phone calls and stay observed and things like that. And then they're going to be back here after breakfast tomorrow morning. They'll be back here.
Between 8:30 and 9.
Between 8:30 and 9. Again, my question is, can I do it like today, where you're the attorney is not involved in it? You know, we'll call you when we need you, and the bailiff just puts them back in the jury room, and you'll be on, let's say, a half-hour notice. Is that good for everybody?
That's good. You okay with that? That's good.
Yes, Mr. Dennis?
Yeah.
You understand?
Yes, sir.
All right. So that's what we'll do. They'll just, we'll do it the same way we did today, and when we need you, if something happens, we'll call you. All right. And Gary, you're going to be here tomorrow, right?
Yeah, that's good.
Do you have all the phone numbers?
Yes, I do.
All right. So if something happens, are you going to be here tomorrow morning, or?
Yes, sir.
Will you be here? Okay.
We'll be there. I'll be there.
All right.
I am slow, Judge.
All right. Well, I know you were here this morning early, then you had to run this delivery, but you were here first thing. But in any event, we'll do it the same way, and your co-counsel, they'll get here within a half hour. All right?
Yes.
He's on his way. All right, counsel, is there anything else to discuss then?
Yes, sir. Thank you.
All right, thank you. It's 5:15. Tom, you want to take that then?
I think you guys. Get out. Yep. Sorry.
Well, that's that. So tomorrow we will be on verdict watch. 30 minutes for verdict warning. It's not a lot. Not a lot at all. All right, so I have to take Lucy in the morning to the groomer. I have to drop her off at. I'm going to drop her off. We can start when I get back from that. Oh my God, I have so many texts. I have to drop her off at 8 my time, which is 9 o'clock Eastern, which is about what time they'll be there. So I will just start after that. We'll look at, see if there's any more jury questions, see if they have anything else to say. And then we can start looking at some of the stuff for show business, which we will be starting on Monday. So we'll see what they say. Make sure you turn on your notifications. Subscribe to the channel and turn on your notifications so that you can make sure that you get notified. But we will see. Is that in UTC time? Funny. Rely on your memory for that. So I appreciate y'all hanging out. We did not get a verdict today, but at least we know that the jury is taking it seriously and deliberating. Oh, look, my eyebrows starting to come off. My verdict eyebrows. I've been messing with it too much, huh? I guess I touched my face without realizing it. So we'll see what happens tomorrow and see how it goes. If you have not come to night court before and tried it out, give it a shot tonight. It's a lot of fun. It will be at 8:45, 7:45 Central. Verdict eyebrows tomorrow morning. Yeah, we're going to have to put new ones on because these are starting to come off. So we'll have to see. I doubt these are going to make it through another night. I was careful washing my face, but probably won't make it through another night. I appreciate y'all hanging out. I am going to get off here. I'm so tired and I want to lay down, and especially because I was not planning on streaming tomorrow, and now it looks like we will. I dropped Lucy off at the groomers at 8, so we'll just start right after that. We will do a verdict watch, and we'll start looking into all the show business stuff and go over that so that we know what we're getting ourselves into on Monday. So that one is going to be wild. That one's one of those that we're going into it knowing that she did it. The question is, was she insane when she did it? Did she know right from wrong when she did it? So we know she was on drugs heavily, but was she insane? So it'll be really interesting, but it's kind of gruesome. So we're going to try to keep it as whatever as we can. I mean, there's not even a way to keep it like PG-13 or anything. We're just gonna run with it. We're gonna wing it. We'll see how it goes. Please hit the like button on your way out. I cannot give you an exact time we'll start tomorrow. It's just gonna have to be after I drop Lucy off. So it'll be sometime close to 9 Eastern, which is when they're starting. So we won't be missing anything, but we will get going, watch, and see what happens. So, but I appreciate all y'all hanging out with me today. And don't forget to check out Night Court tonight, streaming Jodi Arias. Night Court is fun because it's the throwback trials. And we will see you in the morning. Thank you for reporting to jury duty.